The jury is present. You may be seated. Good morning, ladies and gentlemen. I begin every day by asking you the same questions. Did you become aware of any of the facts about this case outside of the courtroom, or you become aware of any information relating to the case while you were away from the courtroom? Thank you. State, call your next witness.
Yes, Judge. The state would call Roy Bedard.
This way, sir. Stand here, face the clerk, raise your right hand and be sworn.
You swear to tell the truth in this proceedings, so help you God?
I do.
You do the other deputy, he'll show you where it's at. Loud and clear into the microphone so everyone can hear what you have to say.
Yes, sir.
Counsel, feel free to move about.
Thank you.
All right, you may proceed.
Thank you, Judge. Good morning, sir.
Good morning.
Could you please introduce yourself to the jury, spell your last name?
Yes, my name is Roy Bedard. Spelling of my last name is B-E-D-A-R-D.
What do you do for work, sir?
I am a police trainer.
Can you tell the jury about your educational background, sir?
Sure. I have a bachelor's degree in criminology and criminal justice from Florida State University, a master's degree and a PhD in educational psychology also from Florida State.
When you were taking your master's and PhD educational programs, did you do any specialized, educational experience in movement, action, that sort of thing?
Yes, so my major is in sport psychology. It's sport exercise and performance. I focused mostly on the performance side because for most of my life I've worked with law enforcement officers, military soldiers, so I didn't spend a lot of time discussing volleyball and baseball like my cohort did, but rather law enforcement officers and the way that they behave mostly under pressure.
Can you tell us about your experience, if you were a law enforcement officer and for how long and for where?
Sure. I started in law enforcement. I went to the academy in 1986. I had my first job with Florida State University Police Department in 1987. I stayed there until 1990 and then transitioned to the Tallahassee Police Department without missing a day, and stayed full-time with the Tallahassee Police Department until 1996. At that time, I left full-time service and went to the reserve status, and in Tallahassee, the reserve program is a paid position. It's a fully authorized law enforcement officer, so I continued to do that until about 2015 when I retired. I left because I started my own police training company and started to train internationally.
Let's talk about your experience.
Can you do me a favor? You see the microphone there?
Yes.
Can you pick it up and put your book underneath?
Yes, sir.
I think that's the microphone that's making noise. Thank you. You may proceed.
Yes, sir. If you can, sir, can you tell us about your experience with teaching? We'll talk about nationally first, and then we'll move internationally.
So I've taught around the world, as I said. I've trained in over 5 continents. I made a living doing that. That's what I did most of the time. For about 25 years, I was traveling around the United States and outside the United States. I think my most extreme year was about 300 days, 1 year outside of the U.S., training internationally.
What would you do when you trained internationally?
So I focus on use of force in defensive tactics. This goes to an earlier background that I had even as a child participating in the martial arts. So I've always been involved in teaching law enforcement officers tactics. So my niche area was to teach law enforcement officers, corrections officers, military soldiers, how to tactically deal with situations in the environment that was unique to them.
Were you also a professor at the Pat Thomas Law Enforcement Academy?
I still am.
Can you tell us what the Pat Thomas Law Enforcement Academy is and what you did?
So I think the Pat Thomas, first of all, there's many academies in the state of Florida that train law enforcement officers locally and regionally. I think the Pat Thomas Law Enforcement Academy, which is under the guidance of the Tallahassee Community College, is the closest thing we have to a state law enforcement academy. It's where all the state agencies essentially headquarter. And so I've started there in 1987 as a defensive tactics instructor and I've continued on without pause to this day.
At the Pat Thomas Training Academy, did you also teach multiple classes in police tactics and police procedure?
I did. So those are all certification courses, what we call the high liabilities. I do teach firearms. I do teach defensive tactics. Of course, I teach general topics. And most recently, perhaps due to the amount of time I spend in court these days as an expert, they have me teaching the legal block to law enforcement officers.
From the Pat Thomas Academy, do you also, are you, I guess, an adjunct professor at any other colleges in Florida?
I am. So a few years ago, after being in Tallahassee for about 37 years, I moved to Sanford, Florida. And Tallahassee, I still teach, as I said, I still have a residence there, but I am also now teaching at Seminole State College as an adjunct professor.
We have somebody from IT to come look. I don't, it's not him, I don't think. It is? Oh, is that what it is? All right, okay. Go ahead.
Yes, sir. Thank you, Judge.
Make sure you just speak up, okay?
Let's transition back, and then we'll go forward again. But when you were a law enforcement officer, can you describe some of your duties you had when you were with the Tallahassee Police Department and with Florida State Police Department?
Yeah, I was a patrol officer, which meant that I worked the streets. I was answering calls for service. I was taking reports. I was dealing with suspicious incidents, domestic violence, the kind of things you would expect an on-call law enforcement officer to be dealing with. I did all of that. But in addition to that, I was a field training officer. That's always been my passion and my interest. And I don't know if I should describe what a field training officer is. But a field training officer is a sort of a transitional trainer. When you leave the academy, of course, you come to a police department. And for example, at Pat Thomas, there were many different agencies that would be represented inside the academy. So you might have people there from the Tallahassee Police Department, some from the Leon County Sheriff's Office, you might have some from the Quincy Police Department. And when they break out of the academy and go in service with their respective agencies, there is a transition that has to be done so that they can function in accord with that particular community. So policies are different from place to place. So field training officers are employed to help them transition, to take them from their earliest basic recruit learning to being fully functional on the street. And that's about a 4-month process or 3.5-month process that involves different phases in which they are not only placed in a patrol car, but they're observed. They have what are called daily observation reports that are written for the purpose of establishing their competencies. In some cases, they're incompetencies. Sometimes we wash them out. They don't make it through that phase. But if they are successful, then they are graduated to full law enforcement officer.
During the course of your career, you know, just in the law enforcement portion, how many times do you think that you've been at FTO mentoring other officers and teaching them?
I don't know. I did it for 10 years as I was a full-time law enforcement officer. I would say maybe 100.
When you were as a professor and teaching at the Pat Thomas Academy and also in Seminole County at the college there, how many police officers do you think you've instructed over your career?
Thousands. I mean, that's what I've done for the last almost 40 years.
Have you been called on by FDLE to participate in, I guess, designing the curriculum for law enforcement?
I have. FDLE is the Florida Department of Law Enforcement. That's officially our state agency. And we have what is known as a post. We don't call it that. We call it the CJSTC, the Criminal Justice Standards and Training Commission, which is our equivalent of any other state's police officer standards and training, thereby the acronym POST. So CJSTC, which is governed by FDLE, is responsible for writing curriculum. And the curriculum is administered to every academy in the state. So I was sourced as a subject matter expert by the CJSTC for now probably 25 years, and I've been responsible for several iterations of curriculum. And those iterations have and continue to be used by well over 50,000 police officers and corrections officers in the state of Florida.
And just backtracking to when you were a law enforcement officer, how many calls do you think you responded to as a police officer when you're on the road?
Oh, it's hard to say. I mean, every day is different, of course, but I mean, you take 10 years and, I don't know, look at the number of calls 4 days a week. Again, it would have to be thousands.
Have you investigated road cases before?
Yes,
Have you investigated stolen vehicle cases before?
I have.
Have you just patrolled areas, in high crime areas, doing proactive policing?
Yes.
In reference to marijuana, are officers trained on the smell of marijuana when they go to the academy?
They are.
Is there two different sides of it, like the smell when it's burning and the smell when it's raw?
Yeah, it's a very pungent substance. I mean, when you smell it even in its raw form, you usually can identify it as marijuana. It has a more pronounced and probably a farther reaching scent when you burn it, of course. But still, you would be able to tell it was marijuana. It doesn't change the scent that much.
Were you, when you were with Tallahassee Police Department, were you a trainer at the police department?
Yes.
What were you a trainer into?
I was a trainer in use of force and defensive tactics, mostly, and as I said, a field training officer. So I spent a lot of time doing what we'll call general patrol procedures for newbies out of the academy.
And then can you tell us the name of your company that you transitioned to in 97 or 98?
96. My corporation started as Rapid Rotation Baton Incorporated. It was the name of my flagship brand. It was a police baton with a holster. Later, I expanded to developing and patenting other law enforcement equipment and doing consulting work. And so I created a DBA called RRB Systems International, which is the corporation that I put out front now when I do the kind of work that I do.
Part of being part of the RRB Systems, are you called upon to testify in court?
I am.
Have you been hired by defense attorneys and state attorneys in the past?
Yes.
Are you also hired in civil cases?
Yes.
When you're hired by in a criminal context, what do you think the percentage of defense attorneys are who hire you to the percentage of state attorneys?
I would think it's probably in the neighborhood of around 80-20. Most defense attorneys hire me. I get hired a lot for stand your ground cases where subjects may be, for example, accused of aggravated battery or murder, and trying to bifurcate the rules of law versus the incident itself. I offer testimony in the area of stress performance and things like that.
Have you testified in court before in reference to the use of force?
Yes.
Have you testified in reference in court for defensive tactics?
Yes.
Have you testified in court as an expert in stand your ground?
I have.
Have you testified in court to police tactics before?
Yes.
In police procedure?
Yes.
And perception and reaction times?
Yes.
How many times do you think you testified in court, sir?
I think latest count it's over 50. I don't know if it's 53, 54 or something like that.
And in respect to that, that doesn't include all the depositions you've conducted?
No, I don't know. I've probably done 2 or 3 times as many depositions.
Judge, this time I had asked to be allowed to have the witness offer an opinion.
Yes, the witness will be entitled to express an opinion.
Yes, sir. Were you asked to consult in May of 2023 in this case?
I was.
What were you provided to review in order for your consultation, sir?
Well, I don't have a list of everything, but I was given what I'm typically given, which is sort of what I'll call the case file on a particular incident. That would involve police reports, depositions, photographs, videos, sort of satellite data. In this case, I think I had some emails that were sent to me. I had lots of video, some body-worn camera video from a variety of different officers. I had an edited video, a slowed-down version of the incident itself. I think that covers it.
Based on reviewing those items, were you able to make observations and be able to offer some opinion about police procedure and police tactics in reference to this case?
I was.
Before we get into that, if you can, have you ever heard the word, in your experience, the word pigs?
I have.
Can you tell us if that's a reference to police officers?
I mean, it can be, for sure. If it's directed at a police officer, it is typically a derogatory term. I've frankly been called that before, so it's definitely not an endearing term.
Yes, sir. Thank you.
Can I get you to get closer to the microphone over here? Yeah.
Yes, sir. If you can, sir, can you tell us what proactive policing is?
Yes, proactive policing is sort of an evolution of the earliest policing, what we like to call a peeling method. We sort of adopted the policing system here in America from our earlier ancestors, the English, and Robert Peel is often cited as being the father of policing. Peel's idea of policing was that police officers should sort of not be seen, not be heard, until there was a problem. And that's known as reactive policing. In other words, a crime occurs, and then the police show up and they help you out. We discovered over the years that crime control was better than response to crime, trying to prevent crime. So the idea of proactive policing evolved. For example, firefighters are reactive. They stay essentially in a fire station until a fire happens and they respond to it. Law enforcement officers used to do that as well. But of course, what was happening, crime was going undetected, unlike fires. So what we had to do is put officers into the field to get into the wrinkles of society, to examine whether everything was baseline, in other words, stable. And as a consequence, there have been many programs that have been very well funded by the federal government and by various state entities to encourage more proactive policing. Things, for example, like community-oriented policing, various types of bicycle units that you might see out there where officers are not limited to the roadways so that they can get into the recesses. Foot patrols, something that you may see, for example, in the bigger cities, like in New England cities, started to appear in the South, where officers would be concentrated into what are known as problem areas. And these problem-oriented policing, for which there are grants for that as well, became proactive to try to not only discover crime, but to forge or perhaps reforge after the 1960s a relationship with the community, so that the first time you saw a police officer wasn't when there was a tragedy. It was, you got to know them personally, and we formed a partnership with the community so that we could get valuable information that could help us fight crime through this collaboration of community members, law enforcement officers, people that had special interests in the community, and that type of thing.
If you could you give some examples or describe how proactive policing is utilized in the times today?
Sure. I gave you a couple examples. I mean, getting out on foot is one thing. As vehicles advanced throughout the ages, of course, it was much easier for law enforcement officers to roll up their windows, turn on their air conditioner, and be in a bubble as they patrolled. And what it effectively did is it separated law enforcement officers from their community. Proactive policing is certainly as a matter of policy and as a matter of academic study, encourages officers and their agencies to open their windows, to park their cars, to get out of their cars, to talk to people. And that's one form of it. Like I said, the bicycle units, you perhaps have seen police officers wearing shorts. That would have been considered very unprofessional 30, 40 years ago. But the advent of bicycle officers was to, once again, I think, humanize law enforcement, to put them into clothing that didn't look so authoritative, you know, with the polyester and the baubles that hang off of it, but to make them look more relaxed and to put them onto vehicles that didn't have windows and didn't have air conditioning so that they could penetrate different areas of the community. And as I mentioned previously, these bicycle officers are oftentimes capable of getting into places where crime happens. Criminals tend to not commit crime in the open, where law enforcement vehicles would be noticed perhaps blocks away. They come in with lights, they come in with engines that you can hear, so they became very stealthy. But I think there was a sense of security that the community feels when they see officers out who they can talk to, they can ask questions to. Sometimes they just like to make small talk, you know, and say, how's everything going, that kind of thing, without being so concerned that perhaps something has happened in the community, just because they're now used to seeing officers that are in their environment.
Are officers trained at the academy in the use of proactive policing and that theory of policing?
Yes, they are.
Have you trained officers yourself in proactive policing?
I have, especially as a field training officer.
As a law enforcement officer during that training, are they trained in baselines for proactive policing? Maybe you can explain what that might mean.
Yeah, so communities function differently, right? So I think it's fair to say if you've traveled the state of Florida, you probably know that things are a little different in Miami than they would be, for example, in Tallahassee. So each community has a baseline, and officers who work areas come to know that baseline, and sometimes they can either be further segregated into this part of the community sort of behaves a certain way versus that part of the community behaves a certain way. So when you're on patrol and you're trying to consider what to get involved in or to investigate further, you're looking for these sort of aberrations in the baseline. So I'll give you an example. If you went into a church on Sunday and it was very quiet, that would be pretty normal. But if you went into a club on a Friday night and it was silent, that would be kind of abnormal. If you walked into a church on a Sunday and everyone was screaming, you would think that's outside of the baseline. But if you went into the club on a Friday and everyone was screaming, you might think that that's just part of the environment. So law enforcement officers are trained to recognize baselines and to respond to changes in baselines, to be sensitive to aberrations, to look for things that are unusual. Sometimes they're easily explained, other times they might be criminal, but nonetheless to be curious. So law enforcement officers, I think the first, when they get hired probably from the selection process, the first quality that we're really interested in is, are they curious? Because that's what communities anticipate they will have in their law enforcement staff.
Now, in reference to on a daily basis with proactive policing, when an officer comes on shift, can you describe what procedures they're taught normally that would lead to proactive policing?
Sure. I mean, bearing in mind that law enforcement officers are humans, they take their boots off and they take their uniform off and they hopefully go back to a fun and meaningful life. And so what happens is during those periods, they miss a lot. They end up going home and hopefully not thinking about anything until shift starts again. So there's some catching up to do. When a law enforcement officer arrives for work, they usually begin with some form of check-on. Now that has evolved in agencies throughout the state and the United States because we're able to do digital check-ons. We're able to check on from laptops, for example. It used to be we'd all assemble in the squad room. Some agencies still do that. And there would be information that was imparted to those officers with respect to things that have happened, mostly during the time that they were absent. Sometimes it might be information that perhaps they were looking for something yesterday and that person still hasn't been found, so we'll be reminded of that. So the check-on procedure is really a catching up period. It's an opportunity for officers to become more vigilant in the field, to know what they're looking for, not just to look for these aberrations, these unusual and suspicious circumstances, but to look for specific things. You know, for example, missing persons would be something that a law enforcement officer would have front and center, right, on their console of their car. They'd have a description of that individual, and of course they would be very concerned about their safety, so they would prioritize looking for that person. Stolen cars, stolen bicycles, anything that might make the check-on list would be something that a law enforcement officer would take notice of and be mindful of throughout their shift.
So officers are trained when they come on shift to review the previous information or the present information so that they can utilize that in their proactive.
Yeah, it makes them more effective.
Objection, leading.
Oh, sustain.
Was looking for stolen vehicles something proactive policing that officers would be trained to do?
Yes,
Overruled.
absolutely.
In reference to that, would basically any sort of crimes that occur, if they were notified, is that part of proactive policing to be looking into those?
Yes. I mean, anything that's happened in the community, like I said, that they weren't privy to because they weren't working when it happened, it's just sort of due diligence to give the oncoming shift officers the information the last shift had as they take their boots and uniforms off and go back to their lives.
Do law enforcement officers, as part of proactive policing training, are they taught to just sort of mingle with the community or to interact with people?
Sure.
Why is that, sir?
Like I said, I think it humanizes law enforcement. I think, years ago when law enforcement showed up, everyone would clamor to the windows and wonder what's going on. I think today, because they've become integral to the community and they are out of their cars, talking to people, intermingling as partners in this crime prevention, the communities have grown accustomed to them and tend to be less reactive to tragedies that happen in law enforcement. Sometimes tragedies do happen, and I think less judgmental and more understanding because they actually know the officers that are involved in these different episodes. So I think it's important as an investment in the community to create policies and to encourage programs that keep officers interacting with the community all the time, not just when crime occurs, but throughout the day and throughout the night.
When an officer, is proactive and interacts with a community member, can that sometimes transition into them doing an investigation when they see unlawful activity?
Sure. So, not every interaction is without suspicion. There are some times when officers will get a hunch, for example, that something is wrong. Maybe nothing is terribly overt, but we develop sort of these interesting senses that I think can't be explained in science, but law enforcement officers notice things about people. They notice, furtive movements. They notice perhaps expressions. They might notice how one person seems to drift away from the group or other people don't assemble around them. Little things that I think people who aren't trained and don't work this kind of job don't typically notice. The law enforcement officers notice it. And so they speak with people to clear things up sometimes. If they have a hunch, if they think something may perhaps be wrong, they'll engage them in conversation. They'll watch not only what they say, but how they behave, how they act, and try to develop an understanding of what's really going on. And so I think that these interactions with the community can be very innocent, if you will, meaning that they're nothing more than to develop rapport, and other times they are investigative, to attempt to figure out if there may be a crime afoot.
Why is it important for law enforcement officers to look for behaviors and actions?
Because this is about crime control. It's about criminals not being overt. They don't walk around with a sign saying criminals. So you have to identify these individuals from amongst a much larger population. And you do that through behavioral cues. You do this through conversation. You do it through observation. Most of the sense that we use when we deal with people is going to be a visual sense, things that we see. And so we tend to attend to things that are speaking to the law enforcement officer as, once again, a violation of the baseline. And even if it's a small violation, it doesn't have to be a gross violation, but even a small violation, that will capture an officer's attention and draw them to you.
In reference to behavior officers are looking for, can you tell the jury, when an officer is talking to an individual, is that person's response or lack of response something an officer should be looking for? Why?
It is. Most of communication is interpretation, right? It's not what you say, but necessarily how you say it. Or there may be some indication of nervousness. There may be some indication of perception in the way that somebody says something, even though the answer that they've given you is a perfectly fine answer. So law enforcement officers are trying to interpret the real meaning of things. And so subsequently, I think a large part of the communication is not the question itself. It is actually the behavior of the individual, the cues, if you will, that trigger an officer to think something isn't right here.
So hypothetically, if an officer engages an individual and they're not responding to the questions or, being evasive, is that something law enforcement officers are trained to take into account when they're in that interaction?
It is. It would inform an officer that perhaps something isn't what it appears to be.
Can you tell us what the duties of a law enforcement officer are?
Well, they're vast, and they've expanded. The original duty of a law enforcement officer is in the title. It was to enforce laws. But I probably don't need to remind anybody in this room that we just went through a couple years of re-examining the role of law enforcement officers, and even to the point where we have talked about bringing other people to the police function, like, for example, social workers. Those are skills that law enforcement officers are expected to have. You know, sometimes they're enforcing laws, other times they're counseling, sometimes they're providing emergency services, sometimes they're providing first responder medical services. They wear a lot of different hats. So the duties of a law enforcement are very vast, but I think generally public safety is primary when it comes to a general overarching theme of policing. It's public safety. And officers are inclined to do a lot of things that may not even be spelled out in policy in an attempt to keep the community safe.
Can you give us some specifics, like on a normal shift, what an officer's duties would be? Focus mainly on the law enforcement portion.
So I think I covered a lot of that. I mean, law enforcement is trying to identify people who are breaking the law. And of course, law enforcement officers are not lawyers. They're not legal technicians. They are working off of their understanding of the statute as it came to them in the academy and in service training and through their FTO programs and things like that. And so their identification of somebody that appears to be doing something that is inconsistent with what the statute requires would draw their attention and cause greater interest.
Would being on patrol in a police car, driving in a neighborhood be part of the duty of a police officer?
Oh, absolutely.
Would getting out of your vehicle and making contact with citizens be part of the duty of a police officer?
Oh, for sure.
Would investigating or following punches of something that they think could be criminal or could be related to criminal activity, is that part of being a police officer?
Very much so.
Is drug enforcement or identification of drug enforcement part of the duties of a law enforcement officer?
It is. I mean, it's a specialized area as well. There are narcotics officers that go to classes and form teams and sometimes task forces for the control of narcotics in a community. But every law enforcement officer is trained in being able to identify narcotics. That's usually where most cases start, at the street level by the patrol officer, and then often that information is turned over to, for example, the narcotics unit for further follow-up. So patrol officers are key observers of the drug culture and what constitutes use, sale, distribution, things like that as they go about their patrol procedures.
May I approach the witness, Judge?
You may.
Let me show you what's marvelous states. Why? You can take a moment and look at those. See if you recognize those there.
I do.
And what are those, sir?
These are still shots from the video that was sent to me on the encounter between Officer Raynor and the defendant.
Are they fair and accurate depictions of what is on the video? Just still shots?
Yes.
Anything seem to be changed or altered?
No.
Just this kind of state move, it states why.
Any objection? Without objection, admitted as evidence.
Judge, may I have the witness step down?
You may. Be sure to keep your voice up
Okay.
when you're down there, okay?
And Judge, I'm going to publish states 12 which is Officer Raynor's video with this witness. It's already in
This
evidence.
side,
Yes.
as close as you can to the TV there.
Okay.
Where you can still see it.
And I just want to play this all the way through and then ask you some questions.
How's it going? Do you live here?
What's going on?
Do you live here?
What's going on?
Sit down. Sit.
Sir.
Can you sit down? I'll talk to you. Stop.
Okay, come on now.
Sit.
Come on now. Don't do this.
Sit down.
Why are you asking me, do I
Sit
live
down.
here?
Do you live here? Yes or no?
What's going on, though?
Cool. Charlie 777.
Nah, back up.
Stop. Stop. Stop, man.
And if we just pause it there. So first off, I want to start out with, have you had an opportunity to review this video multiple times?
I have.
Based on your observations, is there anything missing from this video?
No.
Can you explain why based on your opinion, your expert opinion, why you believe this is the initial starting point of the interaction?
When I first saw this, it appeared to me that when the officer first noticed that Mr. Wallace is someone startled, that this is a sudden interaction, not as if something had happened previous to this that would have been ongoing when the camera came on. So it looks like the beginning of an encounter.
Now I'm going to show you what came in as, is it 52 now? 51.
Let me read it. The witness is entitled to render an opinion as to what he's watching. The ultimate conclusions as to what the video shows, it's up to you. You do not abandon that role as a fact finder in this case. Next.
Thank you, sir. I'm going to hand you this pointer. If you can, when an officer has an interaction with somebody, where is their focus initially, or where do you guys train officers to focus?
We train them to focus on the hands. We do that for a couple of reasons. Obviously, as we talked about earlier, narcotics is actually very well-established criminal enterprise. There are certain techniques and tricks, if you will, that people who sell drugs on the side of the road.
I'm going to object as non-responsive.
You know, the law enforcement officers may be watching because that's part of that proactive patrolling. They tend to watch the hands. That's where hand transactions are made. But probably more important than that, which is something that is, for lack of a better word, pounded into officers from the time that they're in the academy, through their in-service training, well into the FTO program, is it's the hands that kill you. So law enforcement officers, not knowing who somebody is, perceive everyone with vigilance for their own safety. And so they direct their attention to the hands. It's the hands that they're looking at.
In this case, is Officer Raynor's flashlight illuminating the hands?
It is. That is exactly what I would expect an officer to be looking at. And I think from a social perspective, most of us look at the face. When we approach people, we try to gather data from the face. Law enforcement officers, again, look at the hands, and this is where we can see the light being focused.
Now, in observation of states 51A, initially when you look at this, do you see an item in the hand? Not what the item is, but do you see any item in the hand, sir?
I don't know what it is, but I definitely see an item there that is more than just a hand.
And if we go to 51B, just a little bit better shot of it, can you see that item in the hand still?
Yes.
And then if we look at 51C, if I can point right there, is that still in the hand?
It is.
In 51D, are you able to see it still in the hand there?
Yes.
And if we can start with 51B, based on your observation, where is Mr. Wallace's phone initially?
Initially, I think when I see him, it's on his lap, and then it goes into his right hand.
And here in 51B, I'm sorry, 51A, is it in his left hand at this point when you're making the observation?
No, it's on his right.
And if we can look at 51D, does it appear that the phone is transitioning to the left hand?
It is. There's a conscious attempt with the left hand to receive the phone with the right hand.
And then, are we able to see, this is 51E, are you able to see his right hand devoid of the phone at that point?
Yes.
Is the phone, and when you watched the video and were able to observe it, is the phone and that white object in the same hand at that time?
They are. Yes.
Now, let's talk about, if we can go back to what is states 12. When Officer Raynor, can you just talk about the procedure, about how his approach is, and if he was investigating or if any officer was investigating a stolen vehicle, how would they go about identifying that specific vehicle?
Really two ways. You have to look at the identifying features. You can get them off the rear license plate, or you can get them off the VIN plate, which is usually positioned at least in the front of the vehicle, if not alongside the door.
Looking at the way that this vehicle is backed in, would it be safe or tactically appropriate for an officer to go to the back of that vehicle to look at the license plate?
Immediately?
Yes, sir.
No.
Why not? And explain what the proper procedure would be.
Well, any officer that saw somebody sitting in a car that perhaps was a stolen vehicle would recognize that the real threat is not the vehicle. The threat is the stolen object. The threat is the driver. So officers would learn, they would be trained to control and stabilize the driver first before conducting any further investigation. Not to mention, this is still a fact-finding investigation. You want to get a read of who the driver is. Is this likely a stolen vehicle? Are they acting nervous? Does it seem as if I should be more concerned with this than just a encounter where that could be easily dismissed with a proper explanation?
Why would it be dangerous for, hypothetically, for an officer to go behind a vehicle at night with someone in the driver's seat and like bend under the car? Why is that dangerous for an officer?
I think you can infer from my last statement that I said that officers watch the hands. So whenever you attend to something that isn't going to protect you, for example, a license plate, you are not capable of attending to something that can actually hurt you, like, for example, the person's hands, their relative position, access to weaponry, all the kind of different things that can happen inside the vehicle.
The way you've seen it, let me play it and then we'll talk through it.
How's it going? Do you live here?
The way that Officer Raynor is approaching Mr. Wallace, is that consistent with the way officers are trained in these kind of situations?
It is.
And why?
So I think with invigilation, where you have a community that wants some monitoring, it's this sort of balancing act between infringing on someone's right to be left alone and officers trying to figure out what's going on in the community. So they've learned kind ways of doing it. It usually starts with a greeting, sometimes an introduction. My name is Officer So-and-so. what's going on, what's happening, just sort of open questions. It's not authoritative, it's not intended to be frightening, even though for some people it may be. Anytime I think if they see a law enforcement officer, perhaps they think the worst. But it's sort of a greeting. It's a greeting by an individual who society accepts is a vigilant protector of the community.
Now, if we watch Officer Raynor's, just take
Do you live here?
Why you asking what's going on?
where Officer Raynor positions himself, can you explain tactically why he would position himself there and what the benefit is and why he'd be doing that?
Yeah, so I can't get in his head. I don't know what he's thinking, but I would say if I were writing a textbook on this case, I would talk about three major concerns that an officer would be interested in. One of them would be their safety, first and foremost. The second thing would be escape. If this is an individual that's committed a crime, right behind him, you can see on the photo, there's a fence there, and it's a crushed fence. It has barbed wire that's been pushed down by multiple trespassers. It's easy to get over. It's easy to get back. So escape's important. And then thirdly, is going to be the investigation itself. That's probably the least important thing. But to make sure that you can contain or stabilize the individual, you would position yourself in the best way possible to be able to quickly put hands on in the event that you were in a sudden fight, or to be able to put hands on if they were to escape. If you could determine that they were stabilized, if they didn't seem to be a threat, you could take your chances, and you could perhaps start your investigation.
Would an officer's approach maybe be different at night as during the daytime, depending on the lighting?
I think so. I think, as I said to you previously, that most of the information we gather is through our eyes, and we're all disadvantaged at night. Of course, that's why we give officers flashlights, because it allows us to see better, even though it is still a beam, typically. So we're still unable to see many things around that beam. That creates a little bit of anxiety for law enforcement officers and things in their environment that they're not seeing that in the day perhaps they would.
Now we noticed that Officer Raynor initially, when he gets out of his vehicle, he doesn't call dispatch and say, "I'm out of my vehicle." Can you describe if that's consistent with law enforcement procedure and why?
It is. As I said to you previously, law enforcement officers are engaged in a lot of citizen contacts. Most of them go nowhere, I might add. You don't want to be the officer that cries wolf every time you get out of your car. You notify, hey, I need backup, I need help, here's what I'm doing. So a great part of law enforcement is this communicative feature of talking to people and trying to determine if something is wrong. And if there is something wrong, then you advance into all police procedures, which is the idea that you would call for backup, the idea that perhaps you would change your position, maybe you go back to your car and run some things like that. But the initial step is really just trying to find out who this person is, what they're doing there, and whether or not they are a threat to the community.
Now an encounter like this with a citizen, can it transform into a situation where an officer then feels like they have to radio for dispatch?
Sure.
Is that common for it to take a little bit of time for an officer to gather that information?
Yeah, it's not as common as I said, the majority of people we talk to, nothing happens. But when it happens fast. And so law enforcement officers have to be vigilant to that fact too.
And I think we see later on in the video, do you observe Officer Raynor queuing up his radio?
I do.
Would that be consistent with the training of law enforcement officers?
Yes.
Let me just play this for a moment. Now we see Officer Raynor putting his right hand out to Mr. Wallace's shoulder. I guess it's his left shoulder. Can you explain what Officer Raynor, what that is and why he'd be doing that?
Sure. So we teach something called reactionary gap in use of force and defensive tactics. And the reactionary gap is in part based on your environment. There's only so much space that you might have. For example, over here there's a car. You can't really back up. But we try to keep a reactionary gap because of what's known as a reactionary time principle. Things happen before they even register on your mind in about 0.25 seconds. The idea, for example, if you're driving down the street and the car in front of you hits their brakes, it'll be about 0.25 seconds before that registers and you hit your brakes to stop. That's an important thing to know. That's why you keep car lengths between the car in front of you and yourself, so that it gives you reactionary time. So this is similar to that. When you have an individual who could strike you, for example, And we're not talking about a shooting or even a stabbing, but just a knockout punch where the hand can reach you. Officers are trained to put a hand out to create that reactionary gap where they can't step back, and in this case, he's not able to step back. So it seems to me, again, not knowing what's going on in his head and not pretending to know that this is consistent with the tactic of establishing distance so that the eyes can perceive what's going on. In the close quarters, of course, you lose most of your visual acuity.
So just to clarify, Officer Raynor is just, once Mr. Wallace is approaching him, he's trying to create distance so that he can react?
I think he's trying to maximize distance. There's two ways of doing that. One is for you to step back, and two is to push the other person back. So it looks to me he's almost doing both of those things when he puts his hand on him. Oftentimes we teach officers to put a hand up and say, get back, without actually touching. But if you're in that close quarters, there's a very good chance you're going to make contact. You may have to create distance by pushing.
And we talked before, I just want to listen, if we can listen specifically to the words that are spoken, and I'll ask you some questions about those, sir.
What's going on?
Do you live here?
Why you asking what's going on?
Let me just back it up a little more, sorry.
How's it going? Do you live here?
What's going on?
Do you live here?
Why you asking what's going on?
Sit down. Sit.
Sir.
Can you sit down? I'll talk to you. Stop.
Okay, come on now.
Sit.
Come on now. Don't do this.
Sit down.
Why you asking me do
Sit
I
down.
live here?
Do you live here? Yes or no?
What's going on though?
Is Mr. Wallace being compliant and answering the questions of Officer Raynor?
Objection, based property.
I can ask it a different way, Judge. Based on your observations as an expert, what are law enforcement officers trained in when people don't answer the questions? What does it cause them concern, and what is the problem there?
So you can see that this evolves from questions to commands. It starts with, what are you doing? Do you live here? To sit down. So there's an evolution here in control of the officer, or by control of the officer. Officers are generally trained that if somebody's not compliant, certainly with commands, that it's oftentimes a distraction. The distraction, frankly, is quite psychological. It has to do with the fact that we're not able to focus on two things at one time. So somebody asks you a question, you're not able to think about other things because you're thinking about the answer to the question. And I think we all understand this intuitively. You don't have to be taught this. I was taught this in my programs. But we kind of know that if you continue talking when someone's trying to do something, they're quite distracted from it. Perhaps people can relate to the fact that they try to do homework, or they try to work from the office, and somebody's making noise in the living room that they have to go somewhere else or tell them to shut up. And so this distractive feature is commonly used by folks in the community who are trying to prevent officers from making contemplated decisions about what to do next.
Back up.
Stop, man.
Now, is Mr. Wallace being compliant with the officer's commands?
Objection, based property.
Are officers trained in a situation like this to ask someone to get back in the vehicle? Why would an officer in this situation want the person that they're talking to sit back in the vehicle?
It goes to the first 2 points I made. The primary point is not to get hurt. So secondly, it's not to lose them because they fled. When you're in a vehicle, you're contained and you're somewhat stabilized. Now there may be weapons in the vehicle, but at least you can see them. At least you're aware of it. So you have the reactionary timing to your favor because you're placing them in an area you're going to be watching their hands. But what you've eliminated is mobility. The ability to quickly run, to fight, to do the kind of things that the officers are also afraid of. So when you can contain them inside of a vehicle for questioning, it gives the officer a little bit of a relief and anxiety so that they can move on to the next part of the investigation, which is the investigation itself.
Based on your expert opinion, based on what you watched in this interaction, did Officer Raynor use any unlawful use of force?
Objection and basic process of the jury.
Did Officer Raynor follow proper police procedure from what you observed in the interaction?
Objection, lack of predicate and basic process of the jury.
I'll sustain the objection. You can ask hypothetical.
Hypothetically, if an officer stops a vehicle and makes contact with that individual before being able to investigate or follow up on what they're doing, would it be appropriate for the law enforcement officer to ask that person to sit down in the vehicle? Yes. And if that individual failed to comply, would it be appropriate for the law enforcement officer to use a level of compliance appropriate for that situation? Yes. You have just a moment, Judge?
Yes, sir.
No further questions, Judge.
President, if you do return to
Do you need the TV?
Yes, please. Could you leave the video?
It's right up here. Thank you, sir.
you need the witness down here?
No, Your Honor. Or it might be more effective that way.
I'm sorry?
Could you please stay down?
Make sure you use this.
Okay.
Mr. Bedard, you discussed a little bit about the information that you viewed in connection with you being paid by the state to be here today. Is that correct?
Yes.
All right. How much have you been paid by the state to be here today?
4,500. Well, today I haven't been paid nothing so far.
Okay.
But I've been paid $4,500 for the case.
And is that a running bill? Could it be more after today, depending on how long it takes?
That's going to be inclusive.
Understood. And you talked a little bit about receiving numerous materials to review in connection with your testimony. Do you recall that testimony?
I do.
And among the materials that you reviewed, you would have to agree that there was no 911 call that a member of the community placed alleging Othal Wallace was engaged in any criminal activity.
That's true.
You would also agree with me that you received no information, any report that a member of the community flagged down Officer Raynor and accused Mr. Wallace of committing a crime.
That's correct.
There's no information to suggest that Mr. Raynor was dispatched to 133 Kingston as a result of any complaint.
That's true.
We're watching, I think this is the beginning of the video, right?
Yes.
If we had 30 seconds more video, we would be able to see exactly Officer Raynor's vantage point when he comes around the apartment, correct?
I assume so. I don't know what the PWC was shown in the dark, but I mean, that was my eye.
You mentioned the dark. This is June 23rd, right?
Yes.
Are you familiar with?
Back over here.
You're familiar with the summer solstice?
I know what it is. Sure.
It's the longest day of the year, right?
Yes.
It's not completely dark out in this parking lot. Do you agree with that?
No, it's not opaque dark, but it's certainly dark.
You mentioned before officers are trained to detect, I think, non-compliance with a statute or something that's incompliant with a statute. Do you recall that testimony?
When it comes to elements of a crime, law enforcement officers are looking for things that are consistent with those elements and inconsistent with a baseline community standard.
Okay. And you would agree that in looking at this video here, there is nothing apparent that is inconsistent with any statute.
Well, that's not the only reason that officers talk to people.
Sir, did you understand my question?
I did.
Okay, the question was, based upon an observation of this frame at this moment in time, do you observe anything that's inconsistent with the statute?
I observe something that could be inconsistent with the statute.
So the answer is no, you do not see anything inconsistent with the statute.
I don't think at this point we can see anything except somebody sitting in a car in the dark.
Okay. Well, and it is perfectly legal for a person to sit in their car in the dark. Do you agree with that?
Not if it's not their car and they're breaking in.
Okay. Please describe to the jury what information one could glean from this observation that suggests that Othal Wallace is not in possession of a vehicle that he has a right to possess.
There isn't, and that's why the officer got out and asked questions.
Okay. And what do you see in this video which makes Othal Wallace deserving of some suspicion that he potentially doesn't possess this vehicle?
Objection, Judge. Speculation of what's deserving?
Well, I'll sustain the objection. You want to ask a hypothetical?
Okay. Please point out specific observations in this particular frame which would suggest to a reasonable officer that Othal Wallace is unlawfully in possession of that vehicle.
You're framing this as a reactive response. I'm framing it as a proactive one. So there is nothing that the officer knows at this point except that
Thank you.
he is patrolling a high crime area.
Thank
and
you.
there's somebody in the dark in a car.
Okay. And is it...
Allow him to finish his answer before you start again unless you ask a leading question.
My apologies, Your Honor. Is it your testimony to this jury that a person's mere presence in a high crime area allows them to be subjected to immediate inquiries about their activities?
Police officers can talk to anyone about anything at any time.
Okay. And if the question that's posed by the officer is not based upon some particularized suspicion and they're performing a lawful duty, the person can end that encounter at any time they want. Isn't that true?
It depends. It happens very rapidly where an officer may go from mere hunch to thinking that a crime is occurring. And the person on the receiving end of that wouldn't know that, so they're not entitled to just walk away. No.
Okay. So if an officer does not have probable cause or reasonable suspicion to detain a citizen...
Does no one object as to these standards? They weren't brought up in direct, they're not relevant?
Your Honor, they've come in the case. He's a use of force expert on police tactics about what he trains officers in terms of discerning and not discerning.
He's not here to instruct the viewers on the law.
I understand, Your Honor.
I'll sustain the objection.
Is it your testimony that any person at any time, for any reason that an officer believes is justified, has to subject himself to being detained by a law enforcement officer?
Yes. If a law enforcement officer believes that a crime has been committed, the other person may not be aware of that. And as part of the social contract, though it may be an inconvenience for someone, they have to stay there with the officer until they are properly dismissed. Their recourse is in court, not on the street.
So your testimony is that upon an officer's just belief that a person is committing a crime, that an individual, a citizen, has to subject themselves to detention and inquiries?
Yes.
Your Honor, may we approach?
You did the 15-minute break. All rise, the jury. Why should you stand right there and take 15-minute break? Jury's out, Your Honor. Okay, thank you. All right, your objection.
Yes, Your Honor. Respectfully to what Mr. Bedard just testified to, I think he misstated the law. I think that I should either be entitled to some latitude or a curative instruction. What Mr. Bedard said was that only upon an officer's belief that they're doing something, a person is doing something wrong, that a person has to be subjected to a detention. That is not what the law allows, Your Honor. What the law says is that if a officer is not possessed with a reasonable, articulable suspicion or probable cause, then a citizen can terminate the encounter at any time. That's a consensual encounter. And what Mr. Bedard has just said is inconsistent with that. I'm not saying he was being nefarious or anything other than giving his well-founded belief on that, but that's not what the law says. This is germane to the case. He's been called in to testify under some cloud of expertise that he is all-knowing in terms of this encounter, and we believe that the jury should be able to have a full vetting of the appropriateness of this encounter. And what a better way for us to be able to either instruct them on the law, which is Popple 9151, about the encounters between police and citizens, that you can walk away. If there's no probable cause or reasonable suspicion, you can walk away. That is the law. If there's probable cause, you can't. And if you do so, that Officer Raynor was involved in a lawful execution of his duty. And in furtherance of our self-defense claim, we are allowed to undermine the good faith and lawfulness of his actions. And if he's overextending the parameters of a police-citizen encounter, we should be entitled to fully confront that and subject the witness to cross-examination. And furthermore, we believe that the jury should be instructed on the parameters of the law.
Judge, Mr. Probisco asked a question. It was a totally loaded question for the answer. And the witness answer to the best of his knowledge could be, the defense thinks it's an issue of reasonable suspicion and probable cause in this case. The state doesn't agree with that, Judge. I believe the jury instructions are sufficient, and it was Mr. Probisco's question that solicited it. He shouldn't have asked a question that he didn't know the answer for, and we asked the court to deny that. We didn't bring any of that out in our direct, purposely and carefully to make sure that we didn't cross the barrier the judge said.
All I'm asking for.
I'm trying to keep this objective and not subjective. I don't want him to testify to what was in the defendant's mind or what was in Officer Raynor's mind. He can look at this video all day long and have his opinion about, what was going on in that day. But at the end of the day, the viewers will have to decide, they can subjectively look at what's going on in those people's minds. At this point in time, he's not entitled to get into the shoes of either party here and then say, no, he should have, well, he can say, hypothetically speaking, this is a textbook, but what not to do, or what to do, or, how we see reactions of individual defendants, what's consistent with what I expect, or inconsistent with what I expect, and what reaction that will garner, generally speaking, not necessarily in this scenario, but, you see what you want, they can think what they want, the viewers can think what they want. So I'm going to go ahead and overrule the objection, not give a curative instruction. I don't think the viewers, I already said it once to them, but I'll tell them again, this witness here is not instructing them on the law. I get to do that. So that'll be my ruling at this time.
May I ask for some clarification?
Yes, of course.
Here's what I'm struggling with is that I may ask the court a question in terms of, I believe that Roy Bedard's answer to the question was inconsistent with the law on consensual encounters.
I already told the viewers, you're not here to instruct them on the law.
I understand that, Your Honor, but I feel as though we are being hamstrung in presenting this information which we believe is relevant to the jury, that a citizen does have the opportunity to walk away from an encounter. And that's all that I'm asking of Roy Bedard. Roy Bedard has said there's no situation, only an officer's belief subjects a person to detention. And that's not what the law is, Judge.
So you're asking him to opine on the law?
No, I'm not asking him to opine on the law. I'm asking him to use his expertise in when he trains an officer. It would be inappropriate to train an officer that just upon a whim and belief, you can go up to a person and detain them and subject them to inquisitions. That's not what the law says. The law says you have to have a founded suspicion. And now he's testified to the jury that upon just my mere belief and hunch that I can detain you. Why can we not present a cross-examination on the fact that you have the ability to walk away?
Okay, my ruling, I think, is clear. You're welcome to ask him what he trains people to do and not to do. At the end of the day, we can argue the law through the charge conference, and you can argue those things to the jury based upon the instructions that I give them. So that'll be my ruling. We'll take a 15-minute break. All right. All rise for the jury. The jury is present and seated. You may be seated.
Thank you. Mr. Bedard, you testified before. You're a pretty busy guy, right? Traveling around the world testifying?
Yes.
Okay. And in connection with your job, have you ever had a moment to sit in your car and take a phone call?
Yes.
And you do a lot of training with police officers, is that correct? Right. Let me give you, and when you're training them, part of the training is you're giving them hypothetical scenarios, correct?
Yes.
And you're instructing them on how to deal with these potential scenarios that they'll come across in the real world, correct?
Yes.
So in the hypothetical training model, you're essentially defining the facts upon which the officer is being trained. Do you agree with that? I mean, you're setting a hypothetical. You're saying, here are the facts.
Yep.
How would you react to this fact pattern? Okay. Would you agree with me, or let me ask you this, would you train your officers that if they saw a person sitting in their car, talking on the phone, that it would be appropriate to then go up and detain that person?
Detain.
It would be appropriate to go up and have a conversation with them, right?
Yes.
And when we talk about detention, we're talking about acting in such a way or doing something that makes a person feel as though they're not free to leave.
Yes.
And similarly, what you would also instruct your students in that scenario would be, if the only facts that you possess are a person sitting in their car, that person's free to walk away at any point in time.
If the officer commands them that they can't leave, then it's a student officer knows something that the person sitting in the car does not. For example, maybe they are a suspect of a stolen vehicle. So the person is not entitled to walk away if the officer says stop or forces them to sit down. They are only entitled to deal with that in court if they were unjustly dealt with by law enforcement. That is not a street-side decision the person is entitled to make.
Okay. However, what you just testified to rests upon the qualification of if the officer has a well-founded suspicion. You agree with that?
So I think once again, I have to be careful because I'm not here to instruct the theory of law. I can tell you what we're training law enforcement officers. Reasonableness is always part of it. So making a reasonable inference or a reasonable belief, these kind of things which I don't think you included in this question, those are determined in the hindsight of the case. An officer receives a belief and it's assumed that it's reasonable. Now, he may be found later to be unreasonable because of the objective reasonable standard. But the subjective reasonable standard, if an officer does something, it's assumed that that belief to him at that moment is reasonable. And it can't be contested at the street level.
And you're instructing your students, obviously, to act reasonably toward members of the public, right?
Well, we instruct them in the criteria of what should be considered reasonable if they continue to follow the instructions of their training. They conform to training. But again, that's why we have courts, because we're not always correct about it. Sometimes an officer's actions are deemed unreasonable in court, but that doesn't invalidate necessarily the street contact.
Sure, and I appreciate that. I'm asking you from a training module perspective. You would agree with me that you would not instruct your students to make a command upon someone unless they had a reasonable suspicion that that person was engaged in a crime, about to be engaged in a crime,
Judge,
or
objection.
possessing some criminal contraband.
Judge, objection as to legal standard.
Rephrase the question.
You would agree with me that you would not train your students to command someone to do something, whether it be sit down, stand up, or otherwise, unless they had a reasonable belief that that person was doing something wrong.
happens instantaneously. So the officer who at first might be interviewing someone, they might say something like, what's going on here? What's happening? Do you live here? Those kind of things. That's just inquisitive. But if the person, not knowing what the officer has on his mind, decides to suddenly leave, and the officer says, stop, sit down, and the person refuses, we now have another crime. So there's probable cause for that crime.
Correct. But in order to get to that point, in order to make the command, you have to have a reasonable suspicion that somebody is doing something.
Judge, I'm going to object as to legal standard again.
You know, he's now talked about the crime of obstruction that has elements to it that is germane to the question. Sure. The issue is this, and respectfully, I think that you're overcomplicating. If an officer makes a command,
It's just argumentative and disrespectful to the witness.
sure. If you're making a command on a citizen, you can't just do that for any reason that you desire, right?
That's correct.
Okay, so the reason that you would command a citizen is because you are, let's agree on this baseline, about to do some investigation, right?
Yes.
Okay. And if you're going to do some investigation, then you would possess some knowledge that the subject of your investigation is potentially engaged in some wrongdoing.
Potentially engaged, yes.
Okay. And I think that we can agree that the standard of potentially engaged is a good faith basis to believe that. Can we agree with that?
That's correct.
All right. And when we're talking about a good faith basis to believe something, let's advance the video forward just a little bit here. Okay. I think before in your testimony we'd agreed that at least in this portion of the video, from what you using your expertise, we don't see anything criminal going on right here in this still shot, correct?
No, not overtly correct.
And I'm just going to advance it for a few seconds.
How's it going? Do you live here?
And now I've advanced it just a second or so. Okay. Same situation. Same question to you. You would agree that there is no, I'm just talking about just what you see using your expertise in this video. There's no discernible criminal activity going on in this picture right here.
There could be, but I can't see it.
Okay. And you are seeing, just as everybody is seeing, a very good representation of Jason Raynor's vantage point when he's walking up to this vehicle.
Well, I'm only seeing. I'm not smelling. I'm not hearing. I mean, there are things that Jason Raynor would have to his advantage. I could get on a two-dimensional impoverished video for his body camera.
Sure, and I appreciate that response. There's audio on this video as well, is there not?
Yes.
Okay. Do you agree with me that in the contents of the video that we've played thus far, there's nothing that is audibly apparent that is criminal in nature?
I would agree with that.
And just while we're on this car here, you would agree that Mr. Raynor doesn't shine his flashlight or go over to the side of the passenger side of the vehicle, right?
He does not.
Okay. And in training your law enforcement students, I'm sure that you encourage them to hone their powers of observation, correct?
Yes.
Because just as it's important to use those to, I guess, apply your proactivity to those deserving of suspicion, you don't want to capture people that are undeserving of suspicion. Would you agree with that?
You have to operationalize capture. You mean
Okay.
see somebody or to
I think that was poorly worded, but to the extent that's reasonable, you do not want to apply suspicion to someone who is undeserving of suspicion.
I think that's correct.
So, in doing so, an officer is relying on things like BOLOs, correct?
Yes.
Okay. I'm sorry, Your Honor. And in a BOLO, it can come over the dispatch, right?
Yes.
It can come through the email.
Yes.
It can come from another officer just telling you something.
Yes.
If an officer has a BOLO that contains a picture of a vehicle, you would agree that you would instruct your students to pay careful attention to the way that that vehicle appears.
No. Yes. I mean, I think more broadly speaking, there are so many different types of vehicles that I wouldn't expect them to be expert in all of the nuances between, for example, models or of a make, of a particular make. So, I mean, there would be a degree of reasonableness and time. I mean, there's actually a way of training people to be expert in birds and cars and things like that, but it involves mind-numbing hours of observing a certain vehicle, perhaps hundreds of times, to be able to identify those nuances. So law enforcement officers are trained to look, for example, in this case, silver Honda.
May I just get back to a much more simpler issue, which is that.
Can you just ask that the witness be allowed to answer the question?
I'm finished. If it's an open-ended question. It's a leading question, and so we do a yes or no.
Sorry, I apologize. Were you finished with your answer?
So that would be the starting point, silver Honda, right? So then we have to figure out, perhaps with the make is, that would be the next thing. If you have time to do it. In this situation, I think it would be very difficult for an officer to see the make since it's probably not that. Okay.
I don't mean to interject, but I think that going a little bit beyond the scope of the question. The question was just a general one in terms of powers of observation. So
Yeah, well, that's where I was heading with this.
Okay.
So the powers of observation are going to go from broad to narrow.
Sure.
So the first thing is silver Honda. Then we're going to look for make. Then we're going to look
Again,
for...
I don't mean to be rude. I'm not asking anything specific. I was just asking about a training model in general. Can we agree that you're training an officer to use their best reason, their best observations to distinguish between a vehicle identified in a bolo and a vehicle that they see on the street?
Yes.
Okay. And with respect to the evidence in this particular case, you would agree with me that among the items that you reviewed were states of the file, correct?
Yes.
And when a reasonable officer, in looking at this vehicle, would be able to see.
People with that is great, so they know what to see.
Sure. This is State's Exhibit 5, the bolo that we spent all day Monday talking about. Okay? And would you agree with me that there is a feature on the roof of the vehicle?
Yes.
Okay. Would you agree with me that upon a rear look at this vehicle, one can observe the taillights of the vehicle?
Yes.
Okay. And those taillights extend all the way from probably the midsection of the hatch all the way up to the top?
Yes.
Okay. Similarly, there are observable on both sides of the vehicle door handles, correct?
Yes.
Okay. You would agree with me that a vantage point as exists here would allow a person in the same position to see portions of the back lights?
I don't know. I don't know what the officer can see. Again, because of the darkness and the angle that he's coming in. And what he's looking at, remember, he's attending to the driver. He hasn't quite gotten to the vehicle yet.
And you would agree with me that what you're seeing in the video is inconsistent with the way that an officer would approach a high-risk vehicle?
If the officer knew this was a stolen vehicle, then they would have probably stayed back and conducted what we call a high-risk stop or a felony stop.
So we can agree that the actions that we see in this vehicle are inconsistent with Raynor acting upon suspicion that this is a high-risk vehicle?
No, I wouldn't agree with that. I think there's an entry point to figuring that out, and that is conversing. And that's what we're seeing.
Okay. Would you agree that it appears to you that he's not sure if this is a stolen vehicle or not, because that's not how we train officers to deal with stolen vehicles and high-risk stops?
Objection, Judge. Speculation as to what Officer Raynor's thinking.
Sustained.
Okay. Have you had an opportunity to view this video extensively?
Yes.
And in connection with your view of this extensive view of the video, you have rendered certain opinions about the police tactics that are observed in the video.
That's correct.
All right. And you have provided prior testimony concerning your observations of the tactics employed in this video.
Yes.
And you've, on a previous occasion, given testimony specifically on the procedure utilized to approach this vehicle.
Yes.
Okay. And in connection with that, you would agree, you said, it appears that he is not sure if this vehicle is a stolen vehicle or not. That's not how we train officers to deal with stolen vehicles, high-risk stops.
That's right.
Okay. So, what we're seeing in the video is inconsistent with how you would train an officer to deal with a high-risk vehicle, correct?
No.
Okay. Do you remember having your deposition taken?
I do.
And that was on August 24th of 2023. Do you remember that?
Yes.
Okay. And for the record, I'm looking at page 27, line 24, over to page 28, line 3. Would you agree with me that I'm handing you the deposition of Roy Bedard taken on August 24, 2023?
Yes.
Okay. Can you please read from lines 24 on page 27 to page 28, line 4, and to yourself, and please let me know when you're done. Okay. Now, previously, before I handed you the deposition transcript, you disagreed with this question, which was, it appears to me that he's not sure if this is a stolen vehicle or not. That's not how we train officers to deal with stolen vehicles, high-risk stops. Do you agree that the words that I just recited were the exact words that you stated under oath on August 24, 2023?
Yes.
Thank you. In the video, you don't see a flashlight directed to the passenger side of the vehicle, correct?
No.
Advancing the video a few more seconds.
Do you live here?
What's going on?
Okay. You would agree that when Officer Raynor approaches the open driver's side door of Othal Wallace that he does not introduce himself. He doesn't say, "Hi, my name is Officer Raynor."
That's correct.
You would agree that as we advance the video further, Mr. Wallace asks several questions of Mr. Raynor as to why he's being inquired upon.
Yes.
Okay. And you would further agree that at no point in time does Officer Raynor indulge Mr. Wallace in the questions that he is asking.
I'm going to object.
Sustain. The video is the best evidence.
Is the court ruling that I can't ask him what's going on in the video?
I ruled that the video is the best evidence.
Okay. Do you ever hear Jason Raynor respond to Othal Wallace's questions in the videos?
Objection, Judge.
You know what I
The
mean?
video is the best evidence.
We've been asking about what's been observed in the video. I guess I'm just confused as to the difference between that and what we shined a light.
If you can rephrase the question, objective. I mean, hypothetical.
Okay. Do you ever hear in the video Jason Raynor respond to Othal Wallace's questions?
Objection, Judge.
The video is the best evidence.
Thank you. Mr. Bedard, you would agree with me that in the best evidence of the video, Mr. Raynor does not reply to Othal Wallace's question.
He does reply, but he replies with a question, which is inappropriate.
And you would agree in this particular, this is not the best frame, maybe advance it for a second, but
How's it going?
you would agree that the video also depicts Mr. Raynor making no stops from the exit of his vehicle directly to the side of Othal Wallace's vehicle.
Makes no stops. You mean he doesn't pause at the outside of the door before he goes to the inside? No, it looks like he is positioning himself for the unexpected.
And just in a few moments, we've seen the video a lot of times, this is probably a good depiction of it, but in just a few moments you would agree the video shows Mr. Wallace go and approach the small gap between the door and this red car, correct?
Judge, I'm going to object. That's an improper statement. It's not a few moments, it's a few seconds.
The video is the best thing. They're hypothetically my couch based upon the video for this witness.
Okay. In instructing your students in police training, if you were going to discuss a manner in which an officer could detain an individual, would you agree that one of those circumstances would be to position the officer's body in between the only means that the citizen can freely move?
If you're detaining them, yes, that would be one way of doing it.
Okay. And you would agree that what we see in the video is a red car here.
Yes.
Okay. A door that's open here. And a very short window between the opening of the door and the red car.
Yes.
And then you see Mr. Raynor position himself in that only small opening there, correct?
Yes.
And you've been in several parking lots in connection with your law enforcement duties.
Yes.
Okay. You would agree with me that what's depicted here is consistent with a very small space between an open door and this car here, the red car.
Yes.
Unable for a human being to get through without either the person moving or the door being closed.
That's right.
Additionally, in this video, we have a large amount of shrubbery from the back.
Yes.
It would not be reasonable to assume that a person in the same situation could leave through the back.
Not sure that's true.
Okay.
There's a lot of evidence of people going over that fence.
Sure. Certainly, you'd get cut up and it would be difficult.
I don't know if you get cut up or not. I mean, it seems to be a popular way to get into this complex.
Okay. Have you ever been around?
Okay.
Have you ever been around palmettos in Florida? You ever walked through the woods?
Yeah.
You can get pretty cut up with those, can't you?
Can, sure.
All right. So when Mr. Raynor walks up to this point of the open car door, he has blocked Mr. Wallace's ability to freely leave from his vehicle.
I would think that that's true.
Okay.
Yes.
And now we've kind of gone, I think we're 4 seconds into the video right now. In the previous 3 seconds, you've agreed with me that there were no observable items of criminal activity in the video, correct?
In the video, no, but I don't know what's going on in Raynor's head. Again, but I can't see anything. None of us can.
Okay. And similarly, and I'm sorry, I didn't mean to talk over you, but as we are here now, 4 seconds in the video, right before Mr. Raynor approaching the side, you'd agree that there is still no criminal activity depicted in the video.
I'm not sure. You talking about before he gets to the door?
No, sir. I'm asking you. Let's just start with 4 seconds into the video.
You'd have to probably put me there. I'm afraid I don't.
Okay, sure thing. We're at 4 seconds of the video. Okay. You agree that I'm pointing at 4 seconds? Okay, and you would also agree with me that if you're using your 40 years of expertise, you can't see any observable violation of the statute in this frame.
I can see what his hand can see. I can't see what he can see. So he may, for example, have seen something in his hand that he calls narcotics. I don't know.
Okay.
And he's not here to ask, obviously. So I can't tell you what his thoughts were. I would like to ask him that. But to your question, on an impoverished two-dimensional video, I can't see any signs of criminality in the second floor.
And you mentioned before that you can't see Othal Wallace's hands in this video, correct?
I can't see that.
Okay. And the vantage point of this video is from a camera that's mounted on Jason Raynor's chest.
Yes.
Okay. So if you can't see his hands in the video, right?
I cannot.
Okay. So if you can't see the hands in the video, it would be unreasonable if you were using this as a training module to then say to your students, based upon what you can see in this video, you can make an assumption about what is in someone's hands.
Well, the video is not what Raynor's operating from. He's operating from his eyes, which are elevated higher. He has a different vantage. Can you see into that vehicle? I don't know. You should be able to tell us that, but I don't know that answer. I have to only gather what I get from the chest one by one camera.
forward just a second.
Do you live here?
What's going on?
Sit down. Sit.
And we've advanced now to 9 seconds. I think we can agree and probably move on from this point that you don't know what Mr. Raynor did or did not see in this particular frame of the video.
I assume he's looking at his hands because of where the light is directed. He's attending to his hands, whether or not it has actually registered specifically that he has a phone, he has what appears to be, some type of object in his hand. I can't say that.
Okay. And do you have a good recollection of the state's questioning of you just a few moments ago?
Yes.
And my recollection, and correct me if I'm wrong, I just would like to show you what's been, I believe it's a composite exhibit 31 from the state. There were some photographs taken. You looked at some photographs that were taken of the interior of my client's vehicle? Okay. You reviewed those in consideration of your testimony here, did you not? Okay. And as a law enforcement officer, as an expert at trials all around the world, you're probably familiar with what a switcher suit is, correct?
Yes.
Okay. In connection with your direct testimony to the jury, were you provided that picture of a switcher suit in my client's video?
Judge, can I object in the sidebar?
Yeah.
Okay. And my question is simply this. During your direct examination, not previously, during your direct examination, were you asked about this photograph?
Is that an evidence?
It is an evidence.
Can it be identified for the record?
I believe it's part of Exhibit 31. Composite Exhibit 31. Were you asked about this photograph in your direct examination?
No.
We see, you would agree that Mr. Raynor's hand is upon Mr. Wallace's shoulder, or at least approaching it in this particular frame.
He's touching him, but it's certainly I don't know if he's touching it, but it is in front.
Sir, can you sit down?
Do you have a good recollection of the video, how it transpires from here to its conclusion?
Pretty good, yeah.
Do you agree that there is not a time, as we move forward in the video, where Mr. Raynor ever releases his grasp from Mr. Wallace's body?
Again, it's in the spirit of being precise. I don't know if he releases his grip. On the video, it appears that he's touching him. That's the problem with two-dimensional videos, is they lack depth. So I can't try to do this
Do you live here? Yes or no?
What's going on, though?
Who? Charlie 77.
No, back up.
Stop.
In this particular video, in this particular still shot of the video at 2050, you would agree with me that you see Jason Raynor's arm? Yes. You see his hand?
Yes.
You see his hand grasped around Mr. Wallace's shirt.
I'm not sure if I can see that.
Okay. Do you see a
I
shirt?
would object as to,
Do you agree that Mr. Raynor has not let his grasp go of Mr. Wallace's shirt?
objection, Judge.
Is there a method of training that you can point to which involves grabbing a citizen by the back of their clothing such that it restricts their breathing into their neck?
I don't think that was the point of that grab. There's no indication this is a officer attempting to choke someone with rather trying to control.
All right, I appreciate that response, sir. My question to you very specifically was, can you think of, in your line of expertise in training your police students, is there a procedure that involves grabbing a citizen by the back of their clothes, restricting their ability to breathe?
You're making that part of the procedure. The difficulty in breathing would be incidental to the
Sorry, I didn't mean to play that.
in many of our procedures, if not all of our procedures, where we are doing control holds involve grabbing oftentimes clothing.
And we talked a little bit before about commands to a citizen. And let's talk about the other side of that in terms of compliance. So you would teach your officers that if they are, acting upon some reasonable, belief, that a person has to obey the commands. They have to comply, right?
I mean, there are some considerations. For example, if an officer is unreasonably using deadly force, a person does not have to comply and be killed. But short of that, yes, individuals are required by statute and officers are taught that to comply with their commands, right or wrong. And as I said, the rightness and wrongness is usually determined in a tribunal setting. Yes.
Sure. And a component to your training of police officers is kind of how to manage the human factor of stress in the moment, right?
Yes.
Okay. And stress has a physical manifestation. Do you agree with that?
I do.
Heightened breathing,
Yes.
inability to concentrate,
Yes.
inability to articulate oneself.
Sometimes.
Decision making can be impaired in many regards.
Yes, I mean, if I can just break for a second, you're saying stress in its extreme, because there are many levels of stress where none of this is impaired. So depending on how acute the arousal is, those things can happen. It doesn't happen to everyone at the same time. Those are certainly artifacts of stress when you see somebody who exhibits the kind of behavior that you're describing.
Thank you. And I think what we can both agree upon is the reason why you need to train law enforcement officers to manage those emotions is because without the training, human beings are going to be susceptible to have those emotions overcome them in a stressful situation.
It's possible. I mean, some of it's personality oriented, but yes, we assume that we're training officers to a standard, and that standard applies to all of them.
Yeah. So if a citizen doesn't have such training, they're potentially not equipped with the tools to deal with the stressful environment.
Awesome.
And before you had mentioned that I think as society, we universally accept that police officers are vigilant protectors of the community. Did I accurately characterize your testimony before?
I don't know, but I'd agree with that statement.
Okay. So it's your testimony before the jury that every single person in the community except the law enforcement officers are vigilant protectors of the community?
Judge, I'm going to object. That's the speculation. That's not what was said.
Would you train your officers when they're going into, let's say, for instance, a high crime area, that the officer should have an expectation that the citizens that they may encounter will view them as vigilant protectors of society?
Do I think that the community at large, and I don't like to speak in extremes, I mean, I'm a scientist, so there are always outliers and there's always reasons why somebody wouldn't do something, but I think collectively, the community does agree that proactive policing is important for the sanctity of the places that they live.
Yeah, and proactive policing is often applied to the most impoverished areas of our communities. Would you agree with that? Right.
know in the video or just zoom in there. I don't want him to be examined just standing up in the background.
Your Honor, I think you can sit down. Thank you for pointing that out.
See, we still need to live.
No, Your Honor.
I might use it on redirect, Judge.
I don't know how much gonna be.
I'm sorry?
I don't know how long he's
Would
gonna
you,
be.
I'm happy to move it back now if you'd like, Judge.
Huh?
You want to move it back now?
Let's move it back, and we'll move it back when it's time to use it.
Crime happens in affluent communities.
Yes.
Crime is committed by all peoples of all races, of all creeds, of all beliefs.
Yes.
And you talked a lot about your instruction of your police students that the proactive policing model is the appropriate one, correct?
Appropriate to what?
It's a very important part of policing.
Yes, I agree with that.
Right. Yet we are applying this proactivity in a way which we both agree is only targeting a certain portion of the population.
I don't agree with that.
Okay. Well, before, a few moments ago, I think we agreed that rich people commit crimes.
Yes.
Black people commit crimes.
Yes.
White people commit crimes.
Yes.
Gay people, straight people.
The relevance of this?
Sustain.
There's a limit to proactivity, though, correct?
Yes.
Just because an officer wants to be proactive doesn't give them the ability to go and make a command upon someone.
No, the ability to be proactive is sort of a general theme. The commands would come from specific information that's derived from being proactive.
And you would agree with me that one's mere presence in a high crime area does not subject them to commands and required compliance with the law enforcement.
I'm going to object, Judge. Goes to legal conclusion.
Overrule, answer it if you can.
I can tell you what we train officers to do. Hypothetically, mere presence is not sufficient for a person to be stopped just because they happen to be in some particular location.
Mm-hmm. In terms of location, you gave an example before about kind of where there are aberrations of the baseline. Do you recall that bit of testimony?
I do, yes.
Okay. And I think the example that you gave was the church on Sunday morning, right?
Yes.
In the church on Sunday morning, the baseline for that, assuming that they hold services on Sunday morning, would be a room full of people, right?
Yes.
Perhaps a message going on or a song going on.
Yes.
Okay. And you can apply that baseline to other places, like a parking lot, right?
I'd apply the baseline everywhere, yes.
Sure. So things that you'd expect to see in a parking lot to a apartment building would be cars, correct?
Yes.
People in those cars.
Sometimes, I mean, it depends on, we get into the hour, we get into if it's a high crime area, things like that. So I think there are other factors that go in besides just the fact that there are cars and there are people who typically drive them.
Okay. And I think you have characterized Mr. Othal Wallace as being suspicious just because he was in that vehicle.
I'm not sure I did that.
You're not characterizing just Othal Wallace's mere presence in that vehicle as being suspicious.
So again, I'm not privy to all the information that the officer had. I think the officer thought he was suspicious because he decided to exit his vehicle. Now, he could have been there.
You just stop there. We need to remain objective in this, not subjective. Go ahead.
I'm just asking for your objective opinion. I mean, you've been called here to render an opinion by the state of Florida. Is that correct?
Yes.
Okay. And you would agree with me that you believe that that individual in the vehicle would cause a minor amount of suspicion. What are you doing there? It's dark. You're all alone. What's happening?
Judge, I'm going to object as to specifics in this case.
Might I ask for a legal basis beyond specifics to the case?
Here comes that. You may proceed.
You testified before that Mr. Wallace was startled.
He appeared to be startled to me.
And certainly you would advise your criminal law enforcement students to take into account the way in which a citizen would react to their actions, right?
No, that's not true.
Okay, you're not.
Speak up.
That's not true.
Well, maybe I probably asked a poor question. Maybe let me ask it this way. Wouldn't you agree that in connection with your lectures, you would tell your officers you need to be observant of the people that you're dealing with, right? You would observe their behavioral cues.
Yes.
Okay. And certain cues that you're looking for could potentially suggest involvement in criminal behavior.
It's possible.
Okay. And you have things that people can do with their hands that might suggest criminal behavior.
Yes.
Things that people can do with the way that they're speaking that might be consistent with criminal behavior.
Yes.
Okay. And there are ways that a person would act if they are being falsely suspected of something. Would you agree with that?
Object, Judge, as to speculation outside the scope of the grant.
I'll let him answer. Answer the question.
Yeah. I mean, I don't think an officer would know if they're being falsely accused of something. I mean, for example, if it's a approach to Mr. Wallace because maybe Raynor has in his head that maybe this is a medical emergency, or maybe he's operating behind the wheel of a car because he's intoxicated. I mean, I don't know what he's thinking. But approaching him is not inconsistent with police training. Approaching him, talking to him, finding out what's going on, trying to develop a baseline for the parking lot at that moment, I think was appropriate. That's exactly what we would train officers to do.
But certainly you would agree with me when you're teaching your students, you would never tell them, officers in training, it is completely reasonable for you to think that if you go up to someone and falsely accuse them of something that they will have no negative interaction towards you at all. They wouldn't be startled, they wouldn't be scared, they wouldn't be frustrated.
Does someone object as to speculation how someone might react?
Overruled. You can answer if you can.
So again, I take some exception with the idea of reasonable because I think that is a judgment call after the fact. That being said, it is appropriate for officers to approach people, and we do tell them that sometimes their behavior is unpredictable, particularly when we pull cars over. Sometimes people get all panicked when they're behind the wheel of a car. They may not go to the side of the road like we expect. They may cut across lanes, who knows. So I think officers are cued in on the idea that an approach to somebody will have some consequence in their reaction. What that consequence is unpredictable until it happens. But if it's consistent with criminality, law enforcement officers are also trained to recognize that.
So confronting someone who's doing nothing wrong might result in an unpredictable response.
Yeah, I would say that's true.
Nothing further.
Thank you. Redirect. Say that again. Oh, yeah, that's fine. It's okay.
Judge, I don't have any questions at all.
All right, can you
Yes, sir.
fix the screen? All right. May the witness be excused. State.
Yes, sir.
Defense.
No, he can be.
Okay, you're released from the subpoena. Thank you very much. All right, State, call your next witness.
Can I just have a moment, Judge?
Yes, sir. This is a procedural stop that I have to take at this moment. I'm going to ask you to step into the jury room, please. All rise for the jury. Folks, I'm going to give you 5 minutes, okay? Be back here in 5 minutes. All right, do we have a motion from the defense?
Yes, Your Honor. The defense will make a motion for judgment of acquittal. First on the premeditation aspect. As you know, it's more than a mere intent to kill. It must to fully formed conscious purpose to kill. The purpose to kill must exist for a sufficient length of time to permit reflection as to the nature of the act to be committed and the probable result of that act. Based on the video, we can see that there was no premeditation. Mr. Wallace, all he did was react to a situation he was thrust into by the illegal activity of Mr. Raynor, and so therefore there was no premeditation. They're trying to get it in through some posts that were done almost a month prior to this incident. Those posts had absolutely nothing to do, nor were there any indication of Mr. Wallace's state of mind as to the time of the incident. As for the felony murder, it's evident from the video that Mr. Raynor was not acting in good faith, thereby making his actions unlawful. Based on Raynor's actions, Mr. Wallace had the authority to resist and defend himself because he felt that he was reasonably in danger, and therefore a JOA should be granted on that one as well.
Okay, a brief response.
Your Honor, as far as premeditation, the post before and after, as well as the video and what happened in that video, all established premeditation. The state has done that. Of course, in light most favorable at this point as well. And as far as the right to use force, there's been no testimony at this point regarding that. I would say that there's excessive force. The video speaks for itself. The best evidence, and therefore the motion should be done.
All right, the standard of a review at this point in time is the court to view the evidence in the light most favorable to the state. Based upon that standard, I'm going to find that there's sufficient evidence for the jury to consider the case and render a verdict in this case, and that the state has proven a prima facie case at this point in time. The motion for judgment of acquittal is denied. Did you say you have something you're going to present or no?
Yes, Your Honor. Just more for the record, not anticipating it being granted, but we would assert the record of motion for mistrial based upon the court's denial, specifically this time in reference to the testimony of Mr. Bedard on our special hearing.
Okay, the motion for mistrial will be denied. The court's ruling stands.
In terms of the scheduling of things, yes, Your Honor, we do have some exhibits that we're going to present, and we may have some testimony as well. So
Okay.
in terms of the timing, I would suspect maybe.
Well, I'm going to keep going right now.
Okay.
But because I may not get a chance, Mr. Wallace, we've had conversations about taking the stand or not taking the stands for 2 days now. And now comes the time where I have to ask you those questions, whether or not you've had the opportunity to discuss the decision as to whether or not you want to testify or you don't want to testify with your lawyers. Have you done that?
Yes, sir.
And have you given thought to whether or not you want to testify or you don't want to testify?
Yes,
And have you made a decision whether or not you want to testify or you don't want to testify? And what is your decision? You want to testify. Now, you remember we had this discussion that previously you had been, I told you that you'll be able to tell the jurors, you know, what you want to say, but that you'll be vigorously cross-examined. You understand that? Okay, and then you made that decision freely and voluntarily, correct? Did anybody threaten you or force you or coerce into making that decision? Did anybody promise you anything for making that decision? Okay. And obviously, you're not under the influence of any alcoholic beverages or controlled substances. Okay, then I respect your decision. Oh, it's okay. The court reporter took down the answers. So that microphone you have to push down to talk in order to pick up the PA. That's okay. That's fine. The court reporter took the answers. All right. So we're ready for the jury?
Your Honor, just maybe procedurally makes sense now to give the state an opportunity to have any objection. We have a few exhibits that we're going to introduce. I'm just naming them specifically. It would be the court's pleasure to take any objections to those now, let the jury's out. Sure.
I don't know. Is there objections?
I don't know what they're referring to, if I can just talk.
Yeah.
which we talked about, we certified that. Or something else authenticated through Mr. Kyle's. I believe there's an objection to that. We have 2 photographs that we believe were authenticated. We moved those in. I don't believe there's an objection. We also have still shots, frame-by-frame stills, which by stipulation we're agreeing to admit. And I think the only matter of contention is our desire to introduce body-worn camera footage from Amanda Dickens, essentially 30 minutes, an hour before the interaction on video with Othal and Jason Raynor. And in that video, she has a very brief exchange with Mr. Raynor. They don't talk at all. The purpose of that would be effectively to provide some more information on the bias and credibility of the testimony of Ms. Dickens, where she said at a prior time she was very certain that it happened at this trespass location, and the video shows otherwise. As in terms of the relevance, that would be the relevance around in terms of the admissibility. We believe that she has not only authenticated it when she was testifying, but also we have it under a business record certification.
Okay.
Judge, 2 things. First off, Officer Dickinson, she already admitted that she didn't make that statement at that time. So there's no extrinsic evidence is admissible. Once a witness admits on the stand that they made a mistake or they lied or they were inconsistent, you can't put any evidence in. So that's the first hurdle you can't get past. Secondly, it's all hearsay, Judge. It's just conversation with her and Officer Dickinson. But Officer Dickinson already admitted it.
Okay. Well, it's not hearsay. It's not offered to prove the truth of the matter asserted. So that doesn't fly.
There's no statements on the video, Your Honor. That's the point. There's no conversation in the video at all.
Okay. Well, I mean, are we going to play 30 minutes of nothing?
It's 30 seconds to a minute of video.
Oh. Okay. I'll overrule the objection if you want to.
Even though the witness already admitted she didn't say it at that point?
I think they're entitled to show proof that, they're consistent with their position. That she didn't say it, at least on that one instance. I don't know what other instances there are. You're free to argue. There might have been another instance, another communication, whatever it might be. That's argument for the jury. But I think they're entitled to put whatever they want to do to demonstrate that at least in that one instance, there was no communication regarding the stolen vehicle. I think that's what it shows, right?
She's already admitted that on the stand. So you can't put in extrinsic evidence once a witness admits it. Unless they have a case that states differently, all the case law is clear. Once a witness admits on the stand to it, you can't put extrinsic evidence to prove it.
Okay.
So that's exactly what they're doing.
I'll allow it. Thank you. Anything else? So that's the only objection, correct?
Yes, sir.
The rest of it is stipulated too?
Yes, sir.
Okay.
It's just procedurally good. I don't think we have a desire at this point in time to actually publish those items to the jury. We just wanted to see if the court had any issue with that. We would go on the record, admit those, and then you take it.
Out of fairness to the jurors, at least say admit this item and then stipulate to, what it may depict. So they know what to look for. Otherwise, I don't know how many items of evidence are we up to now. But,
That's exactly what I was asking, Judge.
okay, well, but there's an agreement as far as what it might be in there. I mean, sometimes the description becomes objectionable too.
And I know this is exactly why I brought it up, because I don't think it would ever be appropriate for an attorney in this context to argue to the jury. All that I wanted to say was, the defense at this point in time, by virtue of stipulation, admits this piece of evidence, which is the Axon audit trail.
That's fine.
Something to that effect. I just wanted to make sure that was okay.
That'll be fine, okay? Obviously, the description is something that is inconsistent with what you believe it is. You're welcome to stand up and I'll allow you to say it, okay? Anything else? We're ready for the jury?
Hold on.
Hold on.
We need to set up our computer, the state's taking the one that was up there.
Set up your computer?
Yeah,
Okay,
Do we have a moment?
yeah. Defense, you have an objection to that?
No, I think it's in line with the.
Okay.
It's one, this is two, this is three. Want to do that first? Do we have these in?
Let me know when you're ready.
Okay, Sharon, if I could just.
Yes, sir. Oh, take him. Bill. I'm sorry, Bill. Wait. They have to take. Go ahead. He needs to go to the restroom. Take him. All rise to the jury. The jury is present. You may be seated. The state has rested. Defense?
Your Honor, this time the Othal Wallace.
You'll raise your right hand, please.
Do you swear to tell the truth in this proceeding, so help you God?
Yes.
You'll come around here, please.
Witness is seated, Your Honor.
Make sure you speak loud and clear so the jurors hear what you have to say. You may proceed.
Good morning. Would you introduce yourself to the jury?
My name is Othal Wallace, T-H-A-L-W-A-L-L-A-C.
And microphone just a little bit up. Sometimes it picks up your breathing, but
I'm good right here.
get closer. Thank you.
And Othal, where did you grow up?
I was born in Gainesville. Later, I moved to Daytona Beach, Volusia County. Then I stayed in the land for a while and moved to Broward County. Then I moved back to Daytona.
And back on June 23rd of 2021, where were you living?
I was living in Daytona Beach,
And what was the address?
133 Kingston.
Okay. Now, were you working at that time?
Yes, I was.
Where were you working?
At the McDonald's off of Bevel Road in Daytona Beach.
Right. And back on June 23rd of 2021, did you work that day?
Yes, I did.
And what were your hours that day?
I was to open, so I went in about a little after 4:30 in the morning, 4:30 in the morning, and got off shortly after 3:30, between 3 and 4.
And after you got off work, what did you do?
I drove home as I always do.
And then did you stay at home the rest of the night, or what did you do?
Well, when I got home, I took a shower. I had to go see my other kids. I have 4 kids that reside in the Volusia County area, 2 that were where I was living, and 2 lived with them. My other kid's mom lived over in Daytona, so I had to go to see them in Daytona. And I was just trying to split the time, share my time with all my kids.
And I probably should ask you, who all lived with you at 133 Kingston Ave?
My 2 daughters, should I say their name?
You don't have to.
My 2 daughters and my girlfriend at the time, Taisha.
And how long were you out seeing your other children?
I had left after I took a shower, so it was after like 4:30 or 5 maybe, and then I didn't come back until like a little after 8:30.
All right, and you've seen everything that, the video and everything, and obviously you were there, but, when you got home, back to your apartment, what were you doing in your vehicle?
I was just sitting in my vehicle. I was listening to music. I had taken a phone call, and I just went back to listening to music and just relaxing and smoking my cigar.
Were you ever aware of a vehicle pulling into the parking lot area?
I noticed lights because I was just sitting there, and it was fairly dim in the parking lot in the back at that time. So I was just sitting there, and I noticed the lights, and I didn't notice the vehicle just about until it was in front of me, like in front of my car.
Would it be safe to say you were preoccupied with what you were doing?
Yeah, I was just minding my business. I was minding.
And at some point, did you notice Jason Raynor walking towards your vehicle?
I noticed the individual with a flashlight. I didn't know it was Jason Raynor, but I did notice the flashlight, and it startled me a bit, and I was kind of like nervous and just caught off guard. So I was looked up to see what was going on.
And when you noticed the flashlight, where was it shining?
It was directly in my face. I was just about blinded from it.
From the time that you noticed the flashlight in your face to the time that Jason Raynor was at your vehicle, approximately how long did that take?
It was quick, like within seconds, almost I would say just about immediately.
And as Jason Raynor approached, what were you doing in your vehicle?
I had already opened my door because I was prepared to get out the car as I usually do to go in the house. So I was just gathering all my things. That I basically had stuff on my lap, and I was just kind of collecting, overseeing the car before I get out and just getting ready to go in the house. I already had the door open. So I had my leg out.
And so you had one leg out and you were starting to stand up, is that what you're saying?
Yeah, I was in the motion of getting out of the car.
All right, and as you were getting out, did you see Jason Raynor in close proximity to you at that time?
As I was getting out, by the time I made it to stand up, he was like just about he was like in the car door, in the area of the car door, and making his way in between like the opening of the car and like me. You know what I mean?
And at that point, how did you feel when he was standing in that area, I guess?
Like I said, I was already like nervous and kind of surprised, a little shaken up because I didn't know who it was, and I'm not, used to nobody approaching me back there. So I was nervous and confused, a little like, caught off guard.
And how tall are you?
5'7".
And was Jason Raynor taller than you?
About 4 or 5 inches, yes, sir.
Now, when Jason Raynor was standing, I guess, between the car door and the car, did you feel at that time you were free to leave?
No, sir. It wasn't even space for me to leave at all.
But is that the only reason you didn't feel like you could leave is because of the space, or anything else?
I was shocked, and I realized he's right there, so I couldn't move. I was locked in, and I was kind of like going off, and what's going on with this situation.
Did you ever try to leave?
I did. When I stood up, I attempted to kind of move around, but he was right there so close I couldn't go anywhere. So that's at that point. Can I go back a little bit, kind of in the past? Okay, I went to I'm a licensed security guard in the state of Florida, so I had to take
that as a non-responsive
Sustained.
Just why? I mean, I'd asked you about whether or not you felt you could leave, or why you tried to leave.
Okay, well, I couldn't leave. He was standing in the doorway.
Okay. And how many times did you try to leave during this incident?
I made 3 efforts to walk away, and it happens very fast. And I'll try to explain, but I made 3 efforts, and that I can remember.
And did you ever find out as to why you were put in between your car door and your car and unable to leave?
Now, I never got an answer as to why I wasn't able to leave.
And as far as Jason Raynor's actions, was he asking you questions, or what was going on?
I recall him saying something to the effect of, "Hey, how's it going? Do you live here?" And I was just like, "What's going on?"
Was it really dark at that time, or was it just becoming dark?
It was newly becoming dark.
And while you're put in between your car and the door, what was going through your mind?
Like I said, I was already confused and caught off guard by the unsuspected presence of him in between my door, all of a sudden. So I was beginning to get scared, and it immediately he began to put his arms on me and stuff. So I didn't know what was going on. I didn't have an answer to my question, so I was confused as to what's taking place in this situation here.
Why didn't you just sit down as you were instructed?
I didn't know what was going on, and I wanted to know what was going on, but I also do know my rights, so I felt that I had the freedom to leave.
And why didn't you just tell him that you live there?
I asked him a question to try to figure out what was it, try to get some insight of the context of what's going on, and I thought that it was a fair question being he's the law enforcement officer, so upon approach, I just asked what's going on. I never got an answer, but I just asked what's going on. I mean,
Was there ever any conversation between the two of you?
not besides my question and his demands. That was it.
And at what point did everything escalate?
It began to escalate at the point of when he started to put he had his hand on my shoulder, as you can see in the video, and when I made like an effort to kind of like shimmy my way between the space that I had to move and like where he had his hand, he put his other hand on my hand. That's when, like I say, I don't want to go into it, but I want to be able to explain why I held my forearm out. And that's something I learned in security school, is when you want to make distance with somebody or create a space to move, if like anybody have ever seen like celebrities walking through a crowd of people, they have bodyguards and they kind of walk through with their forearm out, not in like a way to like hit anybody or cause force, but if you bump into the forearm, it's a safe barrier to kind of create that space. So that's what I attempted to do when I just kind of like held my forearm out to get. If you look on the video, the door is open and he's standing there. So if I can hold my forearm out, I can create a space where I can maneuver, because I don't want to become physical with him. I'm just trying to kind of make my way out of this small space that I found myself in.
And at that point, were you fearful at all?
I was most definitely fearful because I didn't know what was going on. I hadn't had answers to my questions, and I was just trying to see like what's going to happen here. I never ever in my life been in that situation, and that was kind of like one of my worst fears, is being in a situation like that in the dark with no witnesses, nobody to see what's going on, and nothing to like really bring any awareness to the situation.
Your Honor, we're going to play the video, and then I was going to ask if the court would allow for Mr. Wallace to come down here. And
Okay, did we know what exhibit is you're playing?
it's 12, I think. 12.
It's the real-time video, Your Honor.
You may step down.
State's Exhibit 12.
How's it going? Do you live here?
What's going on?
Do you live here?
Why are you asking? What's going on?
Sit down. Sit.
Sit. Sir.
Can you sit down? I'll talk to you. Stop.
Okay, come on now.
Sit.
Come on now. Don't do this.
Sit down.
Why are you asking me, do I live here?
Do you live here? Yes or no?
What's going on, though?
Who? Charlie 777.
Nah, back up.
Stop. Stop. Stop, man.
If we could back it up. Okay, right here's a good spot. At this point here, you testified earlier that the light was in your eye.
Yes.
What's going on right here?
All right, in this particular situation is when I noticed the light, and I'm a little confused. Like I said, I'm not used to people coming up to me at this time of night, and I was kind of just like caught off guard and a bit like shaken up. So I'm starting to become aware of this presence, and it's garnering some type of emotion that would make me feel kind of scared. Like I was like,
Can we go to the point where the door is open? Okay, at this point right here, explain, I guess, where you are in relation to Mr. Raynor, because obviously we can't see him.
okay, well, just imagine like the hood of the car and the door in the driver's seat. At this point, I had just stood up. So when you're getting out of the car, you automatically turn sideways. It's like a normal motion. So as I'm getting up, I'm turned sideways. And he's basically right here. And that's when you can see his arm on my shoulder. And my hand, like, when I'm getting out of the car, my phone was on my lap, so it's kind of sliding down. And I'm always aware that I crack many phones by just standing up. So I always like kind of grab whatever's on my lap. And that's what I was doing. And
And you said that his hand was on it. Was that just a soft touch, or was it a forceful touch, or what was going on?
This initial touch is what stopped my first effort to walk away. This is the first. If you see, okay, I can't really see. The screen is big. Can I take a step?
Yes.
Okay, so the screen is kind of big. So at this point, you can see. If you go back, you can see where my shoulders shifts. So I can't. Now I realize I don't have my freedom to walk away right here.
And that,
Sir,
Can you sit down?
that's what I was going to ask you. At that point, did you feel as though you were free to walk away?
No, I knew I wasn't, because the only way to walk away was to basically like go through him or go some way around him.
Can you go a little further?
come on now. Come on now. Don't do this.
Sit down.
Why are you asking me do I live?
All right.
Okay, wait, we can't talk if the video is playing, and we can't both talk at the same time, okay? Only one thing at a time.
Let me ask the question. Go back just a little ways. Okay, right there. All right. And if you were unable to, in your mind, leave when there was one hand on your shoulder, how did you feel when the second hand was placed on your other shoulder?
It furthered my fear of what might take place between me and the individual at the time. If you look, he's holding my shoulder, like pushing me, basically pushing me, and then he shifted me back towards the way, which would kind of, if I took a seat, I would sit directly on the driver's seat. So that's kind of what's taking place in this,
Move forward.
in this frame.
Tell me, do I live here?
Do you live here? Yes or no?
What's going on though?
Radios.
777.
Nah, back up.
Stop.
Okay, stop. Now, at that point, you hear him radio, you go to his radio, takes his left arm off you, and that's when you bring up your left forearm. And why at that point did you make a more concerted effort to leave?
Because for various amount of reasons, I hadn't had any answers to any of my questions. I'm scared as I can possibly be. There's no witnesses, so now I'm thinking that he's gonna call somebody else. So I don't know. I didn't do anything. I wasn't, breaking the laws. I had just been sitting there minding my business. So now it seems like there's about to be more people to come assist him with whatever he finna do to me, and I don't know what's going on. Nobody has answered any of my questions. I'm 10 feet away from going into my apartment. I don't know what's going on, so that was my effort to be like, okay, now I have to become a little more assertive in my effort to walk away, and that's when I held my forearm out and just kind of try to make more
All right,
space.
go up till it gets dark, so you can't see.
Stop.
Okay, now at this point, you really can't see what's going on from the video, right? How close were you and Jason Raynor at that point?
We was just about chest to chest, because he was pulling me towards him, and like we was kind of shifting and like kind of spinning around. It was basically if you grab somebody and you have a lock grip on them and you kind of shifting around, the space is so small, like there's nowhere really for us to go, so we just about chest to chest.
All right. Did you continue to try to get away from him?
I was pulling away as I'm like trying. I'm not in I'm not trying to get any closer. I'm pulling away the whole time. I'm trying to like pull away, but he got me by both hands just about, and that's how I'm like so close to him.
And that was going to ask, did he still have you with both of his hands?
Yeah, at some point, but then
And then at some point, were you able to get away from his right hand?
yes, I was.
And how did that happen?
Well, he like either lost. I'm not sure if he lost grip or just moved his hand. But when his hand did move, so like imagine this is my shoulder, and like it's a pulling motion. So when his hand did move, he started to like make movements towards his waistband, and I was starting to look and try to like.
Well, let's go back a little. As you were trying to walk away just before it gets dark, where did he have a hold of you?
On my shoulder and my arm.
And what when you say shoulder, is that what you're talking about?
Yeah, but now at this point, his hand is on my shoulder, but his grip is on my shirt, at the shoulder portion of my shirt. That's what I'm...
Was he pulling on your shirt?
Yes. Now in this frame, if I would have been able to walk away, it would have been like a motion like this. Like, I can't really do it because I got a suit on, but it would have been more of a yoking type of motion. It would have been more, my head would have like been taken back by that motion.
Now, when we get forward again where it's dark, once he was released, when his right arm let go of you, what maneuver or what motion did you make at that point to try to get away?
So his right arm came off of me, but this shoulder. So if you reverse this position, it would it would be like this. So when he dropped his right arm, I kind of like tried to make an effort to duck under it, because if I could have got his right arm to go over my head, I would have been able to put him behind me, and then I would have created like that space of freedom to get away from him or whatever was going on.
And then, did you notice anything when you ducked down to go under his arm?
Right. When I ducked down, he kind of like shifted his elbow and was making a reaching motion towards his waistband. And that's, at that point, I was like, you know, something, this is not gonna go right for me. And I started like basically, like, there was a deep sense of fear that my most, you know what I mean, the thing that I feared the most is probably gonna happen to me right there.
So how, you said you saw his hand go towards his waistband?
Yes.
All right, and in response to that and your fear, what did you do?
That's when I like made an effort to get around, but when he moved, he still had, I can't really do it without an extra body, but it's hard to. So his arm is on me, right? And I'm trying to get under it. Imagine this arm is on me. I'm trying to get under it. But his elbow goes like this, so I can't. But when I'm doing it, his right arm is making that motion. When he makes that motion, that's when I drew my firearm and I couldn't get under his arm, and I kind of ducked. When I ducked and I fired, the gun went off at like right at my ear, and that's when like he was in like a movement type of motion, and he fell backwards, and I like stumbled back as he lost his grip on my shoulder.
All right, and then
Stop, man.
Okay, and you hear you say something at the end. Do you recall what you said?
I was in like a state of adrenaline, so I was basically like, I think I said something like "get the fuck back" or something like that.
Okay. All right, you can sit back down. Yeah, we'll go back. Need a back foot? Yeah. Now, we've all seen those Instagram posts that came out in early June. Were they a part of your Instagram account?
Yes, it was.
And there's the one that references pig's blood. And you make reference to Minnie. What was that in response to?
The pig's blood statement was this probably the stupidest decision I ever could have made when it comes to me venting to things I was frustrated about. But at the time, there was a lot going on in our country. People, was getting killed, and it was unfortunate. Lots of unfortunate situations taking place. And I'm not sure if many of the jurors are familiar with social media, but I'm kind of one of those people that wear my heart on my sleeve when it comes to expressing myself on the internet. So a lot of times I get on there and just say stuff like meaninglessly, or just I'm one of those people that's quick to make comments about things you know, whether it's true or not, I just cast my opinion. So that was kind of basically what was going on, but it was just a reflection of, you know, what I was feeling and going through at the moment about what was taking place all over the country with these unfortunate incidents.
Can I get you to stop there? Disengage the computer from the screens.
Yeah, push the button. There we go.
You Proceed.
All right, what about the post with, regarding Johnny Bolton? What was this about?
The situation with Johnny Bolton is a guy that was killed by a SWAT team in Cobb County, Georgia. No knock warrant, and I felt really bad for the incident that took place. And again, like I say, you know, I made a bunch of comments online about things taking place in the country, and that was one of those comments that I had made just out of frustration for what took place. I was feeling, you know, much compassion and sentiment that his family was expressing online, and I was just saying stuff, you know, just making my frustrations known in whatever way.
Were these posts in any way a manifesto for you? You know, like, this is what I'm going to carry out, this is what I'm going to do?
No, it were just things I said out of frustration because I'm just overly expressive sometimes.
If you could, would you have deleted those posts?
Yeah, but unfortunately I couldn't. I wasn't able to delete them. I do that often when I regret saying things or realize how stupid it was. I just delete it. It happens. You know?
Was it ever your desire to have a run-in with law enforcement?
No, sir. No, sir.
What, you know, and again, you kind of explained, but what were these posts? Why were they there?
Like I say, there's a lot of content on my IG page, and I'm one of those people. Like I said, I'm very expressive or overly expressive, and I get upset or whatever. So sometimes I vent about things online, go to Instagram. I'm one of those people that make comments on YouTube, and you know, whether you could call it trolling or not, or just, you know, an overly expressive person. But I'm kind of one of those people. So you'll find if you knew me or was on Instagram, it's my life, somebody else's life, or neighbors. I'm always just kind of just talking about things and just expressing my opinion. Just whether it's relevant or whether anybody can connect with it, I just do it. That's just something I do when I'm in my leisure time on social media. So I noticed that I have a few young jurors, but I'm not sure if y'all use social media or understand the use of it. But a lot of people tend to get online and just freely express themselves, whether it's relevant, whether people can connect. It's just something.
The narrative.
Sustained.
Sorry.
You're good. You're good. Later on, after this incident, there was an audio post. When was that posted?
Later on, as in?
On June 23rd of 2021.
The post after the situation?
Yes.
Well, there was an audio recording, and I was just, again, being overly expressive about my frustration at the situation I had just found myself in, and I was just frustrated, and I was really in a state of panic, and I was kind of still in that adrenaline state where I thought that this is over with. There's no way in the world that I'm gonna get my last message out, because I was driving and I was expecting something to happen, like a pit maneuver or my car to be, you know, stopped and shot up or something like that. So it was kind of a last-ditch effort to get the message to anybody that was on my social media.
Okay. That night, were you hoping, or were you trying to make those posts a reality?
No, I was just sitting in my car, relaxing, minding my business.
And why did you pull your firearm?
Because in the moment I felt in that moment there was no other way I can get out of this situation. I'm in this situation where I don't know what's going on, and I tried my hardest, and I gave a genuine effort to try to gain an understanding. And I said, you know, what's going on? And after I realized there's a situation outside of my control, you know, I just did what I could to survive the encounter, because I didn't know, you know, how it was going to end for me after I realized, you know, him going for his waistband.
And why was the firearm in your pocket?
Well, when I leave in the morning for work, I get up early, so I always get up and put my firearm. It has a sleeve holster, and I put it in the glove compartment of my car. So as I said before, I was already getting out of my car, and that's one of the first things I grabbed to make sure that I don't forget it in the vehicle. So I grabbed it and I put it in my pocket, and as I was getting ready to get out the car, it was already in my pocket.
And I guess in your mind, how certain were you that you had to react the way you did?
There was nothing else I could do. I was backed in the corner. I tried to leave. I tried my hardest to get an understanding. You know, I seen him reaching for his, waistband where I know that there's, multiple amounts of weapons that could be used to cause, me harm or death. And being in this situation, I'm not sure how people, how other people would react. But in my perception, I felt that this was the only option I have after I had tried everything else. There was no other effort that I could have put into walking away safely, and that was the best thing I could have did to preserve, my being.
1 second, Your Honor.
Yes.
Your Honor, I don't have anything else at this time.
Folks, I understand this is a lunch hour, but I think I'd like to keep going. Does anyone need to eat a snack before we keep going or use the restroom? State cross-examination.
Yes.
Can I have counsel sidebar just very quickly? State, I already ruled on the marijuana issue, so that no need to repeat that. But what is the next proffer that you had at the sidebar?
Yes, Judge.
You may be seated. Thank you.
Mr. Wallace indicated he's never been in this position before, never been in a situation late at night with an officer by himself. There's 17, I said 14, it's 17 other interactions with law enforcement where he either received a notice to appear or was arrested, Judge. Yes, sir.
Your Honor, he's not a convicted felon. As far as impeachment, they can ask him, have you ever been convicted of a felony or a crime, misdemeanor involved in dishonest? When he's talking about, I've never been in this situation, he's talking about, I've never been in a situation where I'm doing nothing wrong, getting out of my car, and I'm backed into a corner. Not that he's never had any interaction with law enforcement in the past. It's all about that. I've never had an incident where something like that had happened and he felt that his life was in danger. And like I said, we can impeach him on if he's ever been, if he's a convicted felon, how many, and whether or not these are any crimes of dishonesty. But to go into all these other acts as improper character evidence, and they're filed any motion, the Williams rule, and
Judge, the state normally wouldn't file a Williams rule. We don't know if the defendant's going to testify. And once they open the door, it's fair game for us to address that situation.
His answer gives the inference that he's never had any sort of interaction with law enforcement. That is misleading to the jury. However, to get into 17 specific instances would be overly prejudicial. So unless you can call back your question, I'm not really sure.
I can ask if he's had interaction with law enforcement and he knows how to behave with law enforcement. He's had times where he's been with them and he's behaved appropriately.
Well, that's an open-ended question, which I know he probably doesn't know how to answer that based upon what the limitations are for impeachment. The standard rule for impeachment is, have you ever been convicted of a felony? Have you been convicted of a crime involving the making a false statement or dishonesty? That's normal impeachment. His state of mind is at issue, and he claims that at the time he'd never been in that situation. So what would your question, proffer your question to me if I was Mr. Wallace?
Yes, sir. Judge, he made a specific statement. He's never been at night in a parking lot or somewhere dark where no one else has been around where law enforcement's interacted him. There's at least 2 or 3 incidences where I would go into it where it was late at night, he was arrested by law enforcement, and everything was fine. And there was no issue. It was one officer who arrested him in that instance. He knows the facts better than I do, Judge. So I would just go into certain instances where you say that you've never been in a situation before with an officer late at night. That's incorrect, isn't that, sir? In fact, on this date at 1:30 in the morning, you were arrested by a law enforcement officer. It was dark at night.
Okay, no, I don't want to let you get into the arrest part. That he had interaction with law enforcement, okay. That the interaction resulted in an amicable or a resolution to the case without resorting to the use of violence. But we're not going to use the words arrest. Certainly there's no convictions, so, and that just establishes the state of mind at the time.
Yes, sir.
Based upon his answer that he had never been in this situation before.
Yes, sir.
Okay? All right, so, and I don't want you to say the nature of the charge either.
I would not do that.
It's just an interaction
yes, sir.
with law enforcement before and blah, blah, blah. Okay, anything else that we need to, while the jury's out?
I don't think so, Judge. I mean, if there's something close, I will obviously come sidebar before I do it.
Your Honor, I just ask that he limit his hands to what he's going to talk about, not a statement, because this stuff isn't like grades around for that.
I'm just organizing the different dates and night times.
Okay. I mean, I'll leave that alone. So bring the jury back. Actually, hold that door. Counsel, I don't know. I got a note. I'm assuming it came from a juror. I don't even know who put this in. 73? 33. When we in the room, a lot of the jury discuss the case when we're not supposed to. Please make them understand we cannot do this. It's brief, but it happens. You want me to do anything about it other than to instruct them again?
I would just ask you to instruct them.
I would just ask for another instruction.
Okay. Bring him in, Mike.
All rise for the jury.
We just... You may be seated. Folks, I want to emphasize an instruction that I have given you because there's no gray area to my ruling, okay? You are not to discuss this case at all. That means nothing when you go into the jury room until I allow you to do that. I have to trust that you will follow my instructions, and I'm banking on you that you will follow the rules. So please do not utter any words that relate to anything that happens in the courtroom while you're inside of the jury room, okay? Thank you. State, you may proceed.
Thank you, Judge.
Something became unplugged. You came back. All right, I'll tell you what, do me a favor. Just move it just back a little bit. And I really want you to stay at the podium, okay?
Yes, sir.
And if you can X out that whatever that is.
That's from Zoom itself.
Thank you. You may proceed.
Yes, sir. Mr. Wallace, when Officer Raynor, you keep referring to him as Jason Raynor, you knew he was an officer, right?
I do know he was an officer, yes.
Speak up.
Yes, sir.
Right, so when he approached you, he was in his uniform, correct?
Yes.
Yeah, he had a shiny badge?
I didn't notice a shiny badge, but
Okay, I'm sorry?
maybe he had one, but I didn't notice it.
You knew he was a cop, police officer, correct?
Yeah, at some point it became clear to me
Right.
that he was an officer.
Before, even hands-on or anything, you knew he was a police officer, didn't you, sir?
Before he put his hands
Before he
on me,
put his hand on you and he stepped around the car and said, "How you doing? Do you live here?" As he approached you, you knew he was a law enforcement officer, didn't you, sir?
I was blinded by the light, so I wouldn't been able to see him until he was in the doorway, and that's when it became clear to me that this is a police officer.
Right. You saw the police car, though, in front of you, didn't you?
I did see the police car.
So policemen usually drive police cars, right?
Yes.
Okay. So it would be apparent to anybody that Officer Raynor was a police officer as he's approaching you, correct?
Yes.
And you would agree with me that he asked you, "Do you live here?" And you didn't respond, did you, sir?
I did respond. I asked him what's going on.
Wait, you didn't respond with an answer, did you?
My answer was a question. I said, what's going on?
Is that how people respond to questions with other questions?
I'm not sure. I can't speak for anybody but myself.
Is that how you talk? So if someone asks you a question, you respond with a question and light following?
And depending on who I'm talking to, and if I feel like, I should answer them without a question, I would just give them an answer.
Right, so you didn't feel like you should have to answer Officer Raynor, did you, sir?
I did feel like I should have to answer him, but the approach was what garnered. It was a natural reaction to just say what's going on. It wasn't a matter of me being defiant towards him.
Isn't it true he asked you several times, "Do you live here?" And none of those times did you answer him, correct?
It is true that he asked me that, yes.
Right, and none of those times did you answer him?
No, I asked him what's going on. I answered him.
And you never said, "Hey, I just live right across the street there," right?
No, I didn't say that.
Right. So you were non-responsive to a law enforcement officer just asking you some questions, correct?
If you put it in that way, I didn't answer his question.
You were evasive. A better word?
No, I was not evasive. I was just simply asking him what's going on. That's what I would ask anybody. If they approached me suddenly, I would just ask them what's going on if I was a bit confused as to why they was in front of me.
So if anybody approached you, you'd respond that way? Not differently with a police officer?
No, I would just respond like that. If it could have been anybody, I could. What's going on? If you just suddenly walk up and you're immediately in my personal space bubble, I would ask you what's going on. Like, are you here to give me? Do you need to tell me a secret, or like what's the need for the close proximity? Is what I'm trying to find out.
Did you ever say, "What's the need for the close proximity"?
No, I asked him what's going on. I think that would have been a more universal way of attempting to get an answer.
After he asked you if you live there, correct?
Yes.
Multiple times, correct?
He did ask me that multiple times.
And he also asked you to sit in the car multiple times, correct?
Yes.
And you didn't listen to him, did you?
No.
Right. But
I did.
You know, you're a security officer, right? Or you went to a security class? You got
Yes.
training, correct?
Yes.
And as a security officer, when you were trained, you learned that people are supposed to respond when a person of authority asks them to do something, correct?
When I was a security officer, I never walked up on
That
anybody.
question is correct, yes or no?
Ask me the question again, please.
When you took this class and you got trained as a security officer,
Mhm.
you learned that people are supposed to respond when a person of authority, a law enforcement officer, or security officer, asks them to do something, correct?
Yes, if it's reasonable.
So in your training, they taught you you only have to listen to a police officer or a security officer if it's reasonable to the person who's hearing it? That's what you're telling us here?
Hold on, ask me that one more time.
When you went through this training,
Right?
as a security officer,
Okay.
right?
Mhm.
You learned that you're going to give commands to people, and there's an expectation that they would listen to those commands, correct?
Correct.
Right. Yet in this situation, after you received this training, you didn't listen. You didn't respond to the law enforcement officer, did you, sir?
I responded by asking him what is going on.
Right, but he asked you direct questions. You can understand that late at night, right, an officer sees someone in a parking lot and they're patrolling the area, that they might want to make sure that person lives there. You'd agree that's an appropriate thing for a law enforcement officer to do, right?
Yes, I would agree.
Right, you live in that neighborhood, and if there's someone suspicious or someone who may not be there, you want the law enforcement officer to look into that and make a decision and see if that person belongs there, correct?
I would want them to do that if they don't live there.
Right, but how did Officer Raynor know you lived there? You didn't tell him?
I'm a regular resident of the place. I park there every
How
day.
did Officer Raynor, who asked you a direct question, do you live here? How would he know you lived there?
He wouldn't have known if I lived there.
Right, because you wouldn't answer him, correct?
I didn't give him an answer as to where I lived. No, I didn't.
Right, because you were being evasive, right? You wouldn't answer any of his questions, correct?
It was not an intention to be invasive.
Okay. Well, when he asked you to sit down, that was evasive. You didn't sit down, did you, sir?
No, I didn't.
Right. In fact, you testified earlier under direct that you had no other option but to kill Officer Raynor that night, correct?
After there would have been a situation where I was pulled on, pushed on, and then where I was back in between the cars and the gate, and then I seen him reaching for his waistband or whatever could have been on his waistband.
We'll get that in a minute, but you testified earlier that you had no other choice but to kill Officer Raynor that night, right?
And after everything else I had tried, that had become the only option that seemed to be.
Did you try turning around and sitting in the car?
Did I try to turn around and sit in the car?
As he asked you to do?
I tried to walk away.
Sir, that's not the question. You said you had no choices. Did you take yourself and sit yourself in the car when a law enforcement officer, who you said, from your training, you know you're supposed to listen to them, asked you to sit in the car?
Well, he was pulling me at that point, so I wouldn't have been able to sit down.
Sir, at that point, he has his hand on your shoulder and he's saying, sit, 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 right? He's not pulling you at that point.
No,
you watched
not-
that video 50 times, correct?
More than that.
Right, and you would agree with me, at the point when he's asking you to sit, 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 he's only pushing you backwards actually to get you to sit down, correct?
Right, but I'm trying to walk away because
But you said you had no choice to do anything else.
after everything else I had to do, I tried to do, that had become that's what seemed to be the only option. But initially, are you asking me could I have sat down initially?
You certainly could have, couldn't you?
Yes.
And you didn't, did you?
No,
Right, and you could have listened to the officer and told him you lived there, couldn't you?
I could have.
Right, but you didn't, did you?
No, because I was trying to get an answer as to what was going on.
Because you wanted to be in control of the situation, sir, correct?
I wanted to know what was going on, most certainly.
You wanted to be in control. You didn't want Officer Raynor to be in control, did you?
It had nothing to do with my efforts of being in control. I just wanted to understand what I was dealing with.
Bro, if they come for me, it's a message to y'all, bro. I'm not gonna back down. Whose words are those?
Those are my words on Instagram.
Your words. About police officers, correct?
No, it's not about police officers.
Really?
Not that message is not pertaining specifically police officers. I was just.
Why don't we get into that then? You sat through the trial, correct?
I've been sitting.
Yes, sir. going to show you what's in evidence as states 45. I'm just going to stand over here, okay?
Yes, sir.
So let's read. One day, I will take great pride and honor in getting me some pig's blood on me. Were you talking about little piglets?
No,
Were you
no,
talking about farm animals?
not specifically farm animals.
You were talking about police officers, correct?
Not just people. Not like just. I'm just talking about people that don't see me as human.
What people do you refer to as pigs?
People who don't see me as human.
So you're going to get pig's blood on my hands and boots. If you can't feel the enemy following me now, I'm going to be healthy for you. I pray against my enemy and I wish death to all. Right? That's your words.
Yeah, but you didn't read it as it's.
Right? Well, let's go. But I want to go on. So if you remember, you had been texting with your friend, right? And your friend actually sent a screenshot of this to you and told you you shouldn't be saying that because you're going to get your account closed down, correct?
Oh, he said something to the effect of that, yes, sir.
Yep. In fact, he says, love you. I love you getting banned. That means he's afraid your account's going to get banned by what you're saying, correct?
I'm assuming that's what he was intending.
Well, you had a conversation with him.
I said I'm assuming that's what he was getting at.
What did you take it to mean?
I just agreed and said I'm assuming that's what he was getting at.
Right, and you said, fuck these crackers and their power, I'm speaking to them. You didn't care, right?
I'm talking about the people of Instagram who have the power to shut down my Instagram.
Right,
That's what I'm
okay.
talking about.
And then you say, you're right, fam. That's why I've been not tagging my old tags. So you were avoiding tagging your old tags on your account, correct? Because you didn't want to get caught.
Caught doing what? I was
You said it. Why I've been not tagging my old tags.
right. Meaning
Right.
saying
You've been tagging things that were antagonistic and anti-law enforcement, correct?
no. I've been tagging other things that may have been the reason why my Instagram got shut down. It had nothing to do with police officers in specific.
Well, let's talk about that. You say, I'm tagging my old tags, saying too much, bro. I want their blood, for what they've done in Minnie. June, they killed another brother.
Mm-hmm.
Who killed a brother in Minneapolis?
There's been various situations that
Who are you referring to?
you talking about. Okay, you have multiple situations.
Mr. Wallace.
Judge, Your Honor, let him answer.
I'm trying
Let me resolve
this way. I can't.
This statement right here was direct to police officers, correct?
No, sir.
Give me one other person in Minnesota who killed someone.
I can't do that. Is over 2 years ago, and can I answer?
Sure.
I made many comments on Instagram about things happening all over the country. I can't say specifically if that message was intended to direct at police officers because it was so much stuff. I commented on a lot of stuff all the time, and I just don't remember specific that being a direct at police officers. So no, I can't agree with you on that.
So, as you sit here today, you're telling this jury that this wasn't in reference to police officers.
No, sir.
And when you say I hate them, you're just saying I hate anyone who
I'm talking about
kills people.
I'm talking about the people. I'm replying to multiple things going on in the text, going on in the chat. If you give me a chance to explain, he writes multiple times, and I'm commenting multiple times. We're having basically a twofold conversation in one chat, and that happens on social media, which when you talking to people. So, and I could have been talking about when I say I hate them, I'm talking about the people that be shutting down my page.
That's not what it says. If you read the context of it, sir, it says, but I feel it 100%. And then you say, fuck these crackers and the power I'm speaking to them.
Yeah, but he also said something about me getting banned.
Is Instagram a bunch of crackers?
I'm not sure if it is, but
You refer to that as law enforcement officers as crackers?
no, sir. No, sir.
Okay. Well, you refer to law enforcement as pigs, don't you?
No, sir.
In fact, after you killed Officer Raynor or shot him, you went on Instagram and you posted that I'm not going to let these pigs do anything to me, correct? Say it up to them.
I said, yes, I did refer to as pigs, but when I say the word pigs, I'm not specifically always talking about police officers.
Who else are you talking about?
I'm talking about people who don't see me as human.
Okay, so when you shot Officer Raynor, you referred to him as a pig, and all the other people as pigs, the officers, correct?
No, not just when I said it again. I'm referring to people who don't see me as human.
Sure. And then you go on and say, I hope they're listening. Fuck them, brother. You just don't know how close I am, bro. Right?
Yeah, I'm talking again. I'm having a twofold conversation about the people who have the power to shut down pages at Instagram.
No, this is about you harming a law enforcement officer because it's in response to pigs and the blood, right? Isn't that correct, sir?
I'm having a twofold conversation in the chat.
Where's the twofold? Yes, sir.
I'm having a twofold conversation in him about the post, but I'm also talking about the people who run Instagram. And if you understand how I conversate, that happens with me a lot of times because I'm very expressive when it comes to comments and making, things on Instagram. So that's kind of what's going on in that.
So in this entire conversation, I don't see your alternate conversation.
You don't see where you're talking about me getting banned from Instagram?
Right. If you read it, it progresses. You were going to get banned because you were posting about killing police officers. And he said, you better watch out. We need you to be out there, bro. We still need you to be around. And then you say, I don't give a shit. I don't care. I'm going to post what I want to post.
It's not true.
Okay, sir. And then further on your post, you say, I hope they're listening, meaning the police, because who else is going to be listening to you?
I want to ask you, do you know if the police have an Instagram account that they specifically watch my page?
I have no idea, sir.
So how could they be?
Well, why would you write that?
Because Instagram monitors, and I'm frustrated with them. So I'm just referring to them specifically.
So when you say, I hope they're listening, fucking brother, you just don't know how close I am. What, are you close to canceling your Instagram account?
Yes.
Oh, okay.
I'm just frustrated by...
So when you say, bro, if they come for me, it's a message to y'all, I'm not going to back down. So if they take your stuff down, that's you're going to cancel your Instagram account?
I'm not, you talking about specifically that. Again, I'm having a twofold conversation. This is over 2.5 years ago when this took place. So when you read the comment, I'm trying to understand the exact context we was having, right? So read it one more time so I can understand which comment you're talking about.
Bro, if they come for me, it's a message to y'all, bro. Oh, yes, sir. And press go? You may. Right here. So when you said, bro, if they come for me, it's a message to y'all, bro, I'm not going to back down. That was from Instagram?
Was it from Instagram?
So you weren't going to back down from Instagram? Is that what you're saying?
I was gonna be consistent with continuing to start more accounts. I'm not gonna give up because they cut one account.
Okay. Let's talk about that night. You were possessing a firearm, correct?
Yes.
And you had it concealed in your body, correct?
Yes, I did.
Right, and you didn't have a concealed weapons permit, did you, sir?
At the time, I had already applied for concealed weapons.
Did you have one at the time of this incident?
No, I didn't.
That's the answer then, thank you. So you were actually not lawfully in possession of that firearm at the time, were you, sir?
It was most definitely mine. I had bought it from a store, and
Were you allowed to possess a concealed firearm?
was I allowed to conceal the firearm that I possessed?
And possess it on your body?
Judge, Your Honor, that goes beyond his scope. He's asking for a legal question.
He went to security school and was trained.
Wait.
Yes, sir. You went to security school, right?
Yes.
You learned when you can carry a concealed firearm, didn't you, sir?
Yes.
In fact, you were applying for a concealed weapons permit, correct?
I had already applied.
So you went through the process, right?
Yes, I did.
And you didn't have a concealed weapons permit at the time you had that firearm secreted or secreted on your side, correct?
No, I didn't. I didn't have one, but I had assumed that my application had been approved because I already had my license.
You assumed it had approved. You had a license from the state of Florida, a concealed weapons permit license?
I had a security license.
That's not my question. Did you have a concealed weapons permit license?
No, I didn't.
Right. You knew that you couldn't possess that gun, didn't you, sir?
Again, if you let me answer, I was going to answer that in my previous question. I had assumed that my application had been approved because these licenses, these types of licenses backpack on one another. If you don't have any felonies and you're legally able to possess a gun and you apply for a carry concealed or a G class, then you would normally get, once you get approved for one, the motion of getting approved for others just smoothly like happens. It's not nothing that will prevent you, because once you're deemed able to be a security guard, then you basically meet the other qualifications. And I had assumed that I did already meet those qualifications. So yes.
So you without any notification from the state of Florida, without any paperwork back, knowing you filled it out, which said you have to wait for you to get a license, you just made an assumption that you can carry a concealed firearm?
Yes, I did.
Even though you went through all that training with your security class?
Again, I had made the assumption because I had known the
That's not my
previous
question.
steps of
You
what was
were
going
trained
on.
in the security class of when you could actually possess the firearm. You had to have a concealed weapons permit, correct?
Yes.
Right. You didn't have it.
No.
And you knew what the law was, correct?
Yes.
Okay. When Officer Raynor approached you, did you say, I have a gun on me, be careful, here it is, officer, I don't want to cause any concerns?
I never got to answer or conversate with him too much beyond asking my question, and I didn't understand why I didn't get an answer. So
Right. Because you didn't answer him.
No, I didn't give him an answer until if I lived there. I asked him what was going on. It wasn't even an effort to pull power. It was just a natural reaction to somebody coming up to me. That's what happened.
Sure. Let's talk about your training. You have extensive training with firearms, don't you, sir?
Yeah.
You're very proficient with them. You'd agree with me, right?
Yes, I would say I'm.
You fired them more than 100 times in your life, right?
Yes, I have.
At least maybe 1,000, right?
No, I wouldn't say just up to 1,000, but I've fired.
And you've possessed firearms around other people before, correct?
Mm-hmm.
Right?
Mm-hmm.
So you know how dangerous they are, right?
Yes.
Oh, I'm sorry. Yes.
And you know how dangerous they are, correct?
Yes.
Right. And you know you only pull them, and you receive that training in your security class if your life is in danger, right?
Mm-hmm.
Is that a yes?
Yes. I'm sorry. My bad.
Right?
Yes.
And in this case, your life wasn't in danger, was it, sir?
Yes, it was.
What danger?
Mr. Raynor had me back between my car.
You mean Officer Raynor, right?
Officer Raynor.
Right. Okay. So Officer Raynor, go ahead.
When he had me in between my car, the door, my car, and the car backed up, I had already tried to leave. He had begun to grab me by the back of my shirt, and I was restricted from everything I was trying to do to prevent any physical encounter or misunderstanding between me and him. And I seen him reaching. I began to be in fear that my life would be taken. And this was already my worst fear in the world, in my life.
Sure, but let's break that down. So you said it once again. He had you blocked in, right?
Yes.
And all you had to do was sit down, right?
I could have sat down.
But you didn't, did you?
No.
Right, you didn't comply with it.
Because I wanted to walk away.
I understand you wanted to walk away, but you could have complied and not got to a point with having used deadly force, correct?
I could have sat down. Yes.
Right, and complied, right?
Yeah.
Right. You'd agree with me, right?
Yes.
Right. So this whole situation would have been diffused if you had just listened to the law enforcement officer there, correct?
But I was already
That's
in.
not my question. It could have been diffused if you listened to the law enforcement officer. Isn't that correct?
He had already been touching me, so diffusing.
Sir, that's not my question.
Mm-hmm.
You said that you had to use deadly force because he's reaching for his weapon, and that only happens because you escalate the situation getting past him. If you had just sat in your car, this would have never happened. You would agree, correct?
I wouldn't say it would never happen because I don't know what was on his mind.
Okay. If you had sat in your car, you would agree with me that Officer Raynor was not just one lieutenant.
And asked and answered. Overruled.
You would agree that if you had sat in your car and listened to Officer Raynor, there was no threat upon you at that point, correct?
I wouldn't have perceived any threat.
Correct. Let's talk about this. You're talking about that you have to do this and Officer Raynor grabs you. Isn't it in fact true? Let's go back and watch it. Let's go frame by frame.
Scoot over a little bit, please.
How's it going? Do you live here?
How's it going? Do you live here? He asked you two easy questions, right? Didn't respond, right? Let's hear what you say.
Live here?
What's going on?
Sit down. Sit.
Let's look at this picture right here. You testified with your attorney that this was a Swisher Sweet, right?
Yes.
Okay. You can see that it looks like a joint too, correct?
I know what it is, but I don't know what you can perceive it as, but it was a Swisher.
Aren't Swisher Sweets a much bigger cigarette style?
It's a cigar, and I'm at the end of it. I'm at the end of a cigar. So
you would agree that people smoke marijuana in Swisher Sweets, correct?
I don't know what people smoke their marijuana out of. But I smoke cigars.
So you don't smoke marijuana?
No, I have before, but I wasn't smoking marijuana specifically, but I have smoked marijuana before.
Because if you were smoking marijuana at that point, that would provide Officer Raynor an opportunity to arrest you. Right?
Your Honor, again, it calls for a legal conclusion.
It goes for whether or not he thought the officer could have arrested him.
Ask me the question again, sir.
If that was a marijuana cigarette, do you think Officer Raynor could have arrested you?
If it was a marijuana cigarette, I don't know what he could have done if you know, I don't know what he could have done.
You know if that's a crime around this one, marijuana?
Am I aware of it? Yes, I know it's illegal in some places because at this point people have license for it. It's legal and medical marijuana is legal. I'm not sure.
Do you have a medical marijuana card?
No, I don't.
Okay, so it wouldn't be legal for you, right?
No, but I wasn't smoking marijuana.
Okay. So you're saying this is the end of your cigar?
That's the butt end of my cigar because it's.
Why do you try and conceal it when Officer Raynor comes up there?
It's visibly out. I didn't try to conceal nothing.
Let's watch and look at your phone.
How's it going? Do you live here?
What's going on?
Do you live here?
What's going on?
So let's just go a little frame by frame. You see it right there in your hand initially? Mm-hmm. You see you're pulling your phone?
My phone was sliding out of my lap.
I understand what you're saying, sir, but you see you're putting your phone, and it seems like you're concealing?
I didn't conceal nothing. I just was dropping my hands.
Okay. So in this instance, Officer Raynor has his arm on you, correct? And he's just asking you because you're getting out coming toward him. He's just making space.
I'm just standing up.
Right. You agree he's not grasping you here, right? He's just making
Your Honor, I object. Best evidence. They've been carrying on about that. You can watch the video.
The one who was there. You would agree right here, he's not grabbing you, he's just pushing you to make distance, right?
There was no way to make distance. I was just standing up.
There was no way to make distance because you were approaching toward the law enforcement
I
officer.
was just standing up out of my car.
Okay, but then he said, sit with this light little tap, and you didn't sit, right?
No, I didn't. I just continued to stand.
Yes, sir. You've never met Officer Raynor before, correct?
I didn't even know who he was.
Right. No interaction with him before?
No, sir.
You know how to act with a law enforcement officer, though, correct?
Yes.
And you know that if there's something that they do illegal, the place to challenge it is in the court system, correct?
Did I know that law?
Based on your security training.
They don't teach you that law in security training. I don't get police training in security training. They give me security training to be a security officer, not necessarily police officer. We don't learn the statutes of how police conduct themselves.
So as you sit here today, you didn't know that you can fight in court if there's something the officer does that you think is wrong?
I know that you can make complaints and you can file a civil claim, but I didn't. To this degree, there was nothing.
Let's talk about this body camera.
Sorry. You said there was nothing.
There was nothing I would have done to. I mean, there was nothing I would have been thinking about, because there's nothing necessarily initially making me, want to take him to court. He hadn't.
He didn't do anything wrong.
Yeah, at this point.
Right.
At this
He's just asking you to comply. He did nothing wrong.
And I was trying to walk away.
You weren't complying though, were you?
I hadn't done nothing wrong.
How do you know?
Because I've been sitting in my car.
What if he had a report that you were a suspicious individual? Does he have to relay that to you right away?
He would have been.
Cause for speculation.
This video right here that we've watched multiple times, you would agree that that's the complete interaction with you and Officer Raynor, correct?
To my knowledge.
You were there. Was there any other interaction?
No, I've never had any interaction.
That's not my question. Your defense team is making it a big deal about 30 seconds of the video before. Was there any interaction with you and Officer Raynor prior to what we see on this body camera here?
No.
No. So this body camera is a fair depiction of your entire encounter with Officer Raynor. Do you agree?
I'm not sure if he's seen me or.
That's. The question is, your entire encounter with him is all recorded on the body camera, correct?
To my knowledge.
Well, is there any other part of the interaction that's not codified here?
What I'm saying is, I don't know if he had seen me and I didn't know he was there. I don't know.
That's not, okay. Your interaction, your speaking, communicating, and interacting with Officer Raynor, it is all on this video that we watched, correct?
Again, to my knowledge.
Well, you keep saying that, but I don't understand what that means.
Because I don't know if there's something else somewhere else that I was never made privy to.
Are you aware, you were there that night, right?
Yes, I am.
Is there any conversations, any interactions before this video starts with you and Officer Raynor?
Not with me and him.
Right, so your entire interaction, you, Othal Wallace, Officer Raynor, right? The entire interaction is on this video.
Allow him to finish one at a time.
You would agree, it's all on the video?
Yes, sir.
Thank you. After you shot Officer Raynor, did you call 911 to report that someone was shot and they need an ambulance?
No, I didn't.
Right, and you could have just called anonymous, couldn't you?
No, yeah, I could have.
Right.
I was so, there was a lot of adrenaline going on, a lot of emotions, and I was too afraid to have any further interaction with another police officer or the force period because I didn't know how it would go, given that this one didn't go at.
So you could have called it anonymously, right? And you could have reported, there's an officer been shot behind 133, right? Get an ambulance there.
When you say anonymous, I mean, I couldn't have called it. I know that police record, and I was afraid to have any further interaction with a police officer or the force.
Because you just unlawfully killed Officer Raynor.
Because I just had a situation where I had to defend myself. I didn't necessarily know if Mr. Officer Raynor was dead or not.
Right, but you just shot him and you didn't call any help for him.
I did have to shoot him, but I didn't make it. Like I say, I was afraid to call anybody.
You're claiming self-defense. You live right across the street in 133. Why didn't you run in there, lock the door, call the police, tell them Officer Raynor's been shot, get an ambulance here, it was an accident, I didn't mean to do it, or was self-defense, I need someone to respond. You didn't do that, did you, sir?
No, I didn't.
Instead, what you did is you fled, correct?
Yeah, I did.
You're right. And you actually drove up to Jacksonville in the car you were in already, right?
Yes.
Okay. But you didn't go right to Georgia at that time, did you, sir?
I was basically driving around aimlessly because I was afraid.
Instead, though, what you did is you called your dad and said, I need a new car, because you wanted to disappear, right?
The first thing I said on the phone with my dad, I'm not sure if he remembered, but I told him I was scared and that a cop had got shot.
But you didn't tell your dad, I had to shoot him in self-defense, did you?
I didn't go into why or anything. I just told him that it happened.
But you didn't, when you drove up to Jacksonville, you had an opportunity. You know Jacksonville goes straight to Georgia, right? You've been to Georgia many times.
Yeah, Jacksonville on 95, you could go there.
Right, so you could have taken the vehicle that you killed the police officer in from that you were driving, and you could have stayed in it on your way to Georgia, correct?
Yeah, but I was too afraid to.
You were too afraid because you were trying to cover your tracks, right?
No, I was too afraid that if I was seen in the vehicle, that I automatically get shot and killed and never have an opportunity to have this day.
Why not just drive to the police station, walk inside where you know they have cameras, say, I'm the one who did it, please, I need to give my side of the story.
At that moment, those are the very people I was scared for my life from.
So you think if you walked into a police station where they've got cameras, all these officers, that they're going to rush at you and just shoot you on camera there?
I didn't know how it would go by me trying to explain what took place. So I was afraid.
Right, and then in fact, you went all the way to Gainesville, right? To get a different car.
went over to Gainesville, yeah, and I called and
And you backed your car in, right, at Home Depot? You didn't just pull it in regular, right?
backing in is just like a normal way that I park.
Or it's also a way to avoid someone seeing your license plate, correct?
I mean, it could be for somebody else, but it's just the normal way I park.
Sure. So after you just shot a police officer, you were just thinking, well, let me make sure I back in. Let me take a little more effort, back the car in, just make sure. Not trying to get out of there quickly. I'm just going to take the extra time to back the car. That's what you're saying?
Backing in is like a forced habit because that's just what I'm used to. I back in at work, I back in at home. It's just kind of how it happens.
You cut your hair after, didn't you, sir?
Yes, I did.
Right, to avoid detection, correct?
The reason I cut my hair is because I was afraid that if I got identified, I would be killed without question.
Right. Once again, you could have went to any police station among hundreds that you passed your way to Georgia, but you didn't stop anything.
No.
You didn't call the news media and say, hey, I just had self-defense with a police officer. I need you to come with me when I turn myself into the police don't kill me, right?
I didn't consider that as an option.
Instead, you went all the way to Georgia, right? And you go up in a treehouse, correct? Is that a yes?
Yes.
And you have an AK-47 style weapon out there with you, correct?
Yes.
500 rounds of ammo.
Beyond the scope of direct.
500 rounds of ammo, correct?
I don't know the specific round count that was.
And you're hiding out there, correct?
I'm just scared, and I'm staying where I feel safe.
Right.
Until I can figure out how to bring myself to the law.
You would agree Officer Raynor was polite and courteous to you, correct?
No.
You don't think he was polite and courteous?
When he asked the question, but are you talking about verbally or
verbally? He was polite and courteous to you.
Initially.
Yeah, and then you wouldn't answer his questions, right?
No.
Okay, even though he was polite and courteous to you.
But I asked him a polite and courteous question.
Don't you think most importantly when someone asks you a question, you respond first and then you ask the question after that?
In normal communication, but I was confused, and I asked him a question out of a natural reaction. It wasn't like a casual conversation we was having. I just asked him a question as a natural reaction.
Sure. But let's talk about this struggle that you say ensues. So tell me how long it takes for you and Officer Raynor to struggle and you pull your gun and shoot him. You went through this long thing that took a long time when you were down here describing it. Describe it to us.
I was just describing motion by motion.
Right, let's hear it.
When it happened, when he started to force me back and push and pull and twist, there was obviously a struggle, you know.
Well, you didn't respond. You actually were not moving and getting away from him until he called on the radio, correct?
I had already tried to walk away twice.
Right, but I do, sir, and on the radio, it's when he calls for other officers, or he's getting on his radio, and he says, Charlie 77, and you say, no, back up, man, don't you, sir?
That's when I reasserted my effort to leave.
You reasserted your effort and pushed Officer Raynor out of the way, didn't you, sir?
He was already pulling and twisting me.
You pushed him out of the way to get away from him.
I held my forearm out. That's what I did.
Sir, you pushed him away. Right, let's see. Right, he's trying to have you comply, and you pushed yourself away. You would agree that using force against a law enforcement officer, even your forearm, that is a form of a battery, right?
I held my forearm out.
Actually, again, he's asking him to draw a legal conclusion.
Rephrase the question.
Yes, sir. You're aware you can't resist police officers with force, can you?
Yes.
Objection, again, he's asking for evidence.
You're aware you can't do that, right?
Yeah.
You're aware you can't touch police officers or hit them, correct?
I never touched him. He was coming towards me, and he already had me. So I was trying to create a space where I could walk between the door and him, and I just held my forearm out. The reason I held my forearm out is so that nothing would get misunderstood about me being aggressive towards him. I didn't want him to perceive me as any form of aggressive, because that's why I held my forearm out.
Based on your training in the security class and in your other, maybe training you've had, you would agree by pushing a police officer and trying to get past them, that's not appropriate for someone who the police officer is trying to talk to, correct?
I never pushed him. I just held my forearm out. I just held it out.
And you touched him with it?
I didn't intend. He was already on my arm.
Okay,
so
let's
I didn't
seconds.
like force. I didn't like do any motion like that. I just held it out to try to get around the door in the space between him and the door.
Where was the gun?
At this moment,
Yes.
it was already in my pocket because I was
Which pocket?
the right pocket.
And where was it in a holster?
Yes.
Okay. So you had a gun in your holster, in your pocket.
Mhm.
You agree with me? Is that right?
Yes.
Correct? And tell me how much time it took from when Officer Raynor grabbed you till you shot him.
I can't specifically. I would have to reference.
I don't want you to watch the video. I want you to tell me from your memory.
It's two and a half years ago. So whether it took a couple seconds, or are you meaning by seconds or like milliseconds? I don't know how specific you intend to be here.
Here's what I want you to do. You told me that you and Officer Raynor are chest to chest for a tussle. I assume for a couple seconds. Is that correct?
Well, he's pulling on me. He's pulling me towards him and trying.
How long?
It happened for a good few amount of seconds. It took
A good few amount. More than 10?
just about.
Okay, so you're tussling for about 10 seconds. You agree with me, correct?
Mhm.
Is that a yes?
I don't want to agree because I don't know specifically if it was 10 seconds or 8 seconds or 9.5 seconds. So I'm trying not to. I don't want to be time specific because I can't remember the amount of seconds.
Let's give you the benefit of the doubt. 8 or more seconds.
Okay.
Fair enough?
Yes.
Okay. You'd agree 8 or more seconds that you're tussling at first with him, correct?
That he's pulling on me and
Right. Pulling on you after he cues up on his Charlie 77 and he's still grabbing you here. And then there's another at least 8 seconds where you're face to face. Not on the video here, but it has to be off video because we don't see you face to face here, correct?
I would say we're pretty face to face.
Are you including your time in this one right here? Because all he has is his hand. Let's go forward.
Can you sit down? I'll talk to you.
Okay, come on now.
Okay. So, are you talking about this? He's tussling with you?
I mean, that's what I was meaning when I said he was pushing and pulling on me.
He was just directing you to try and have you sit down, correct?
I just tried to walk away from him when I stood up.
But that's not a response to my question. He's telling you at this point, please just sit down. Sit down and I'll talk to you, right?
Yes.
Right. You didn't listen, right?
No.
And he's got a hand here and a hand here trying to direct you back into the car, correct?
He's pushing me into the car.
Into the car, right? He's not using excessive force on you at this time, right?
I'll begin to get scared, so
Did you scream for help from anyone in the community?
Scream.
Help!
It's in the back of the parking lot. Everybody's in the house. There's nobody outside.
You saw the video before how all those people in body cam came running out after Officer
2nd DCA 2021. So if you want to take a look at it, if I got it wrong, I have to give you a ruling right now because you're about to do closing arguments. So my ruling is that I'm going to give it. There is a correction to be made to the jury instructions, to that particular instruction, the third paragraph of the verdict.
We did a change a little bit, just slightly, Judge, to make it seem more like it flowed. Because when we did it, it was, what we did is we just changed and did first-degree murder of a law enforcement officer, and first-degree felony murder. But then we just put the same rule applies to the lesser-included offense of first-degree murder, just so we don't have to reread the same thing for.
Well, I was just going to add, the same rule applies to the lesser-included offense of first-degree premeditated murder and first-degree felony murder.
Absolutely fine, Judge.
Okay, let me just make that correction. That's kind of weird. My instruction is not matching what I have in paper. Let me just read it out loud. If you return a verdict of guilty to the charge of first-degree murder of a law enforcement officer, or this is where you changed it, or the lesser-included offense of first-degree murder, it is not necessary that all of you agree the state proved first-degree premeditated murder, and it is not necessary that all of you agree the state proved first-degree felony murder. This requirement is that all of you agree the state proved either first-degree premeditated murder or first-degree. A little bit confusing.
This is how, did you read the new one, Judge? Does that one make more sense?
Well, the old one read, if you return a verdict of guilty to the charge of first-degree murder of a law enforcement officer, it is not necessary that all of you agree the state proved first-degree premeditated murder of a law enforcement officer, and it is not necessary that all of you agree the state proved first-degree felony murder of a law enforcement officer. Instead, what is required is that all of you agree the state proved either first-degree premeditated murder of a law enforcement officer or first-degree felony murder of a law enforcement officer. The same rule applies to the lesser-included offense of first-degree premeditated murder and first-degree felony murder. Did you think you sent that, or?
Me or Mr. Urbanik, I think.
I
I'm just gonna
can't-
send you a new copy, Judge. Gary, you okay if I just send it to the judge?
Go ahead and send it.
I got it.
Did you send me the
I
verdict?
just sent it. Did it not go through? It says it was sent at 3:48 p.m. I can. It'll take probably about 10 minutes. I can have Terry go down and print it out for us, Judge, if we need to.
Well, I don't know why it's not coming through.
Do you want me to just put on a flash drive for you, sir?
Let's give it a second.
Okay. Did it disconnect you from the internet by any chance, or?
No, I just received an email from someone else.
I'll send it again. Maybe it's me. I didn't. I only sent it to the judge. I'm going to send it to Gary too this time. Let's see. Gary, let me know if you get it. I just sent it to you too. So this is the first video. So this is the down version. So now.
Okay, I just received it.
That's something from somewhere. I think it's some instruction. The jury instruction. Deadly force, what it means. More jury instruction stuff.
Somebody's phone is ringing on the table. Okay.
Hold on, let me play this so you can see this. From current side. Just that, and the below further portion, premeditation, then that below further portion. This is just, sure, I'm not gonna, you know, and then this is, I'll probably take that, but,
Okay,
oh, no, actually, that's it.
I have the verdict up now.
Okay. Hold on a second, look at that. Let's see. Do you want to project it too, Judge, or no?
If you wish, I don't care.
I mean, it's up to you.
I have it in front of me. I don't
Okay,
need to
perfect.
project it.
Just so, Mr. Wood, do you have it up, or do you want me to?
I've got it.
Okay.
I read it. How do we tell the jurors about the requirement that they be unanimous on their finding of guilty of first-degree murder of a law enforcement officer by either theory or both?
I think it's just by the verdict instruction. Under the verdict, it's the instruction.
I suppose I could explain it too.
You could, Judge. I mean, we had it come up in a trial with Judge McGillen, and I think we had forgotten to put that in there, actually. And they came back and they were like, we're 9-3, and we actually had to put it in, and once it...
Okay.
If you want to explain it, we're fine with it, Judge.
I think I'll have to explain it.
Okay.
That's just...
Is the court denied by our requested
Yeah,
interrogatory request.
yeah. I mean, I'm old school. I'm kind of like you. I prefer to split them and find a unanimous verdict on each theory. But the case law is a case law. I can't go against that. So I respect that's what it is.
And Judge Nichols had this happen about a year ago. The jury actually said, I have 6 for this, and they came back.
Right. Okay, so I will give the verdict as proposed. I will not be able to give you instructions right now. I won't be able to fix all this before I can give it to you. So I'm hoping that you can use whatever you have in front of you and
I mean, I think
give your closing based upon that.
I think Mr. Probisco and Mr. Urbanik pretty much they have the standards of what we're going to use. So I think.
Okay. All right. So then we'll be in recess for. Where do you go? Never take them out without letting me know. Please.
Before we do have to get back to the justifiable use of force.
Hold on. Wait till the defendant comes back.
No, I'm just reminding you, Judge.
Yeah. Hold on. Yeah. Always let me know, man. Do you know when he left?
Just a moment.
Just now? Okay. All right, for the record, the defendant is back in the courtroom. Do you wish me to go back any on the jury instructions so that he can hear what we're talking about?
You heard him all. I mean, literally, you were talking about, I'm old school, I'd rather have it this way when you walk.
Okay, good. All right, so now you were saying, Mr. Lewis, what were you asking me?
We need to go back to the justifiable use of force. We never finished that, Judge.
Oh, 3.6F?
Yes.
Okay. Well, let me take a look at the one you sent me.
We didn't send you one. I was just going to go by what Ms.
He did.
Oh, okay, but yes, I don't think it was very. I would prefer to go with what Mr. Wood has, and we can argue what we agree or don't agree with.
Okay.
But I can.
Let me take a look at the standard.
Sure, of course.
All right. I have the standard up.
Yes, sir. And I compared Mr. Woods to the standard, and I kind of agree with what he put together, except for there's certain things we don't agree with that I can argue.
Okay, then let me take a look at his.
Yes, sir.
What page is his on?
I think it starts on page 22.
Got it.
Yeah.
Yeah, it starts on 20, it should be 24.
Maybe mine's just out of whack.
What?
So we print these things, sometimes it depends on the font.
I'm just looking. It has 22 on the bottom of the page.
22.
Okay.
Yeah.
Yeah, it starts 3.6.
Okay, and then what do you disagree with? And
Judge, if you go to page 23, the first paragraph, if Othal Wallace was not committing any crime other than the alleged first-degree murder of a law enforcement officer, it's basically saying he doesn't have to retreat. The state would disagree. He admitted on the stand he was carrying a concealed firearm, which is a crime, and he's not allowed to carry one. So we would object to that paragraph coming in, Judge.
What's his defense?
Judge, parsing more from putting Mr. Wallace's testimony in context, he was in his car, he was got his gun as he was getting out of the car when he was confronted by Mr. Raynor. So we would contend that he was not committing a crime at the time he was getting his gun fact, it was not concealed, and therefore that paragraph should stay in. Oddly enough, the incident happened about 8 days before the law changes by concealed firearms, but that's neither here nor there. We think the paragraph should stay.
But the gun was concealed at the time that he encountered Officer Raynor.
Pardon me?
By his own testimony, the gun was concealed at the time he came in and had his interaction with Officer Raynor.
Well, as I recall, he had grabbed the gun as he was getting out, and then he put it in his pocket. I understand that, Judge, but he wasn't doing anything illegal at that point. This just leads the jury, who was the smoking body, testified to that. He wasn't doing anything other than sitting in his car and listening to music when this whole complication occurred. So our respective position is that there should stay.
Hey, Judge, there's not going to be a paragraph in there saying he was doing anything illegal or whatever. It's just he doesn't get the benefit of the stand your ground at that point for the no duty to retreat.
I agree with the state. Strike that paragraph.
And then,
Over the objection of the defense.
and then, Judge, the next one where we...
Hold on.
Yes, sir.
Next one.
Yes, sir. On page 23, I don't know if it changed when you deleted it, but it's on the bottom of page 23. It has an A, and then it goes next to it.
I'm sorry, that's page 24 for me.
24, okay. It says the
Paragraph
person...
A?
Yeah, it says the person who against whom defensive force was used was in the process of unlawfully and forcefully entering or had unlawfully and forcefully entered a dwelling, resident, or occupied vehicle. That's not the case here, Judge. As the defendant testified, Officer Raynor never entered his vehicle. There was no evidence it was unlawful entering in any way. He was having actually the defendant to sit back down, so he didn't even break the plane, the officer. So this is not applicable in that situation, Judge.
I'm going to leave it. I'm going to leave it because you have paragraph D in that same instruction. That you can argue that.
So I was looking at where it was A, B, Judge.
Right.
Okay, and then you're talking about going back
to
under
D.
A, B, C, D. Okay.
As an exception, so I think they're entitled to it. You argue yours, they argue theirs, the jury decides.
So just so we're clear, there's an A, B, and then there's an A, B, C, D. So you're saying,
Yeah.
Okay, so I was just saying.
Yeah, it's,
Okay.
I'm going to leave it.
Okay.
I'm going to leave it. All right, any others? Can I polish this one and get rid of a child and all that stuff?
Of course,
Yes,
of course.
yes.
Okay.
And I think, Judge, also, we would object to my page 25, but it's after that D. where it says a person who unlawfully and by force enters or attempts to enter another's vehicle is presumed to be doing so with the intent to commit an unlawful act involving a force of violence. And then it also goes on to define dwelling, resident, vehicle.
Yeah, but again, D above it covers it.
Okay, but can we take out dwelling and resident?
Yeah, I'm gonna
Okay.
clean, obviously neither one of those are applicable. Like I said, I'll polish it up, but I would leave the paragraph right above dwelling, which is the one you're asking to be taken out. I would take out dwelling, residence, that's it, vehicle applies. That's it.
Yes. Sure.
Okay. All right. We'll take a few minutes and then we'll have the jury in. Yes?
Yes, sir.
Okay. We'll be in recess for, let's say about 10 minutes. What page?
It is on my page 29. It's right before 3-7, plea of not guilty.
I'm not gonna do any of that. We went by the other.
No. It's right above that, and it says the discharge.
29?
It's on my page 26, but it's the 2 lines right above 3.7, plea of not guilty. It's above those, and it says the discharge of a firearm, whether accidental or not, has been deemed to be the use of deadly force as a matter of law. That's not in the standard jury instructions. It's actually an instruction in there to the judge, just describing it, but it's not an actual standard jury instruction, I don't believe. Am I wrong, Mr. Wood? But is it, I thought it was, when I read it, it was not actual standard instruction, it was just an instruction to the court. 3.6F? 6F.
You said that is not in the standard?
I don't see it in the standard. I know it's in here, like for, yeah, it's here, but it's not a standard jury instruction, Judge. It's a, it looks like an instruction to the court. If you look on page, looks like page 6
I just printed, I just looking at the,
right, if you look at page 6 of 7 on the standard jury instructions.
okay, where? Under aggressor?
Can I put it up and show you, Judge? Might be easier.
It might be easier because I don't see it.
It's the paragraph right before 3.7.
Paragraph above 3.1?
It's right here, Judge.
Oh, it's right by the comments.
Yeah, it's a comment section is what it is right here, if you see. I highlighted it for you.
Oh, each one has his own. Okay, here we go. I got it.
I don't think it's a standard instruction. It shouldn't be given, Judge.
But it is a correct statement of the law.
Okay, make your argument again.
It's not part of the standard jury instructions, Judge. It's just a note to the court. I don't think there's any conflict that using a deadly weapon was deadly force. I mean, using the gun was deadly force in this case, so I don't think we need to put it in there. It says if there's a conflict, you would, I guess, maybe address that.
What is 3.6G?
Let me look. I'm not sure. I think that's going to be justifiable use of non-deadly force. Yes, that's what it is, Judge.
You said this creates a conflict with what I've given?
I didn't say it's a conflict. It's just not a standard instruction, Judge.
I'll leave it.
Okay.
Okay. I'll leave it as is. All right. So we'll take 10 minutes, okay? All right. Ready for the jury? Oh, I'm sorry, we wanted to address one last issue with the jury instruction.
Yes, sir. I emailed that to you, and when did you receive that? Okay.
Okay, and then the discussion was that the 3.6F, there's the addition to the definition of carrying a concealed firearm, the elements of that, and second paragraph below that one. Okay, thank you very much.
Just get that podium back, or are we just gonna wander?
I took it out for a reason. I prefer you stay close. I'll bring the little podium back, but that microphone has to be very close to you. Okay?
Yes, sir.
I'll go get it. Can you tap on the microphone right there in front of you? Yeah. Yeah, thank you. Don't touch it with your hands anymore. Mike, come here. Should we go around over here? Oh, you right there. See that camera? Right there. Yep. Start sitting in the door, facing out that way. Yeah. A little more. A little more. A little more. Okay, come back a little bit. This way. Good. Right there. Thank you. All right, that's it. That's it. At the podium? Ready for the jury? Yes. Huh? Okay. Are you going to be using the TV or no?
Yes, Judge. I'll grab the jury.
Okay. Okay. Huh? Yeah, that's okay. Bring the jury in. All rise for the jury. You may be seated. Ladies and gentlemen, both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the lawyers say is not evidence or your instructions on the law. However, do listen closely to their arguments as they are intended to aid you in understanding the case. Now, each side will have equal time but the state is entitled to divide their time between an opening argument and a rebuttal argument after the defense is given its closing. At times, the attorneys will refer to what they believe the laws that will be given to you and instructed. You will be instructed on those laws, but I will be giving you a copy of the law tomorrow. You'll have your own personal copy of the law.
Eric, can we come sidebar very quickly?
Yeah. Go ahead. State, you may give your closing. I'm sorry. You good? You may proceed. Cable came loose. It's the same. There it is. It came back. Let me just get rid of that. Make sure you speak up loud.
I will, Your Honor. Good afternoon, ladies and gentlemen. Late afternoon. I want to thank you for the time and attention that you've given this matter and this case this week. Believe it or not, lawyers watch jurors, and we watch you, and you've all been paying very close attention to everything you've received, and you've received a lot of evidence over the last 4 days. And as you've seen, in real life, a murder of a human being is much different than people imagine, much different than you see on TV. In real life, up close, the murder of a human being is raw. It is emotional. It has a great sense of finality to it. Now, the evidence you've received, and I'm going to talk about that evidence quite a bit, but first I want to talk to you about something that you all were asking some questions about last week. Last week, remember, during jury selection, we did talk to you in that vacuum where we could not talk to you about what the actual law is. And I agree with the judge. His instructions are the instructions to follow. If there's anything different in mind, follow his instructions. But I want to go through some of those instructions with you now, and then talk about how the law fits those instructions and how the state has proven the charges in this case, beyond a reasonable doubt. There is only one count you're considering. And again, you're going to get these jury instructions from Judge Zambrano. At the very top, when it's discussing count one, before going into the elements of count one. And that's an important word I want to talk about, elements of count one. For every charge in Florida, every criminal offense is made up of certain elements. It might be 2 elements, 3 elements, 4 elements, and the state has to prove each and every element. But it gives you guidance of how we prove the charge. Before getting to the elements, the instructions are going to tell you there are 2 ways you guys already know this from last week, that someone can be convicted of first-degree murder. That premeditated murder we talked about last week, and a felony murder, both of a law enforcement officer. So there's two ways we can prove first-degree murder of a law enforcement officer. We can prove it by proving premeditated and felony murder. The instructions you need to understand are long. There's nothing we can do about that. They are also very repetitive. And at times, they'll seem a little out of order. And this is one of those examples, because the verdict instruction is way at the end, almost at the very end of the jury instruction packet that you were going to get. But this instruction tells you, I'll have to read it from my laptop, that if you return a verdict of guilty to the charge of first-degree murder of a law enforcement officer, it's not necessary that you all agree the state proved first-degree premeditated murder of a law enforcement officer, and it's not necessary that you all agree the state approved first-degree felony murder of a law enforcement officer. So what that means, at the top, you've got first-degree murder, law enforcement officer. There are two theories the state can prove. And again, from last week, felony murder of a law enforcement officer, premeditated murder of a law enforcement officer. As long as you all agree we've proven one or the other, the appropriate verdict is guilty of first-degree murder. So all 12 of you could believe we proved both of them, which I submit to you the evidence has. But 9 of you could say, well, I think the state's proved premeditated murder. 3 of you could say, I think the state's proved felony murder. But as long as you all agree that we proved one or the other, the appropriate verdict is guilty as charged of first-degree murder of a law enforcement officer. So again, you have the two options, as long as you all agree on one of them. Here is the instruction for first-degree premeditated murder of a law enforcement officer. A few moments ago, I talked to you about elements. This is an instruction where there are 6 elements. 6 elements for the state to prove. I'm going to come back to this in a minute, but I want you guys to see what the instruction looks like first before I talk about each element. This is in the same instruction, and you're going to see jury instructions like to give you definitions for some things. So again, I'm going to come back to these definitions in a minute, but the instruction on first-degree murder of a law enforcement officer, premeditated kind, defines act, defines killing with premeditation in 2 paragraphs. Not surprisingly, it defines what a law enforcement officer is. It also defines an employing agency. And again, I will come back to those in a moment. And this is an instruction you are going to see over and over and over again in these jury instructions. It's going to come at the end of first-degree premeditated murder of a law enforcement officer. It's going to come in the instruction for first-degree felony murder of a law enforcement officer. It reads, a person is not justified in using force to resist an arrest by a law enforcement officer, or to resist a law enforcement officer who is engaged in the execution of a legal duty, if the law enforcement officer is acting in good faith and he or she is known or reasonably appears to be a law enforcement officer. However, if an officer uses excessive force to make an arrest, then a person is justified in the use of reasonable force to defend himself, but only to the extent he reasonably believes such force is necessary. And I'm going to talk about this instruction more, but this is one, when I talk about repetitive, you will get it over and over again in these instructions. Now here's that other option. We talked briefly about the instruction for first-degree premeditated murder of a law enforcement officer. Here's the other one. Felony murder. 6 elements as well. And I'm going to come back to them and talk about them. And you're going to see even the elements are kind of similar between felony murder and premeditated murder. Felony murder is a long instruction. It tells you you don't need premeditation. But you do have to prove the felony. So the state has to prove the felony that we're alleging the defendant was committing when he killed Officer Raynor. So the instruction will give you the definition of that felony. As I said, you get it over and over again. Here's that instruction legal duty, and excessive force. Repetitiveness, law enforcement officer, employing agency. And I want to spend just one moment on this instruction because you will get lesser included offenses. I want you to think about lesser included offenses as kind of stairs. It's a step down. So the highest charge offense, first degree murder, law enforcement officer. A step down or a lesser included offense is first degree murder. A step down is second degree murder of a law enforcement officer. And that's what this instruction tells you. It tells you all the steps down, and then you get those definitions as well. So just to kind of explain it a little bit, I've got the first degree premeditated instruction I talked about, that I'm going to spend some time talking about. This is the proof. First degree murder of a law enforcement officer. The lesser included offense of just first degree murder. Not surprisingly, we don't have to prove that Jason Raynor was a law enforcement officer for that lesser. We don't have to prove that Othal Wallace knew that Jason Raynor was a law enforcement officer. And we don't have to prove that he was engaged in the lawful performance of a legal duty. So that's why it's a step down. Now the evidence has proven the highest offense. So let's go back to that clean instruction. I want to talk to you about these elements now. Again, this is the first option for first degree murder, the premeditated kind. These elements, a lot of them are very easy for you to look at and very easy for the state to prove. Jason Raynor is dead. Obviously, Officer Jason Raynor is dead. You heard from the medical examiner. You saw autopsy photos. There is no doubt that Officer Jason Raynor is dead. The death was caused by the criminal act of Othal Wallace. Again, overwhelming evidence to prove this element. The defendant admitted on the stand that he killed Officer Jason Raynor. It is on video, him having a conversation with Raynor and then shooting Officer Jason Raynor. when he approached it. He was so fearless that he refused to sit down over and over again. So fearless that he wouldn't even respond to the officer's comments. And so fearless that he aggressively engaged Officer Raynor when he tried to call into dispatch. That cuts against a self-defense argument. The actions after as well. His behavior after he shoots Officer Raynor also proves this was not self-defense. It just wasn't. He ran. He ran far, and he ran fast, and he tried to cover his tracks as best he could. He booked up to Jacksonville, cut across to Gainesville. After making his social media post, when he could have been calling anonymously, 911 or some way to get Officer Raynor some help, who he just left for dead behind 133 Kingston. But no, he goes all the way to Gainesville, first calls his dad's not willing to help him, then he calls his brother. His brother gives him a ride up to the Atlanta area, Snellville, Georgia. He never says anything around Ms. Bodison about self-defense. He never says anything about self-defense in his last message. What he thought was his last message to his followers, he doesn't say anything about defending himself. Behavior after shows this was not self-defense. And guess what's in the self-defense instruction one more time? This is the most important place where you will see this instruction. Same one, I'm not going to read it again. A law enforcement officer in the execution of a legal duty, in good faith, a person cannot use force unless the force is excessive, which again is not present in this case. There is no excessive force used. And I want you to remember some of the defendant's statements. One of the issues with self-defense is there another option? You know, justifiable use of deadly force needs to be the only option, essentially. And Mr. Wallace admitted over and over again on the stand about the other options he had. I could have sat down and complied. Could have sat down, but I wanted to walk away. Initially, could have sat down, yes. 0 injuries, you know, excessive force. Yes, there has to be excessive force, and there's 0 injuries. He testified to that. I had 0 injuries. I was fine. Mr. Lewis asked him, he asked you to sit in the car. Didn't listen, did you? No. And here's the biggest one. Mr. Lewis asked him, all you had to do to defuse the situation was listen to his commands. And the defendant's response was yes. And that should have been the end of this. It should not have ended with Officer Raynor having a bullet in his head and his life taken from him. Because Mr. Wallace didn't want to listen to a pig's commands. Because he told his followers, when they come, I'm not backing down. And he didn't. And Officer Raynor is dead for that reason. Ladies and gentlemen, Othal Wallace was going to murder a law enforcement officer. It was a matter of where, when, and who he would kill. Tragically, the where was Daytona Beach, the when was June 23rd of 2021, and the who was an officer who was patrolling an area doing his job. And because the evidence is overwhelming, I ask that you use your common sense, follow the law as instructed by the judge, and if you do so, the appropriate verdict is to find Mr. Wallace guilty as charged of first-degree murder of a law enforcement officer. Thank you for your time.
Thank you. We're going to take a restroom break, about 10 minutes.
All rise for jury.
seated.
Are we ready for the jury? All right, bring the jury in, please.
Yes.
All rise for the jury.
The jury is present. You may be seated. Defense, you're closing. Court is pleased.
Members of the jury, good evening. If there's one thing that I think we can all agree about, it's that this has been a very long and stressful couple of weeks. And this morning, when I was leaving my house, my wife gave me a cup of coffee and she said, I know that this is going to be a long and stressful day. I read your mind. I was thinking about that on the drive to the courthouse, and it really underscored what this case comes down to, which is that the state of Florida wants you to read Othal Wallace's mind. The government has summoned you here today to deliberate on the most serious accusation that we can lodge on another one of our citizens. And with your deliberations comes the responsibility to fairly consider all of the evidence, all of the testimony. And in doing so, you have to be convinced that the state of Florida has met its high and heavy burden to convince you beyond a reasonable doubt that Mr. Wallace is guilty. And the state has not met its burden. The state of Florida has to prove either that Mr. Wallace, in a premeditated fashion, killed Mr. Raynor, or that he was committing the felony of resisting with violence at the time, and that caused his death. And in doing so, the state has relied on what I would categorize on an alphabet soup of information to you. They presented a day of testimony on Monday, essentially about an email that Jason Raynor may have considered, that he may have opened, that he possibly relied on. The other day we heard the state of Florida wants you to read Mr. Wallace's mind. It would have you believe that when Mr. Wallace came home after visiting his children, that he was sitting there with such hatred and malice in his mind that he was ready to essentially execute a police officer steps from where he would lay his head. And in reaching your determination, you need to make an individual assessment. Each and every one of you needs to make an individual assessment about whether the state has met its burden, about whether the state has ignored or oversimplified or completely disregarded what's at issue in this case. The state is asking you to read his mind. and in participating in a fair and full deliberation of what actually matters in this case. I believe that the law requires you to consider how Mr. Raynor's actions affected Mr. Wallace's state of mind. We heard all of this testimony from the medical examiner, from the FDLE agents, from the ATF agents in Georgia, and all of these guns and everything. Is that a distraction from the heart of the issue here? Is that a distraction from the state of mind that your government must prove to you beyond a reasonable doubt existed? Why would the state spend so much time on presenting you evidence that does not get to the heart of the matter? Try to impress you with the fancy badges and the titles and the credentials? Distract you from the fact that if you look at the video, you will have to ignore the fact that Jason Raynor was not acting on any suspicion. He was just in there on a whim. Mr. Wallace was not doing anything wrong. Mr. Wallace didn't come up to Mr. Raynor and put his hands on him and ask him a question at first and get in his face and push him back into his vehicle. That's how this encounter started. So instead of embracing that and diving in with every witness on the video and presenting to you evidence of peace of mind, they presented you this alphabet soup of FBI and ATF and the Georgia police and the officer Toluta that came in here and gave you redundant testimony about what my client's girlfriend said when she was presented with the fact that Othal Wallace was on the body camera. Members of the jury, if Jason Raynor was acting lawfully, then we rightfully concede, as the law allows, that he had the ability to detain Mr. Wallace. And Mr. Wallace doesn't want to distract you from the issues. He doesn't want to put up a dog and pony show over here and try to impress you. He acknowledges the fact that law enforcement officers have a difficult job. They have a dangerous job. That there's considerable leeway given to them when they have to make these on-the-scene decisions. And lawfulness can mean that you can get it wrong. You can be in good faith pursuing a vehicle that looks close, pursuing a suspect that looks similar, looking into a circumstance that looks suspicious, but ultimately it turns out to be unfounded. So the question before you is the reasonableness of the actions. Are you acting in good faith? So when the state of Florida is presenting its case to you throughout this week, and even the remarks of the government prosecutor, they're saying, here's a possible explanation. It could have been this. It could have been that. The state wants you to read my client's mind, but they're not presenting any evidence to the heart of the matter. There's only 3 elements that are in dispute. I disagree with the government that we have conceded that death was caused by the criminal act of Othal Wallace. There was no criminal act. It was self-defense. It was not premeditated. Mr. Raynor was not engaged in his lawful duty. Now, certainly there are many ways that a person can come to this reading of one's mind. It could be your intimate partner. You're with that person every day. You can finish each other's sentences, give them coffee when they need it, or a 30-second video. So the state wants you to read Othal Wallace's mind in a 30-second video. Now, there's certain things that you could watch in a 30-second video depiction of a law enforcement officer, and it would not be very hard to discern the majority of what's going on in that officer's mind. Video of an officer writing a speeding ticket, running radar, walking someone to the courthouse with handcuffs. But in this video, we don't see any of those consistent activities with police functions. It's very convenient that the state ignores to you in their presentation the fact that Mr. Bedard previously testified that Officer Raynor's actions were not consistent with the way one approaches a high-risk vehicle. He quarreled with me about that, and then I had to remind him with his sworn deposition testimony, or just a month ago, where he stated just that. He stated, this is not consistent with the way that an officer would approach a high-risk vehicle. So you have to ask yourself, does Officer Raynor's actions on the video undermine premeditation? Does it undermine lawful duty? And a fair deliberation in this case requires you internally and amongst one another to take into consideration that Mr. Wallace is in fact permitted to using even deadly force against a law enforcement officer. And again, it's very convenient in the way that the state is trying to ignore the fact and suggest to you that under no circumstance can an individual use any type of force against a law enforcement officer. Well, when Judge Zambrano instructs you on the law, the opposite is true. That the state of Florida needs to show to you that there was in good faith, that there was a lawful duty that was being performed. And if those things aren't happening, and Mr. Wallace is in a position where he reasonably feels for his life, then he can in fact use reasonable force. And if Mr. Wallace reasonably believed that the force was excessive, then he can use the amount of force that he reasonably feels is necessary. And let's talk a little bit about that. The state's evidence is inconsistent with premeditation. What's confusing to me, and what I hope is confusing to each and every...
Jake's confusing to him. I think that's the proper argument.
Okay. Overall, go ahead.
Mr. Jury, what's confusing about the state's evidence in the state's case is the fact that they want you to ignore, completely ignore and disregard that Mr. Raynor was wrong about the stolen vehicle. He was wrong about the stolen vehicle. So if he's wrong about the stolen vehicle, and Mr. Wallace is not doing anything wrong in his car, then how does Mr. Wallace feel when he's sitting in there doing nothing wrong after visiting his kids, getting out of his vehicle, about to go inside, and he's abruptly met with a light in his face and a person blocking his only escape from his vehicle? How is that not a factor in a human being's state of mind? The essence of humanity, something that we can all share, about that fight or flight mentality when you're presented with something startling, when you're backed into a corner and your blood pressure raises and you get stressed out and you start to stress and you can't think clearly. The state would have you just ignore all of that because Jason Raynor wore a uniform. And then he walked up to somebody. The state wants you to disregard the fact that we live in the United States of America and you do not have to just submit on a whim to an officer's commands or directives. The decision must be present in the mind at the time of the killing. Must allow enough reflection. When Mr. Wallace is sitting in his car not doing anything wrong, and he has Mr. Raynor's hands on him for the entirety of the encounter, pulling him, grabbing him, eventually choking him with the back of his collar. Is it reasonable for you to believe that in his mind he's thinking, oh, this is the opportunity I've been waiting for? I'm plotting the execution of this pig? Or is the real human circumstance a person who is surprised, caught off guard, and then in a defensive posture and reacting to the provocation that they did not deserve? That's what's shown in the video, members of the jury. What's shown in the video is a man that's not acting consistent with this radicalized cop killer that the state of Florida would have you believe that Mr. Wallace is. Is Mr. Wallace's salutation of sir? He calls him sir. This man who the state claims has been lying in wait to execute a police officer at his doorstep calls him sir. Asks a basic question. How is that premeditation? How is that a premeditated intent to kill when you arguably address the object of your ire with a formal salutation? If you find the state's evidence inadequate and inconsistent on whether Mr. Raynor was acting lawfully and in good faith, then how can he be guilty at all? They would have you believe that the conversation ends because Othal Wallace answered Mr. Lewis's screaming match to him and said, "Oh, well, all you had to do to end the situation was to sit down. Just comply." Has the state of Florida presented to you a credible amount of evidence? Look at all the evidence. Mr. Wallace is literally on trial for his life, and he embraces all of the evidence in the case, and he encourages every single one of you.
The objection he's talking about, the defendant encourages him. That's improper.
Overruled.
Mr. Wallace, the person that's on trial here, the human being for whom you have been summoned to consider whether he is guilty of a heinous crime, wants you to look at all of the evidence in the case. And when you look at all of the evidence in the case, among it you will not find any consistent narrative which shows that Mr. Wallace did not have the right to walk away from that encounter. He had every right to walk away from that encounter. As much as the state of Florida would like you to look away and think about all of the fancy apprehension and the crime mapping and the FDLE labs, which show nothing about the disputed issues here. We don't contest that my client's DNA is on the gun or on the shell casing or Mr. Raynor's DNA is on the hat. None of that matters. None of it. All you had to do was sit down. He doesn't have to sit down. He has the right to walk away because he's not doing anything wrong. So if in your mind you're not doing anything wrong and you have the right to walk away, what is going through Othal Wallace's mind when a light's shown in his face? When somebody abruptly comes and blocks his only escape? When somebody puts his hand on him? What's going through his mind? The way the state has presented this case, you would think that the roles were reversed. And that the culmination of the video was the result of Othal Wallace coming up with an erroneous suspicion, quickly approaching the side, grabbing, twisting, not answering basic, humane, courteous questions. Mr. Wallace acted in response to these actions of Mr. Raynor. How have they shown premeditation? So, what is the state of Mr. Wallace's mind when Mr. Raynor is performing a barrage of actions on him? Is the state's evidence in this case eliminated a self-defense claim? Because it's the state of Florida's burden to prove that the evidence that it has presented to you overcomes his claim of self-defense. What are the circumstances of the killing and the conduct of the accused? Now, look at the social media evidence, members of the jury. Mr. Wallace didn't deny that. He testified to you that he regrets that. It's an absolutely stupid way, an unproductive way to communicate frustrations about what was going on in the world. And it's very unfortunate that you are now tasked with reviewing that evidence in light of what happened on the video. And we acknowledge that. Now, what's interesting about the social media evidence and the way that it was presented is it's consistent with what I've been discussing this entire time. This look over here about all of the elements that aren't in dispute, and we'll pile on all this evidence, and then maybe that will be enough to get to what actually matters. So the state of Florida would have you believe that you are able to read Mr. Wallace's mind with, what was it, 3 social media posts. We heard testimony, members of the jury, of tens of thousands of pages of social media. And the state of Florida, who has the burden in this case, brings the charges, investigates. We heard all about this big investigation, coming down to the moment of truth. We're in the arena, and they give you 3 posts, 3 social media activities of my client a few weeks before. Is that the full picture? Similarly, members of the jury, I'd like you to consider the fact that when you are taking all of the evidence back with you, the state of Florida has similarly cherry-picked just a few still shots of the slowed-down enhanced video. When you look at the defense exhibit, you're going to get a zip drive with about 150 of them on there. And I'd like you to look at every single one of them. Because what the state of Florida dodged around and didn't have any witnesses talk about or discuss the appropriateness of was the horse collar, or the grabbing, or the twisting. Sir, he's not yelling at the cop. He doesn't come up and say pig. He doesn't have his gun waiting on his lap, waiting for the opportunity to execute a police officer. How is that consistent with someone who is so maligned towards an officer weeks before? It's not. It is absolutely inconsistent. The social media in this case also, at least the way that it's presented, completely ignores the context. Completely ignores it. Now, members of the jury, again, Mr. Wallace's testimony and my sentiments on his behalf in no way condone the violent rhetoric expressed in this social media. It's not productive. It's counterproductive. But there is a vast distinction in a person who looks like Mr. Wallace, who's lived his entire life in a high-crime area, and who is observing people who look like him when they're engaged with a law enforcement officer, doing something wrong or not, and wind up dead. When Detective Smith took the stand and I asked him about that, he almost seemed contemptuous that I would even suggest that there was some context to this. So you have to ask yourself, is his righteous indignation justified? Yes, absolutely. I think if you're a fair-minded, non-prejudicial person with common sense, you can agree that it is absolutely unacceptable about some of the things that are still happening, that have happened for hundreds of years, that Mr. Wallace carries with him through his heritage.
Sustained.
And to not even give that any context or credence? Similarly is the way the investigation unfolds. One day later, on June 24th, Mr. Wallace is charged with attempted first-degree murder. One day later. You know, Detective Donardi almost seemed surprised that he was questioned so aggressively on, was there ever any consideration about why Mr. Raynor came up to him? No. There was no mention of the stolen vehicle in the report. There was no mention of cannabis. The cannabis didn't come until they paid Roy Bedard to come in here and tell you about it. So has the state really proven beyond a reasonable doubt the significance of that social media? Or have they made a presentation to you in a light that is most favorably to their narrative but is a distraction between the actual state of Mr. Wallace's mind. And I would suggest to you, members of the jury, that the high and heavy burden which you must deliberate has been met is not met by 3 out of 5,000 social media posts. I understand their tone, I understand the tenor, they're disgusting, they're vile, and you need to consider them. But when you consider them with context, you consider them in light of what was going on in Mr. Wallace's mind, and you consider them in light of how he's acting in the initial exchange on the video, and how he only reacts, they have improved the state of mind. Mr. Wallace was not committing a felony at the time that Mr. Raynor died. None of the other elements are in dispute. It comes down to whether Mr. Raynor was acting lawfully. And they have to prove, beyond a reasonable doubt, not probably, not, okay, remember, here's 4 or 5 things that probably were going on at the time to prove lawfulness. You probably got the email. There's probably a joint in his hand. There's probably a lot of crime. Did you see any crime statistics? Did you see any data from that? Or did you just hear people talk about it? One of the people that you heard talk about it was Amanda Dickens. And Judge Zambrano was going to instruct you, when you're weighing all of the evidence in the case, from all of the witnesses, that there are some rules that you should apply. And Mr. Wallace encourages you to do so. And one of the things is, does the witness have an interest in the way that the case will turn out? And I would suggest to you that every single law enforcement officer in this trial has an interest in the way that this case comes out.
You know, I don't want to object to relevance of that.
Members of the jury, what I'm talking about is the law that the judge will instruct you on. Nothing else. I'm talking to you about the law, and what you're going to hear is the law says that you can consider whether a person has an interest in the way that the case unfolds. And one of the other items for deliberation is whether a person has made an inconsistent statement at a previous time. Well, we heard from Amanda Dickens. First of all, she allegedly has this conversation with Mr. Raynor a few minutes, really, before everything unfolds. And I'm not trying to pull wool over your eyes or make light of the situation or anything like that, but I would say it is absolutely reasonable and within common sense, even during a time of trauma, that a law enforcement officer would express some semblance of that information to someone that night, or the day after, or the week after, or the month after, or 6 months after, or a year after. However, Amanda Dickens doesn't do that. As we're approaching trial, then the epiphany from above comes and says, he said he was going to go on vehicle. Well, members of the jury, what's before you for consideration is a video of what Amanda testified to be her first recollection. The story was, I came to a trial to search her, and when I was done with that, he said, all right, I'm going to go look for that stolen vehicle. In a few moments, I want you to look at that video, because there's not a in between the two. So how much credibility is there? I'm not saying any of that. There's a lot of person can provide testimony that's not. The state of Florida's burden true, then you can disregard. Flat out, it's not credible. Think what is there. An initial response by the police trying to apprehend and identify this person. I'm not suggesting otherwise. We're suggesting in the checks and balance in the system that we have is you are the deliberators of the facts in this case. Was there a rush to judgment? For the ultimate charge in this case before I would contend that if you look at the by the common sense. I mean, this is something that I understand another chance to come and talk to you. Reality is believe a lot of cops. What better opportunity for him to be in the higher ground, heavily armed, that Mr. Wallace was aggressive, hostile, fired a shot, resisted with violence. In fact, the testimony was to the contrary. Officer Salcedo from Georgia testified that he was compliant, that he was cooperative, that he went peacefully. Mind that the how was Mr. Wallace's mindset affected by Jason Raynor's actions? And that wouldn't be an issue in dispute. Proactive initiated this. So how do we read Jason Raynor's mind? Well, 30 additional seconds of video from the state's presentation to you is a complete miss. 3 seconds. Don't. So how do we read Jason Raynor's mind? Well, 30 additional seconds of video would help. Now, what's amusing from the state's presentation to you is a complete missing of the mark of the importance of the 30 seconds. We agree. Don't deliberate this. The video is the entirety of the encounter between Mr. Raynor and Mr. Wallace. Agreed, end of story.
You deliberate what you want to deliberate, folks.
I agree with that 100%. If you don't have to believe anything that I say, you don't have to believe anything that the government has to say. What we say is not evidence. But members of the jury, I stand before you about the words that I expressed to you, and I will say that what I am submitting to you is backed up by the evidence in this case. And the significance of the 30 seconds of videos, it does give some insight into, at least on June 23rd, 2021, the practice of Jason Raynor. And that was after the 4 calls that he had that night, every single time he put his camera into sleep mode. Every time. You're going to have the audit trail. It's about 25 pages long. It's amongst the many exhibits that you have to look through and look at that. And the expert, the Axon expert, came in and told you just that this was a deliberate pressing of a series of buttons that hindered the 30-second look back. Again, we don't have to prove anything, and I'm not suggesting that this was some calculated thing or an accident or maybe there was privacy. If you find that cause, it's the state of Florida's burden to prove otherwise. But the fact of the matter is, On 4 occasions that evening, Jason Raynor put his camera into sleep mode. And what we also heard from multiple law enforcement officers who were with the Daytona Beach Police Department is that the policy is you keep your body-worn camera on and you really only put it into sleep mode when it's privacy or power failure. And when you look at the Axon trail, you're going to see that Mr. Raynor's body-worn camera was at 90%. So the point of the 30 seconds of video is, what did he see? What did he see in those 30 seconds? The guy that the state paid to come up here and give you his testimony couldn't point out a single thing. He's traveling around the world testifying 300 days a year. He's the preeminent expert in law enforcement tactics, and he tells you, I don't see anything criminal in the video from the first initiation. So, would the 30 seconds help you? What did he see coming around the corner? I would argue to you he saw nothing. He saw nothing, which further bolsters our claim that Mr. Wallace was doing nothing wrong. So how do we read Jason's mind? Well, we can look at the video. We can look at the video and assess his actions in the video. And I gave an example a few moments ago about some things that you readily come to mind if you saw a 30-second video. Writing a ticket, running radar, putting handcuffs on someone. You can read a lot of an officer's mind by just that 30-second video. But again, it seems like the state of Florida was in a different trial when they presented to you all of this weight on Roy Bedard, yet he gets caught in his own words, standing right here a few hours ago, saying, yeah, I said that. I said that is not how we approach a high-risk vehicle. That's what he said. And that's what's on the video. So the state, let's break this down here, okay? This vehicle is evading the entirety of the Volusia County law enforcement for the week. Because when you look at the Volusia Crime Bulletin, it goes out on 6/21. So on 6/21, up in Ormond Beach, there is this stolen vehicle report. And then 2 days later on 6/23, it's still out there and it hits a license plate reader in the area. And what is uncontroverted in this case is that a stolen vehicle is a high-risk vehicle. And if we move forward, we heard testimony, we saw pictures, we heard about the felony stop that happened as to the actual vehicle, which involved multiple officers, guns drawn, and a tactical approach. You see none of that in the video, members of the jury. What's uncontroverted is that there was not a 911 call complaining about Mr. Wallace. There was not a dispatch to 133 calling about something else. He wasn't flagged down. So you can eliminate from any reasonable consideration that any of those things prompted his response to 133. So then you consider the vehicle. And again, we go back to, we agree. If a law enforcement officer is acting reasonably, then he can get it wrong. And we're going to give them leeway. We understand that. But with great power comes great responsibility. It's not that hard to look at the side of the vehicle and determine that the lights look different. That there's differences to the top of the roof. That there's no door handles. Members of the jury, I am not putting a burden on Mr. Raynor that he needed to be Superman or have any superhuman powers. All I'm asking you to do is consider what's on the video in light of reasonable law enforcement actions. And what we heard from Mr. Bedard, what we heard from Detective Denardi, what we heard in sum from all of the law enforcement officers, is that your powers of observation are what you hone. Those are the tools of your trade. You sharpen your sword. So you should be more perceptive. And it's unreasonable to suggest that on the longest day of the year, when there's still some light in the sky, and I agree, there's not a lot of artificial light back there, but he has a flashlight. He didn't one time look to the passenger side of the vehicle. Perhaps if we would have had that 30-second video, we could either prove or disprove the fact that he pulled up on his computer that email that he may or may not have considered and compared it with the vehicle that he was coming upon. How is that an unreasonable call for action? It's not. There's no backup. There's no call for, how hard would it have been to call dispatch and say, do you have any more information? Have you seen it anywhere lately? So instead, the state would have you believe, inconsistent with its own expert witness, that that's one of the possibilities here. That he was approaching this high-risk vehicle in a parking lot without announcing his location, without any backup, and going immediately to the driver's side of Mr. Wallace's vehicle and restricting his free liberty. Immediately. So what's going on in Officer Raynor's mind in that point in time? What is Othal Wallace's state of mind when he has the right to be free from unreasonable intrusions into his liberty? And all of a sudden there's a flashlight in his face, and a person at his door, and a hand on his shoulder, and then another hand on his arm. And then when he tries to walk away 3 times, he's yoked and tussled with. How does that affect Mr. Wallace's mind? Are those actions reasonable? You can walk away if you're not doing anything wrong. Why does the state of Florida want you to so steadfastly ignore that fact? Because in order for you to convict Mr. Wallace, the state wants you to believe that any time a law enforcement officer comes up to you for any reason and gives you a command,
Counsel, observe the golden rule, please.
wants you to believe that it's entirely appropriate in the United States of America in 2021 for a sworn law enforcement officer to come up upon somebody just because they want to and ask questions upon them and makes demands of them and put their hands on them. And there's nothing wrong with that, and you should just comply.
Counsel, observe the golden rule, please.
And that Othal Wallace should have just complied. That he should have just complied. Because, why? He wasn't in a stolen vehicle. Nobody called 911 on him. Nobody flagged him down. You don't see him doing any crimes in the video that we've looked at. Nothing. But he should just comply and sit down because he's in a high crime area. So your government argues that if Othal Wallace has the audacity to find himself in a high crime area, that he is immediately subject to inquiries about his address and his activities. And that's acceptable. That's lawful. That's reasonable. That's good faith. How has the state of Florida proven to you beyond a reasonable doubt that Othal Wallace didn't have the right to walk away? He tried to do it 3 times. 3 times. Bedard finally reluctantly agreed that. Donardi agreed that. Bedard agreed that he would not instruct his law enforcement students to detain a person if they weren't doing anything wrong. Oh, it must have been the cannabis. This is another side. We'll get to the cannabis in a moment, but this is obviously from the rear. But this is a very good representation of the vantage point that Mr. Raynor would have had when he came across the vehicle. And as we saw on the slide before, the lights are different. The lights extend into an area that was easily and instantaneously observable by Jason Raynor. It was so dark out there. I mean, the state of Florida would have you believe that you needed light vision goggles to see 1 inch in front of your face. I mean, you could see this, you could see this, and you could see this. And then you ask yourself, what evidence has the party with the burden in the case presented you to show what efforts Jason Raynor took to dispel that this vehicle was one and the same with the one in the crime bulletin? Where's the evidence? I challenge you, members of the jury, to look to every single piece of evidence in this case, and you will not find a shred of it. What you will find, which is very convenient from this theory that, he's smoking a joint that he rolled with white rolling papers here. It's a Swisher Sweet. It's a Swisher Sweet. How is this isn't, probably, members of the jury, this isn't horseshoes and hand grenades here where you get close and you score a point. This is beyond a reasonable doubt to prove that he should be convicted of first-degree premeditated murder on a law enforcement officer. And the state wants you to disregard the fact that there's a brown cigar wrapper in here and a brown tip of a cigar in his hand. Do you see any smoke in the pictures? Do you see any embers in the vehicle? Do you see any cannabis? Did you hear one single law enforcement officer come and say, "Oh, you know what? We found all of this weed in the car. There was obviously he was smoking." No, he didn't. No, he didn't. That's the quality and substance of the evidence that you would need to say he was smoking cannabis in the car. But you don't have that. You have, again, a jump to conclusions. Here's a theory for you to consider, members of the jury. It's common sense. Okay? The state would have you believe that after he fulfilled his desire of killing a police officer, he stopped and bought some Swisher Sweets after the fact, on his way out of town. So if the basis of Mr. Wallace being detained is merely him sitting in his car, then how are Mr. Raynor's actions in good faith? How are they in good faith? How are his actions lawful? What evidence will the state of Florida present to you or sum up in their rebuttal argument to say that a law enforcement officer's lawful duty is to come up to someone who's sitting in their car, not doing anything wrong, and instantly detain them and refuse to provide information about the reason for the detention? I'd love to hear that piece of evidence in the state's rebuttal. But what they did do was they paid Mr. Bedard $4,500 to help you look the other way, to impress you with the fact that he's traveling around the world and he knows everything about police training. Yet, when it came down to it, he admitted that Raynor's actions were not consistent with approaching a high-risk vehicle, that he did detain him and box him in. And it doesn't make a lot of sense with just common sense or police practice of de-escalation that if you're just acting proactively and trying to gain rapport amongst the community whom allegedly believes that you're, purveyors of justice, that you would instantly detain them. There was this long discussion about, well, now we've readdressed policing and we want them to be more friendly and we put them on bikes and we want them to, have better community ties. So the way that we do that is when we see a person sitting in a parking lot, you go up to them and you immediately block them in and get 4 inches from their face and shine a light in their face as well. How does that play into Mr. Wallace's state of mind? The state would like you to focus on the hour-long presentation from the FDLE analyst about the phone mapping rather than have you dive into that matter. Or maybe you should consider the hours and hours of testimony about the things that didn't matter, like that my client's DNA is on his gun that he was found with that he admitted to using, or the shell casing, or the hat. The state hasn't met its burden. They want you to believe that Mr. Wallace's mere existence in a high crime area allows law enforcement officers to just get it close enough. The car looks close. He's got something in his hands. He's probably doing something wrong. What's the baseline? What's the baseline? We want to talk about the baseline in a church on a Sunday morning. What's the baseline in an apartment parking lot at 8:50 at night? People in cars. People in cars. Close enough doesn't cut it here, members of the jury. It's beyond a reasonable doubt. Where's the taser? Did the state present the taser? The state proved beyond a reasonable doubt that there couldn't have been a reach for the taser at any point in time. You have pictures of the taser latch being undone. I mean, the question is more of, evidence integrity than anything else. I mean, they keep the most important evidence in a paper bag. They throw it in the trunk of the car and take 2 pictures and then call it a day. How's the state of Florida's presentation of this case shown that Mr. Raynor did not go for his gun? It's convenient that there's all of this evidence about what you can clearly see on the video or what's not in dispute, but the really mind of the matter comes in those seconds that you can't see in the video. That I would argue to you, Mr. Wallace's testimony was absolutely consistent with the totality of the evidence and the medical forensic evidence in this case. Mr. Raynor was taller by several inches than Mr. Wallace. The trajectory is consistent with the way that Mr. Wallace described this event happening. Anywhere, the medical examiner candidly told you 6 inches to 2 feet. That's not inconsistent with what he said happened. It's not inconsistent with them tussling and fighting. So what is going on in Mr. Wallace's mind when he has a light shown in his face, when he's not doing anything wrong? Did the state of Florida present to you some manifesto that he was drafting at that moment in time about the ways in which he could execute a peace officer? What's going through Mr. Wallace's mind when Mr. Raynor comes and blocks his free liberty, the liberty that he had every right to exercise because he was not doing anything wrong? And how did Mr. Raynor coming around and blocking that make him feel? Who initiated the encounter? The state conveniently ignores that premeditation has to be considered in light of the circumstances of the killing. If Mr. Wallace wasn't doing anything wrong, then he created no circumstance under which Mr. Raynor had the right to approach, detain him, put his hands on him, and ask him about his activities or his address.
How's it going?
Do we see any attempt in those few seconds to discern that this was or was not the stolen vehicle? No, we didn't. No, we didn't. But according to the state of Florida's theory of defense, their theory of the case, if you're in a high crime area, you just comply. You just answer the questions. You just sit down. Because when you're in a high crime area, you don't have the rights that everybody else has. Othal Wallace wasn't deserving of any scruples to determine whether he was doing anything wrong. So let's dive in a little deeper and let's consider this idea of excessiveness. I would argue to you, members of the jury, there's a vast difference between the way an officer would approach someone if they are executing a warrant on a serial killer versus somebody that's trespassing or at worst and maybe smoking a joint in his car. Oh my God. So it's a sliding scale. It's reasonableness, okay? It's reasonableness. I would argue to you that there is no credible evidence to suggest that Othal Wallace was smoking cannabis in his car. Okay? And even if he was smoking cannabis in his car, he deserved to get tussled and grabbed and pulled on and treated like that? Is it consistent with somebody knowingly engaged in criminal activity to walk towards a law enforcement officer with a joint in their hand? I would argue no. So the state would have you believe that, oh, it was the cannabis that was detained.
What's going on?
Well, you can use your common sense, rely on the video. Again, disregard everything that I have to say. But what the video unequivocally shows is that Mr. Raynor had no opportunity to view anything until he has already detained Mr. Wallace. Mr. Wallace is about to be detained in a millisecond here. Use your common sense, and by all means, listen to expert Bedard. Okay? Because he told you can't see what's going on in his hands here. So what's going on in Jason Raynor's mind? What is this element of proactivity that's existing where this community caretaker function is such that just to strike up a conversation, the best way to instill confidence would be, I'm going to go over and surprise the heck out of this guy sitting in his car. Members of the jury, there is no credible evidence to suggest that the stopping of the car, the exiting of Jason Raynor, and the walking and approaching the vehicle was founded upon anything other than a desire to make contact with somebody. And we don't know the intentions beyond that. And if the state hasn't proven to you with the substance and quality of its evidence that it was something lawful, that it was something reasonable, that it was something in good faith, then I would argue, foremost, you have to consider that in your inquiries of premeditation and unlawfulness. You should also consider it on the ultimate issue of guilt. So what evidence has the state presented to you to justify the parking, the exiting, and the walking? Because as we know, what's uncontroversial here is that Othal Wallace becomes detained at this point in time. And you can only be detained if you're doing something wrong, and there's no evidence that Othal Wallace is doing anything wrong. So rather than do any investigation or consideration into the genesis of this encounter, they'll just go ahead and charge Mr. Wallace with first-degree murder, and we'll backfill everything in later. We won't give any regard to the context of the social media posts. In fact, what would be better to do is we'll go ahead and we'll get like 20,000 pages of it, and we'll pick out the ones that look really bad. And we'll give those to you for consideration.
Improper argument, Your Honor.
Sustained.
What's going on?
Sit down. Sit.
Sir.
Can you sit down? I'll talk to you.
Why does Mr. Wallace have to sit down? What has he done? What has he done?
Don't do this.
Sit down.
Why are you asking me do I live here?
Do you live here? Yes or no?
What's going on though? Who, Charlie?
Is this a reasonable approach to instill confidence in the community? Why do you live here? Sit down. Let me grab your shirt while I'm doing so?
Objection, Your Honor. That's improper argument. Let me grab, he didn't say that.
Well, the jurors will rely on what the evidence shows you. Counsel are free to argue what they may show, but it's your decision to determine what happened here. You may proceed.
What did Othal Wallace do up until this moment to deserve a hand and a push and a grab? Absolutely nothing. Absolutely nothing. So, to be fair to both sides, you say, well, what's the context of this encounter? What's the context leading up to this? And as we've gone through in a laborious fashion in this trial, and I've also touched on it here, we're without context. We don't know. It's uncertain. There's theories that are unproven. In fact, there are theories that are, I would argue to you, objectively disproven by a fair look at the video. The state disregards the context. The state would have you look the other way. The state hasn't proven to you beyond a reasonable doubt that the social media in this case allows you to read Mr. Wallace's mind beyond a reasonable doubt. Where's the context? Members of the jury, the proactivity that caused the ire of my client enough to post these disgusting things on social media, his worst nightmare, became his reality.
Stop. Stop. Stop, man.
How is the state disproven that Othal Wallace's version of events is inconsistent with the truth? How is the state of Florida proven to you that Amanda Dickens' testimony should be relied upon? Here's the man she had this conversation with Jason Raynor about him going.
Hello. Mommy.
Hey, no yelling.
I know. Mom. I know. I just want to let her know because my boyfriend, he had a part and she said he gave me a part. But I can't talk to her because I need to go to work tomorrow. Go step your feet apart for me. I've been like, getting this job for a little bit wider, a little bit wider. My job. The only reason I'm trying to help them on now, I got to work at 8. Can we tell her now?
Yeah.
Can you please, can you do me a favor?
We're gonna talk to her.
May you just tell her to that I said to grab my boyfriend Damien and just meet me at the police station on 92. Tell her, please.
Yep.
Tell her I said just please. Oh, I'm sorry.
Okay.
There is absolutely no discussion between Mr. Raynor and Miss Dickens in that video. Again, undermining the context that the state would have you ignore. Mr. Wallace said some awful things on social media. He acknowledges that. He doesn't deny it. The state has argued in its closing and undoubtedly will argue to you again in its rebuttal presentation of all of these gross admissions that were made and, that he was trying to blame it on Instagram. Well, rely on your recollection, members of the jury. Was there a clear and fair opportunity for Mr. Wallace to answer the questions when Mr. Lewis was screaming at him and dancing around in circles in front of him? Where's the context? The Instagram audio post is an inartful dying declaration. He expressed his characterization of Raynor's actions towards him. Ultimately, has the state of Florida proven to you beyond a reasonable doubt that Mr. Wallace was unreasonable in feeling that Jason Raynor was fucking? How is the state of Florida proven to you beyond a reasonable doubt that it was unreasonable for Mr. Wallace to be on edge, to be scared? Is it unreasonable for a person, for Mr. Wallace, sitting in his car, doing nothing wrong, to have this happen to him? Is it unreasonable that in light of an innocent mind, to be yoked up by your collar like that, to be on edge, to have your heart racing, to maybe not be thinking clearly, to start to sweat, to start to have those fight or flight instincts that the human being that Othal Wallace is undoubtedly had in that moment? But the state would have you just rely on a few of 5,000 Instagram posts. So you have to ask yourself, members of the jury, where else does the evidence of premeditation come from? Does it come from the gun? Does it come from the FDLE tracking? Does it come from Roy Bedard? Does it come from the fragments or the photos or the uniform or any of the other alphabet soup ATF, FBI? No. The only evidence of premeditation comes from the social media, which again, members of the jury, you have to understand in context. The message was inartful, the message is unproductive, but it's in response to culturally significant events that are happening at the time. Culturally significant events that Othal Wallace testified were in his mind at the time that he was being yoked out of his car by a law enforcement officer. Argue that there is a complete difference in the state of mind presented in a social media post by one who looks differently than Othal Wallace in speaking about a different context to which he is inartfully articulating online. It's a completely different mindset. His indignation is justified, his method of delivery was not. But the method of delivery is different than the state of mind. What causes more of a state of mind? What sheds light more on a person's state of mind? When they're in their car, being approached, being startled in the way that they react to that? Or vapid banter on a medium for the purpose of vapid banter? At no point in time does Mr. Wallace come up in the initial encounter and be disrespectful towards Mr. Raynor. So let's rectify those two. The state of Florida's only evidence of premeditation in this case are social media posts that happened weeks prior. So to hold him guilty of premeditation based on these posts, one would have to logically assume that for weeks he harbored this hate, he harbored this malice, and finally had the opportunity to live out his intentions that he posted online. How is it reasonably possible then for a person with so much hate harboring and manifesting in their gut for so long to call the very target of these posts sir, to act calmly, to try to walk away 3 times? How is that consistent? How can the state of Florida even get close to a premeditated or murderous mindset when the best that the state of Florida can say justified this was maybe a tip, maybe marijuana, maybe a high crime area, and wants you to ignore the state of Mr. Wallace's mind when this is happening to him? Only after and in response to what Mr. Wallace was subjected to did he draw his weapon. He was responding. He was defending. Members of the jury, I submit to you that in this 30-second video, you can read Othal Wallace's mind. The pages of his mind begin with confusion, and they end with fear for his life. And while he's retreating, he perceives a threat. the threat of a law enforcement officer reaching for his waistband inches from his gun. Now, the state took a lot of time to establish this chain of custody laboriously. The gun belt got off. I took it. I put it in there, sewed it up, secured it nice and safe in this paper bag. Here's the Axon guy. We were not going to ask the Axon guy anything in our direct examination about the 30-second video, though. Not going to ask him anything about that. But what he told you was the sensor is all the way down. You have to pull the gun out. He couldn't tell you exactly how far, but you have to pull it all out. And the state of Florida made the big deal about that gun always being in the holster, never being removed from the holster. Yet 4 minutes later, on the Axon audit that you'll see, there's a signal firearm draw. How reliable is that information? Othal Wallace does not have the burden of proving that he was justified in using deadly force. Instead, the state of Florida has to prove beyond a reasonable doubt that the defendant was not justified in using deadly force. So is it unreasonable to use deadly force when, after doing nothing wrong, having a light shine in your face, being ignored when you're asking a reasonable question? Okay? There was, I think, 4 minutes of going back and forth of, well, you didn't answer him between Mr. Lewis and, well, you did answer him, you didn't answer him. Othal Wallace doesn't have to give him an answer. And if we're holding law enforcement to a high esteem, in a high position of authority, how is it unreasonable to expect an answer to a question? Hey, why are you detaining him? How can the state of Florida get close to a premeditated or murderous mindset when all of these things happened? And Mr. Wallace only acted in response. He's justified in using deadly force if he reasonably believed. Reasonable belief. All that Mr. Wallace is asking you to do is be reasonable. Is it reasonable for him to feel in fear for his life when everything that happened up to that point was excessive? It's one thing if Mr. Wallace is credibly doing something wrong. It's one thing if Mr. Wallace is a serial killer, if he has known violent tendencies, and there is a level of tactical force in response and guiding of his body, then it would absolutely be unreasonable for us to argue to you self-defense. But excessiveness and good faith and reasonableness are sliding scale common sense determinations.
Objection, Your Honor, a misstatement.
I will instruct you on the law, okay?
So any amount of force in this situation is excessive. Because if you're not doing anything wrong, you can walk away.
Try not to use the word you for them.
If Othal Wallace is not doing anything wrong, Othal Wallace can walk away. And that's exactly what he tried to do. And what's been, again, covered in all of the unimportant pieces of evidence in the case is that the state of Florida still needs to prove to you that Mr. Raynor was acting in good faith. That he was acting in good faith. That Mr. Wallace, it's irrelevant as to the status of Mr. Raynor as a law enforcement officer if he's not acting in good faith, if he's not acting lawfully, and his actions are excessive. Judge Zambrano will instruct you on the law on this matter, on the justifiable use of force. And you'll hear some discussion about the duty to retreat, and a discussion about certain scenarios in which a person is presumed to be in reasonable fear. And it's very important that you pay careful attention to that law. The judge is the authority about the law. In no way, shape, or form am I suggesting to you that if, in my banter with witnesses, that I am correct over Judge Zambrano. I would submit to you that I have done my best to accurately elicit that information, but Judge Zambrano is the authority on the law. And what I would like to help simplify it with is this, is that Othal Wallace had a gun in his pocket. We're not disputing that. It's his gun. If you want to take time to debate that element, you're welcome to. He had the gun. It's his gun. That's the murder weapon. End of story. and he had it in his pocket. And the only reason why he's at any jeopardy of having this carrying a concealed weapons situation thrust upon him and in his face is because Jason Raynor prevented him from walking inside and putting his gun away. I mean, you see Othal Wallace walking out of his car. The car door is open when Raynor first gets out. So is it unreasonable? Is it really even illegal for a person to have a gun in their pocket when they're walking from their door to their car for 10 steps, maybe? So the way that can wrinkle itself in the law in this case is the law will suggest that if he's doing something wrong, which we would submit that he's not, then a person has a duty to retreat before they use it. Mr. Wallace was trying to retreat from jump one. So we embrace that law. It doesn't change the analysis or you have to do any creative leaps to get there, because from jump one, what we believe the entirety of the evidence, not just the cherry-picked evidence, but what the entirety of the evidence shows is that Mr. Wallace intended to exit his vehicle and walk to his apartment, and he was prevented from doing so by Mr. Raynor. Initially when he got out of his car, and then he tried to get away again, and Mr. Raynor put his arm on him and pushed him a little bit, forced his way back, asked some questions, tries to get around again, and then he's met with another hand. And then he tries to walk away again. And he gets a horse collar. And then he tries to swoop under his arm again, and he sees Raynor going for his waistband. And I will comment on this, members of the jury. Mr. Wallace was nervous. He was testifying for his life today. And what he could have said is made up some story to you and said, absolutely, he drew the gun and pointed at me. He gave you his best recollection of what he remembered in the moment in time. But you have to view it in context. How is it reasonable at all for a law enforcement officer to go for his duty belt when the encounter started for no reason and the citizen walked away? How is that reasonable? It's excessive is what it is. However, if an officer uses excessive force to make an arrest, what was Othal Wallace even under arrest for? So if he's not under arrest and force is being applied, then it's not good faith. What is he under arrest for? He's not in a stolen vehicle. There's a Swisher Sweet pack in the car. Members of the jury, a fair deliberation of the facts of this case requires a number of things. And I would say that among the most important of them are that you listen to one another and respect the deliberative process. Each and every one of you has to make an individualized moral assessment about what the state of Florida has proven in this case. And in doing so, you should internally consider all of the evidence and debate amongst yourselves. And a full and fair deliberation of the matters in this case requires consideration of the heavy, heavy burden that the state of Florida carries in attempting to get a conviction. And I would ask you, because of the heavy burden, the state gets to have the final word in this case. Certainly as a criminal defense attorney, I'd lobby to change the law if I could, but we accept that that is the case. And it should be that way, frankly, because the state of Florida has the burden. But I would encourage you to consider, when Mr. Larissa gives his closing remarks to you, to in the deliberative process, consider what would Mr. Shoemaker say to that point? What would Mr. Probisco say to that? How do we think that Mr. Wallace would respond to that? That would be a fair deliberation. And what's interesting about the law, as it applies to reasonable doubt, is that the state uses, the law is that you have to have an abiding conviction, of guilt. As you can probably discern from all of the procedure and all of the formalities, that the words matter. We take a lot of time to arrive at the words that we're using in the law that the judge will instruct you on. And it's interesting that the word conviction is used, because conviction, just like many words in the English language, has multiple interpretations. And it's also synonymous with the feeling, and in this context, the conviction that one would have. And we don't use conviction in the terms of, I'd really love a steak for dinner tonight. We use the term conviction when we're talking about true core beliefs. Politics, our religion, our family. What is our conviction? That is the standard here. An abiding conviction, one with which you hold to the same regard as your most deep and core values. And if you don't have that abiding conviction, Mr. Wallace is not guilty. And again, on behalf of Mr. Wallace, we would absolutely acknowledge, and we do not want part of the deliberative process to suggest in any way that law enforcement is an easy job, that it's a job that should be overlooked, it's an unnecessary job, or that any verdict that you render in this case would be a disservice to Mr. Raynor. We acknowledge that. We embrace that, and we agree that that's the case. But with great power comes great responsibility. We understand that there may be deliberations, and you are absolutely free. Again, I can't stress this enough. If something that I've said, if something that Mr. Shoemaker has said has turned you off, consider the evidence. What we're saying is not evidence to you. But if you're going down and you're thinking, well, even if Mr. Raynor was in the wrong in some way, did he deserve to die? I think that's a fair question for debate. And what I would argue to you is that the question should be posed as, was it reasonable for Jason Raynor to make Othal Wallace feel like he was going to die? On June 23rd, 2021, Othal Wallace had the right to be free from unreasonable intrusions into his privacy and into his liberty. If you determine, which I believe the evidence supports, that Mr. Wallace invaded on that right, he was not acting lawfully. If he's not acting lawfully, that has an effect on Mr. Wallace's state of mind when he is battling with someone who is unlawfully detaining him, and that affects Othal Wallace's human instinct and plays to a self-preservation state of mind, not one of premeditation. I thank you for your time, and I thank you for your consideration in this matter. And I hope that your deliberation in this case finds Mr. Wallace not guilty.
Thank you. We're going to take about a bathroom break, 10-minute break.
All rise for the jury.
Thank you. Be seated. Okay, you have the defendant? Yes, we do.
Yes.
All right. You bring the jury in.
All rise for the jury.
All right, jury is present. You may be seated. Mr. Marissa, your rebuttal.
Thank you, Your Honor. Good evening, folks. I will agree with Mr. Probisco on one thing. It's been a long day. And you know, while I get to go last, and usually that's considered an advantage by some, y'all been here a long time. I just ask you to please bear with me as I talk to you. I'm not gonna scoff. I'm not gonna make fun. I'm gonna talk to you. And all I want you to do is listen to me. And your decisions, what you decide, that's yours. You own it. Juries are to be trusted. Trusted to care. Trusted enough to be able to abide by the law as you're instructed. You're trusted to do that. So I want to point out some things to you. I'm not trying to tell you what to think or what your decision should be, but I want to make sure you understand certain things. And the first thing I want to say is, I was wondering for a while which trial we were in. Was Othal Wallace on trial, or was Officer Raynor on trial? Was the state of Florida on trial? But I've been around long enough to know that defense attorneys like to blame everybody but their client. They're not going to blame their client.
Mr. Stain.
The bottom line is premeditation. I think Mr. Probisco said there's no evidence of premeditation. But folks, let me ask you about something common sense. The defendant posted that he wanted to get pig's blood on his hands and on his boots. Believe it was. He posted within 15 minutes. His own words. The defense says, can't read Othal Wallace's mind. I submit to you, you don't have to. All you got to do is listen to them posts or read those posts and listen to that message. I mean, it'd be one thing if he didn't kill Jason Raynor, if he didn't plant a bullet in his brain. But that's what he did. Why? Because his rights were violated according to the defense. So he can shoot Officer Raynor, he can take that gun, pull it out of his pocket, point it at his head and pull the trigger because his right was violated? What did Mr. Bedard say? What does the law say? The law says that you do not resist a police officer with violence. The judge is going to tell you that. And you may not like it. Some of you may say, well, what about us? What about our rights? That is why we have a courtroom. That is why the defendant gets his day in court. And you, members of the jury, are the ones who are going to decide if he's guilty or not. There's a lot of talk about Officer Raynor and that he was somehow wrong You remember Mr. Nipper, the fellow with the, I think he had a mohawk. He came in, he lived right across the street. Right across the street from those apartment complexes. How many times did he say he had, how many bullet holes did he have to repair in his house that he was renting? 9. 9. The reality of our world today is that we need police officers to help to maintain order, to protect us. There's a lot of communities that need that help and that assistance, and law enforcement responds. Is it wrong for a law enforcement officer to walk up to somebody and say, hey, how you doing? Do you live here? Is that wrong, folks? Use your common sense. What did Officer Raynor do? He asked, where do you live here? And what did he get? He didn't get an answer. Now, Mr. Probisco says he don't have to. And that's right, we don't have to do anything if we don't want to. But the law steps in. If we could do what we wanted all the time, then there'd be no consequence, there'd be no order. We would live in a world where people could do whatever they wanted at any time. And the reality of our world now is there is violence each and every day. All you have to do is turn on the TV. What do they talk about? Violence. Do you want, or excuse me, does society want a community where you're afraid to go out and walk around?
Sustain. Please abandon.
Yes, sir. Yes. I know y'all seen this video a bunch, but I want to play the video for you in real time. Mr. Lewis is going to help me with this. And then I want to show you a slow version. But before we play that video, and I know you probably are going again, but I want to kind of lay some context here. This video lasts about 42 seconds. The defendant's tires are, you can hear the gravel, you can hear it screeching out. He's leaving. 42 seconds from the time Officer Raynor says, hey, how's it going? Do you live here? Until the defendant is leaving in the car with Officer Jason Raynor, laying on the parking lot with a bullet in his head and his eye hanging out. And at 21 seconds, that's when Officer Raynor keys his mic. That's when he starts to call for backup. 21 seconds. At 24 seconds, the defendant's hand is on, Mr. Officer Raynor's hand is on the shoulders. And we'll see this in slow motion. At 28 seconds, there's a shot. So from 24 seconds to 28 seconds, 4 seconds. 4 seconds, the defendant pulls a gun, points it, and shoots Officer Raynor in the head. This talk about moving and getting underneath and pulling that gun out and trying to get away 3 times. Folks, the whole situation only lasted 48 seconds, 42 seconds. That's it. Think about this. Officer Raynor didn't know that the defendant had a gun in his pocket when he came up. And there's talk about this stolen vehicle and how, there's no evidence of that, and a marijuana cigarette. All of those things are just the state giving you the information it had. You can accept it or reject it, but you know what? It doesn't matter. Officer Raynor was trying to figure out what was going on. His right, his duty, his responsibility. He saw a car, he saw a person in it, and he did, what he did was absolutely okay, it was lawful. He was walking up, hey, how you doing? Do you live here? How was that wrong? And the defendant, how did he respond? He didn't respond. He didn't answer the question. Jason, can you key that up for me? Just play the video, just straight through.
How's it going? Do you live here?
What's going on?
Do you live here?
Why you asking? What's going on?
Sit down. Sit. Sit. Can you sit down? I'll talk to you.
Okay,
Stop.
no, come on now.
Sit.
Come on now. Don't do this.
Sit down.
Why you asking me do I
Sit
live
down.
here?
Do you live here? Yes or no?
What's going on though?
Who? Charlie 777.
No, back up.
Stop. Stop. Stop, man.
Now, I want to play it slowly, and I'm going to ask Jason to stop it every now and again so that we can, I just want you to see it. I'm going to make a few comments. You can agree with me or not. Go ahead, Jason. Okay, now stop for a minute. It's a Honda, no doubt about that, and it's gray. Keep going. The door's open, and Othal Wallace is starting to come out before Officer Raynor gets there. Keep going. Keep going. Stop. Now what I want you to do is watch what he does with the phone. Go ahead. Stop. Stop. Can you stop? Some people say, or there's some argument that was he was trying to conceal a marijuana cigarette. We don't know if it's a marijuana cigarette. What I submit to you he was doing, he's right-handed. He has a gun in his pocket. A police officer is coming up. What does he do? He takes that phone and gets it out of his right hand. He's freeing up his right hand, folks. Before there's even been a touch or anything, he frees up his hand. He takes that phone, clear as day. He moves it. What's Officer Raynor doing? He's asking him to sit. Hadn't touched him at this point. Go ahead. He touches him lightly on the shoulder. Go ahead. Now stop. Did you see that little tap? Excessive force, right? What do you think? Go ahead. Now, stop. Did it again. Stop. He's turning into it the way I see it. I mean, make up your own mind, but Othal Wallace does he look like he's afraid, folks? Does he sound like he's afraid? Does he? Or does he sound like he doesn't like what Officer Raynor is doing? Go ahead. Now, let me show you the stop again. You got, now, once you pay attention, you got one hand, one of Jason's hands on his right hand on the left shoulder of Wallace, and then his other hand with the flashlight is over there. Both of his hands are up here. Okay, go ahead. Flashlight in his left hand, right hand on the shoulder. Stop. Bad forearm happens when Officer Raynor starts calling in. Officer Raynor's got one hand on the shoulder and one hand on the mic. And what does Wallace do? create space, which I think he also said, but not, folks, I submit to you, not to try and get away. Keep going. Stop. He's turning. Keep going. Stop. He's turning towards the car, folks. Now he says that he had the gun in his pocket. Maybe did, maybe didn't. Maybe it was in that car door and he's pulling it out. I mean, it's for you to decide, but where is he trying to get away from Ray? He's going back towards the car. Go ahead, Jason. Now, yeah, it's over. That I submit to you that is Wallace standing up. Officer Raynor's falling to the ground. He's falling to the ground. He's shot. He's shot. And ultimately, he's going to die from that shot. Okay. Which we take that off. Again, I'm not going to try to tell you what to think or how to interpret this. But according to Wallace, Officer Raynor's reaching for his waist. I'm not exactly sure what that means, but Officer Raynor's got a hand here and a hand here. Wallace turns toward the car. And in 4 seconds, folks, 4 seconds, he's shot in the head. Now, how in the world is he going to reach down and go for it? He's trying to stop. He's trying to stop him from moving. He's trying to get control, sure. He doesn't know what he's got, but what he knows is when he walks up and asks, hey, how you doing? What's going on? Do you live here? Wallace gets out of the car and won't answer. It's what's going on? What's going on? As a law enforcement officer, he's trained. That's as Bedard said. That's a distraction. He's trying to distract the officer. Look, we're not saying that Wallace did anything wrong. We're saying the question is, was what Officer Raynor did reasonable under his training and circumstances? Listening to the defense, you think he was the one that pulled the gun and shot somebody. He was doing his job in a high crime area, and somehow that's wrong. Is it wrong for a police officer to go out in the community and try to engage folks, find out what they're doing, especially in a community where there's been 3 shootings in the last several days? Where there's been domestics, where there's been narcotics trafficking. Look, it's a tough world out there. Most folks never know that. They don't experience. Is it somehow wrong for a police officer to go in a community that suffers from those things and try to make it better? Isn't that what Officer Raynor was doing? Did Officer Raynor say anything? Excuse my language, but did he say, hey, motherfucker, what are you doing? Did he walk up there and threaten him? Did he have a pass in his hand? Did he have his hand on his gun? No to both of those. Did he grab him and shake him? Did he threaten him in any way? Get out, get back in the damn car, I'm going to bust you. No, he didn't. He said, sit. Get in the car, I'll talk to you. Wallace wasn't having any of that. But somehow, Officer Raynor is the bad guy. And, God forbid, that his liberty be restricted while Officer Raynor's trying to figure out what's going on with reasonable questions, I just put a bullet in his head. Othal Wallace put his phone from his right hand to his left. And then he waited until Officer Raynor had one hand here and the other hand on this mic. That's an opportunity because Officer Raynor's distracted. Not only that, I agree, yeah, he was worried about law enforcement coming. He didn't want to deal with them. He wanted to get Raynor and go. Now, Mr. Provisco has really, he's minimized those posts. And you know what, folks? At the end of the day, you can believe the defendant's story if you want. I was just so fed up with what was going on. I shouldn't have posted them. I think he even said I should have took them down, but I couldn't. Sure, he could have took them down. He never took them down. How do you, folks, how do you ignore the fact that he posted, look at those posts real quick. Yes, get them for me. Here's one. We are at war. Johnny Bolton died at the hands of a trigger-happy SWAT team. These crackers are not far from seeing the blood of their own flowing, thicken the gutters of America. How about the other one? One day I will take great pride and honor in getting me some pig's blood on my hands and boots. He did. Well, almost. He got Officer Jason Raynor's blood on his vehicle when he shot him in the head and left him for dead. Now, you can say, oh, it's just coincidence that he posted these things and then shot somebody and now claiming it's the officer's fault. If you think that's reasonable. I mean, it's up to you. You know, it's very important for you to judge credibility. The defendant took the stand, and I challenge you to judge his credibility. You saw him up there. I'm not going to regurgitate everything he said, but you heard him, you saw him. You saw how he acted. You saw how he answered questions or didn't answer questions. You know, I think Mr. Provisco was implying that law enforcement had such an interest in this case. And of course they do. You saw how it affected Officer Dickens when she had to watch and relive finding Officer Jason Raynor. Sure, they want the just and right resolution. So he implied that they would lie or that they would manufacture evidence or somehow come in here and try to pull the wool over your eyes, to use his term. But what about him? What about the defendant? Does he have an interest in this case? Does he have something to lose? Does he? According to his defense counsel, he does. Is that a reason for him to stretch the truth a little bit? Or maybe a lot? You think about it, and then you decide. You know, there's been a lot of talk about if this, then that, and that, you know, that if you find that Officer Raynor acted unlawfully, then Wallace is not guilty. Folks, that is not the law. The judge is going to explain the law to you. The reason that the law says you can't resist an arrest or resist an officer with violence You have to look no further than this case right here. Why that's true. Why that is the law. Law enforcement officers, hey, they choose to be cops. They choose to go out there and work in dangerous conditions. They do it all the time. But the law recognizes and understands that as human beings out there putting their life on the line, and listen, 42 seconds, after 28 seconds, Officer Raynor was shot in the head. 28 seconds from the time he got out of his car and walked up there. Think about that for a minute. 28 seconds to make decisions, try and figure out, what do I have here? Oh, go on and walk behind the car. Sure, while you got a man that you don't know coming out of the car, and they won't answer your questions. What's he going to do? Just say, ignore him and the officer's safety concerns and walk around to the back of the car, which he couldn't do anyway. You heard Letitia, the defendant's ex-girlfriend, say that there was bushes up there. That car was backed in. Whether Wallace did it on purpose or not, it doesn't matter. Officer Raynor couldn't see the tag. Somehow he should have, by God. He should have went and looked at that tag. Again, who's on trial here? Is it Officer Raynor or is it the defendant? 28 seconds. And he's supposed to figure out that ain't the car. 28 seconds. Now, again, you can choose not to believe that that's one of the reasons why he stopped, or you can choose to believe it. It's up to you. But is it reasonable? If the actions that Officer Raynor did consistent with that, and even if it wasn't, it doesn't matter. He has a right to walk up to a person and say, what's going on? You live here. And a defendant cannot resist with violence, period. Now, sure, if a police officer pulls out a baton and starts beating somebody for no reason, you got a right to defend yourself. What did we see here? There was 4 seconds from the time that Officer Raynor keyed his mic till he was shot. What did he do? Excessive. There's a tap on the shoulder, and there's a alleged horse collar. That's not what the defendant called it. What did he say? He was yoked, or he was trying to yoke, he was pulling. And I'm not even sure what yoke is exactly. Maybe y'all do. I don't. But that's what he said. Wallace shoved the officer. Created space. When he shoved that officer, folks, he committed a crime. Now, if he wanted to contest why the officer approached him, if he wanted to establish that the officer was wrong, that's what a courtroom is for. Otherwise, what, we're going to have folks shooting law enforcement officers because they don't agree with why they were pulled over? Or they don't agree with the reasons the officer wants to talk to them? Do we live in a society where officers can detain people for no reason? Absolutely not. And there are rules and laws in place to protect your rights. But those laws and rules, they don't give a defendant the right to pull a gun, point it at an officer, pull the trigger, shoot him in the head, leave him for dead because they didn't agree with what the officer was trying to do or the questions the officer was trying to ask. That's not the way it works. And maybe you don't like it. I don't know. Maybe you do. But that's the law. I submit to you that Officer Raynor couldn't have put his hand down towards his waist. He had one hand on his mic, one hand on the shoulder, and 4 seconds later he's shot and dead. The defendant was already moving, but where he couldn't see Officer Raynor, look at the video for yourself. The video's the best evidence. But look at it. He turned away. He was going for the gun, folks. That's exactly what he was doing, and it's exactly what he did. When did he ask to leave? Did he say, "Officer, I'm leaving. I don't want to talk to you"? Did he ever say, "I don't want to talk to you"? He talked to him. He engaged in conversation with him. What about that? Never once, not once, did he say, "Let me go." In fact, if you really look at that, analyze it yourself, but I submit to you that Wallace was in control. Raynor was trying to get control. Officer Raynor wanted to, and he was trying to do it in a polite way. Now, Mr. Probisco kind of scoffed at that. But I tell you, he was courteous and professional. And you know what? He gave the defendant benefit of the doubt. And the defendant gave him a bullet in his head. That's what happened. I thought I heard somewhere that Officer Raynor blocked in the car. Well, how did the defendant how did he get away? How did he get out and drive through? He never blocked the car in. Wallace got in it and took off. And how often is it? Well, I shouldn't say that. You are fortunate here that you have statements from the defendant that were voluntarily made. I mean, nobody was interrogating Wallace when he said he wanted pig's blood on his hands and boots. He posted that on his own and admitted it was his own words. Not like he was put in a box and questioned for 3 days before he made the statement. Folks, you should consider that, I submit to. And the other post as well. Nobody made him do it. He wanted to do it. Now again, you can believe it was just coincidence that he made those posts and 3 weeks later, Officer Raynor's dead and he shot him. You can do that if that's what you believe, if that's what your deliberations reveal. But it's one heck of a coincidence, wouldn't you agree? And how about some of the language? Pigs, crackers. Last time I checked, those aren't terms of endearment. And it's uncomfortable to be confronted with having to sit and make decisions when you've got that kind of negativity, that kind of energy. And because it makes most folks feel uncomfortable. But it made Wallace, it made him mad. He was mad and enraged over what was going on. It's clear from his posts. And again, is it coincidence that less than 3 weeks later, he kills a police officer? Off the bed? Can you play the audio, the story, I think it's called, please? I know y'all heard this one. Again, we don't need to read Wallace's mind. He's given us his mind. Can you play it?
No. I want y'all to know something, man. I love y'all. I want y'all to know something, man. I love y'all. Black power. Stay strong as a nation. Keep fucking fighting. Move fucking forward. Don't let these pussy ass pigs fuck with you. I love y'all. Black power and shit.
consider. He had just shot Officer Raynor in the head and left him for dead. Never mentioned self-defense, does it? Never says I was in fear of my life. Does it sound like he was in fear? Or does it sound like when he starts talking about don't let these pussy-ass pigs fuck with you, that he was excited about it? You decide. And I'm sorry to use that kind of language, but that's what it is. That's what he said. And folks, you can consider that. It is a window into his mind. You are fortunate to be able to have that evidence to consider. Now again, okay, he was just all pumped up with adrenaline. Folks, it was 15 minutes later. He's driving away, ultimately gonna head up to Snellville, and he says, don't let these pussy-ass pigs fuck. I think it speaks for itself. What do you think? There's no doubt he said it. He admitted it. You'll have instructions about the execution of a legal duty. See, the instructions, one part of the instructions, look, these instructions are created by lawyers, so they're not necessarily the easiest things to understand, but they're the best attempt to try and guide you. But don't ever forget your comments. Take that back there with you. And have some good, honest conversations. But there's an instruction that says under the felony murder about the resisting officer with violence, it says that Officer Raynor has to be in the lawful execution of the legal duty. But there's another instruction I want to draw your attention to, always a but. That but says that, and do we have that instruction handy, the one about cannot resist? I think I know it pretty well. That instruction says that an individual cannot resist a law enforcement officer with violence if the officer was executing a legal duty. Let me talk to you about that for a minute. Engaged in the execution of a legal duty. We know what legal duty. First off, you'll get another instruction that talks about law enforcement officers. What's their duty? To deter and detect crime. Is there any debate here that that's what Officer Raynor was doing? The defendant says he didn't know him, never met him before. There was nothing going on between those two. Officer Raynor's doing his job. He's trying to protect the folks in that community, in his jurisdiction. That, folks, is engaging in the execution of a legal duty. Understand, it says execution of a legal duty, not lawful execution of a legal duty. You don't get to attack police officers because they might make a mistake about the law. Think about this for a minute. 28 seconds into his encounter, and he's shot in the head. 28 seconds for him to process what's going on and try to apply that to the law. It's an unrealistic burden. That's why, as long as he's engaged in the execution of a legal duty, detecting crime, and he's acting in good faith. What was it that Mr. Probisco said a lot about, is that good faith, and he was implying it was bad faith. Judge for yourself, folks, but 28 seconds. What did Officer Raynor do that was bad faith? He was investigating. He wanted to know if the guy lived there. There'd been shootings in that area. Nipper had 9 bullet holes in his house. Officer Raynor didn't have to be there. That's the sad irony of this. But he took pride in his job. And he put himself on the line. He put his life on the line, folks, and he lost it doing his job. He didn't lose it doing something bad or something unlawful, illegal, something in bad faith. He lost his job because he didn't go in there with his gun pulled. And he didn't go there and be more forceful on his commands. He was giving the defendant the benefit of the doubt. He was trying to be polite and courteous. And that's the sad reality of what happened here. Doing his job and trying to do it in such a way that would be respectful. And he got it. He got it. We know he was reasonably known to be a law enforcement officer. The defendant helped us with that. Now, it also goes on to say that if the officer uses excessive force, folks, I'm not going to beat you over the head with that one. I mean, you've got literally about 28 seconds and to watch to reach your conclusion about excessive force. Excessive, and then the self-defense claim. Let me talk about that for a minute. It says that a individual is justified in using deadly force. Now, deadly force, taking the gun, pointing it, shooting it, and putting that bullet in somebody's head, that's deadly force. Nobody's arguing with it. But they can only use deadly force if there is an imminent meaning immediate, right then and there, threat of death or great bodily. Is that what will happen? What do you think? It's a reasonable person standard, folks, on whether or not there's reasonable fear. Would a reasonably cautious person in the defendant's situation have done what he did? A reasonably cautious and prudent person, would they? Mr. Probisco is challenging the posts and such because, as we argue, it's evidence of motive. We don't have to prove motive. But juries, folks like to know why somebody does what they do. You can choose to believe Mr. Wallace's version. You can choose to believe it, or you can reject it. Too many coincidences. Wants to get the blood of police officers, pigs, on his hands and boots. It's war. Blood running in the gutters of America 3 weeks before, and then Officer Raynor's dead, and then 15 minutes later, I submit to you, bragging about it. And again, no mention of self-defense. Not with Miss Bodison. Remember the lady that wrote, that was, I think, the girlfriend of Wallace's brother, Octavius, I think. No mention of self-defense. Because it wasn't. But, again, who's got an interest in the outcome here? Who has more of an interest in this outcome than Wallace? Nobody. Nobody. Mr. Lewis was asking him about, why didn't you just sit down? and he said he wanted to leave. He didn't want to sit down. And then he shoots Officer Raynor. He had a duty to avoid that. Call it a duty to retreat. He had a gun in his pocket. Now you can buy a story if you want that he had put it in his pocket because he was getting ready to leave and take it in the house. Doesn't matter. He had a gun in his pocket. He didn't have a permit. Didn't want to admit that, but he did. That's carrying a concealed firearm. Mr. Provisco kind of talked about it in passing. If you're engaged in criminal activity and try to use the stand your ground or self-defense, if you're engaged in criminal activity, which he was, contrary to Mr. Provisco's dissertation, he has to retreat if he can. What does that mean in this case, folks? It means he should have sat down. He could have sat down. And he admitted he could have. But he didn't. He could have got back in that car. And we wouldn't be here today. He didn't. Listen to the jury instruction. Another thing. I won't play it for you. You'll have a chance if you're so inclined. But at the end of the shooting, after he shoots Officer Raynor in the head, he says, "Fuck that man." I submit to you that's what he said. Didn't want to admit it. He said, I think his words were something like, get the fuck back, man. That is not, I submit to you, that is not what he said. But he doesn't want to admit that because that's further evidence of his intent. He wasn't in fear for his life. Folks, it's sad and it's disturbing, but he wanted to kill him. And he did. Fuck that man. Evidence of fear or disdain. It's your call. It's your decision to make. And there's no evidence, even the defendant never said that Officer Raynor drew his weapon. Quite frankly, once he was under attack, once he was getting that violence, that force directed on him, I submit to you would have been justified to pull his weapon. But he didn't. He tried to control the situation and he couldn't. And he lost his life for it. And, you know, Mr. Provisco was kind of making fun of what we did with our case. Like that we...
Sustain.
Okay. Let's just say he was less than complimentary.
Objection,
Overruled.
He was less than complimentary about some of the things we did. Should we not present the evidence that that the gun that killed Officer Raynor did not have Officer Raynor's DNA on it? Should we not do that? We don't know what's going to happen in the trial. We don't know what evidence is going to come out. Mr. Provisco acted like we did. We were preparing for trial, as we should. A police officer in our jurisdiction, in our community, in our state, was shot in the head and died. We're not gonna leave any stone unturned, and folks, we make no apologies for it. You deserve to get every bit of evidence, every piece of evidence And then you consider what it's worth. You make that decision. The phone records. Again, less than complimentary about, well, wait, like we're wasting your time, were we? We're being thorough, folks. Again, we don't know what's going to come out. We don't know who's going to testify and what they're going to say. We have to be ready for anything. And again, we don't apologize for that. It's our duty to give you everything that we have. And then it's your decision to decide if it's important. We don't presume to what you're going to think. We just give it to you and you decide. We know for sure that Officer Raynor's gun was never pulled out because of the audit trail. Now, you got the audit trail, and I want to try and just correct something here. Mr. Provisco said something about the alert going off. I think the implication was that Officer Raynor pulled his gun. You know how that Axon, the alert is if you pull your gun, and I think the testimony from the guy from Axon was if you pull it out far enough from that sensor, then it automatically triggers the body cam if it's not on. Not only that, it sends an alert to that audit log saying weapon pull. But what else did they tell you? What else did that man tell you? Childs or something like that, I believe. He said that if you have a lot of officers in close proximity and they pull the gun, then every body cam in that zone will get the audit alert of a gun being pulled. And I'm going to show you before we're done the video of the officers. You saw it before. It was heartbreaking. Where the officers are running, they even fall down as they're going to try and get to their colleague, their officer who's lying there bleeding on the ground. And their guns are pulled. Of course, Officer Raynor's log is going to reflect that. But it was several minutes after he was shot by Wallace. Folks hold dear the Fourth Amendment. You know, nobody wants their privacy violated. But let's put this into context in this case. There was talk in opening by, I think, Mr. Shoemaker about the right to be secure in your homes and it's safe. That's true. But that doesn't mean a law enforcement officer can't come up to you and ask you where you live, if you live.
Counsel, be careful, golden rule.
Okay, my apologies. That doesn't mean that an officer can't ask somebody, hey, how's it going? Do you live here? The Fourth Amendment is not a ticket. It's not a pass. It's not it's okay to shoot a police officer if they violate your Fourth Amendment rights. That's not the law. The court is where you address it. Otherwise, it'd be chaos. Mr. Provisco is talking about a civilized society. So if your privacy right is violated, you can park a bullet in a police officer's head? Is that what it means? What do you think? Could have answered the question. I mean, he lived there. That's what he said. I think Letitia was a little bit different. She didn't say he lived there, but upon cross with Mr. Provisco, she said he was welcome there. I mean, yes, I live in this apartment. How hard is that, folks? What's wrong with an officer asking that? And why wouldn't he answer? Oh, because he don't have to. You're right. He doesn't have to, but there's consequences for actions. Talking about your deliberation, want to make sure it's clear. You get back there and some of you say, I think it's felony murder. Some of you say, I think it's premeditated. Just want to be clear, as long as all 12 of you agree it's one or the other.
Judge, we object based on previous objection on this comment.
Sustain. Rephrase your comment.
You can choose premeditated or felony. What the instruction will tell you is that so long as all 12 of you agree to first degree murder, by whichever theory, that's valid. That's what the law says. That's what the instruction says. Sleep mode. Sleep mode. The state was I won't say accused, but it was implied that the state was trying to distract you by some of the things that we brought up, like the DNA evidence, like the shell case. But this sleep mode is, I submit to you, a distraction. It's an attempt, like some of the other arguments that the defense is making, for you not to focus on what you need to focus on.
Objection.
Overruled.
That encounter, that 48 seconds is all there was of what happened. That's it. Anything else about what was on, what could have been on there, that's speculation, folks. And what does the reasonable doubt standard say? It's not a speculative doubt. It's got no place in your deliberations. You can decide to consider it, but consider what? What is there to consider? He had it on sleep mode. Could have been for privacy reasons. They don't know. It's speculation. And it has no business, it has no relevance to the case. That video captures the entire encounter, the entire episode, everything. Even the defendant admits that. And the defendant fleeing, taken off. You'll get an instruction. It's consciousness of guilt. Fleeing from the scene, you can consider that to be evidence of guilt. Why not stay? Well, the defendant says he was afraid that he could get shot by law enforcement. But 15 minutes after he shoots and kills, or shoots Officer Raynor, he dies 55 days later. He's posting. He's bragging. Don't let the pigs fuck with. Excuse me, pussy ass. Does that sound like somebody who's afraid law enforcement's gonna shoot him? Sounds like he's inviting a confrontation. It was a public page. It's a public. Anybody could see it. Everybody could see it. Think about that. He wasn't restricting it to people that he knew or that were friends or whatever you call it on Instagram, followers. He posted it for the whole world to see. Consider that. And consider the tone. I mean, I don't have to tell you about the tone. You heard it. You heard it. He builds. I love y'all. I love y'all. Keep fucking fighting. Keep moving fucking forward, and then don't let them pussy ass pigs fuck. You can see, you can hear it. That is an indication of his mind. It's not, we're not reading his mind, we're hearing his mind. Make no mistake, this ain't a mind-reading episode here. This is us using common sense to the words he used and the things he did. Went to Gainesville, Georgia. And he could have shot all the police that were there. Yeah, he could have, I suppose, and got killed himself. Is that maybe something? I think, I submit to you. The reason he didn't fire, because he didn't want to die. He didn't want to die. When he had Officer Raynor alone in that secluded parking lot in the dark, knowing he had a gun and knowing that Officer Raynor was giving him the benefit of the doubt, he had an opportunity. I'm not saying he planned to kill Officer Raynor weeks in advance. He was predisposed. He wanted to kill a police officer, and the opportunity presented itself. Now, you can reject that if you want, but again, 3 weeks before, he's saying, I want to get pig's blood on my hands and boots. 3 weeks later, Officer Raynor's dead.
It's been an hour.
I'm about done, Judge. I'm about done. Can you play the Burlinson video?
Where is he? 5-7 Central Rescue Code. Right. Where is he? Central gunshot wound. Who shot him? Come on, buddy. Hey, it's gonna be all right. Yeah, officer down. He's shot. Where's it at? Hold it, buddy. Hold it. Hey, just talk to me, man. Talk to me, Jess. Where's the guy who shot him? Who shot him, buddy? Oh, man. Just hold on, buddy. Just hold on. Central Rescue Code 3. See if we get airborne.
God bless, man. Oh, my goodness.
Get something to hold pressure.
For 3 years.
Just hold.
I got it. He got my shirt. He got my shirt. He got his shirt. He got my shirt. He got my shirt.
Hey, 10-3.
Damn, man.
Gunshot wound to the head and one on the chest. Come on, man. Just keep talking to me, buddy. Just keep talking. Get rescued here now. You're gonna be all right, buddy.
You'll get these instructions at the end. You must follow the laws as set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law. In this case, all of us are depending upon you to do to reach a wise and legal decision in this matter. Let me remind you that it is important that you follow the law as spelled out in these instructions in deciding your verdict. There are no other laws. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Now, folks, I'm not gonna tell you what verdict you should render. What I'll tell you is what my challenge to you is that you do your duty. You consider the evidence and you deliberate. Follow the law. Follow the law. And reach the only verdict that is fair and just and is supported by the law. Thank you for your attention. And thank you for what a day I don't think any of us will ever forget. Thank you for being here today. And thank you for doing your duty as jurors. God bless you.
Thank you. Ladies and gentlemen, our business is not really because you have to follow the law. So this is mine. I was going to help you come here tomorrow a little early, but I think it's better if I just keep your normal schedule. So I'm going to expect you to be here tomorrow at 9 a.m. 9 a.m. Now, special different rules for tomorrow. This is what I want you to do. When you come tomorrow, I want you to bring an overnight bag with everything you need in case the deliberations should go past one day. So you pack up whatever that is, your clothing, your medication, whatever it is that you need to be with us in case we have to be here longer than one day. I'm not suggesting that we should, but I'm just saying I don't know how long you're going to take. That's entirely up to you. Once I give you the case, you control the calendar. You control how long we stay in this building. You control what happens as far as the verdict. So when you arrive at the courthouse tomorrow, I want you to leave that bag in your car. Do not bring it into the building. If necessary, we'll give you an opportunity to get that bag later in the day. But for now, that will be the plan. I want to remind you, you are not allowed to talk about the case yet. I haven't released you from that order. So please do not discuss the case with anybody. And that includes among yourselves until you have heard the law. You've heard the arguments of the lawyers, but you haven't heard me speak. Just to give you an idea, the jury instructions are lengthy. It'll probably take me about an hour or a little over an hour just to read them to you. And you will have a copy, each of you. And then after that point, the case will be given to you, and then you begin to deliberate tomorrow. That is the plan for tomorrow. Do you have any questions? And then I will see you here tomorrow, sharp. Should it have to go past tomorrow? I'm not suggesting that it should, but it does. Should it go beyond tomorrow, then it's Saturday would be the day that we would come back. Okay? You will be excused at this time. We'll see you tomorrow at 9 a.m.
All right, the jury.
Yeah. Sorry? Yeah.
Who's that? You may be seated.
Thank you. Folks, be here tomorrow 8:45. Sometime tonight I'll give you the final version of the instructions that I will read tomorrow in case you want to go through them, okay?
Yes, sir.
Thank you. We're in recess.